Hey, good morning, good afternoon, good evening, everybody. How are we doing? It is time. It's time for a new trial. I've been keeping this one a little bit close to the vest.
Defense made a motion for a mistrial. Prosecutor was up to some fuckery. Potentially damaging evidence, no basis for it. The judge specifically said, do not ask that question. Do not use that as evidence. She walked right down the path and asked the question. It may be over on Tuesday morning. Batman Bruce Wayne bitch snitch. Gerald Brooks, your constitution does not apply to me because I'm a sovereign citizen, a traveler on the land, I'm a Moorian empire or whatever, bitch snitch. Because they're so fucking absurd. If you want to be a sovereign citizen, just do yourself a favor first. Go to YouTube here and just get every sovereign citizen that's ever been before. Find me one that won. God dang, you're right. Don't go down this. It's not the path. Don't have time for stupidity. Some clever dick on the internet didn't find the great loophole in all of the world's law. Bitch snitch. God dang, you're right. God dang, you're right. Traveler on the land. God dang, you're right. Moorish empire. Traveler on the land. Bitch snitch. Moorish empire. God dang, you're right. Traveler on the land. Bitch snitch. The late evening U.S. people. Grounds. Hey, good morning, good afternoon, good evening, everybody. Wherever you are, whoever you're with, whatever you're doing, however good it feels, we're just glad that you're doing it here with me. And it is the day that Becky Hill's chickens may come home to roost. She is going to be facing questioning along with other jurors, with the other, well, not the other, she wasn't a juror, with jurors other than the juror that was questioned last Friday. Now, the audio of that we'll have available as soon as possible. But here we've got Alex coming into court. Let's see, no audio really yet, I guess. So we're gonna do. What are we gonna do? We'll do this. How about this? No, that's not what we want to do. That's the opposite of what we want to do. Do this. How about that? Until we get some audio in the court. Or that. Yeah, let's do that. So you can see this all handsome mug. How you all been? I hope you had a great weekend. We are off to the races. We are here. It is that time. It's that time. All these allegations that have been building up against Becky Hill for the last several months regarding her conduct in court are coming home to roost. That's what we're here to do today, is to look into all of those allegations. The court is going to question the jurors, going to question Becky Hill, and reportedly the defense Murdaugh's team has a witness that they're going to bring in as well, probably for foundational purposes, etc. Yoda is already excited. You can hear Yodaing off in the other room. So we're doing good. We're going to follow this as long as I possibly can. It's 11:35 p.m. here in Korea. Got a little bit of a rest. We'll get as much of this as we can. But I plan on being here the entire time. So, hey, welcome to everybody here. 280 of you here now and 115 likes. Make sure you hit that like and subscribe button because that's what keeps us in business. What do you got? Yeah. It's like 170 of you haven't done your job. So get down there, smash that like button. You're not doing anything right now. You're just waiting for this to start. So may as well put your time to good use by hitting the like, hitting the subscribe. If you haven't subscribed, please do. If you are subscribed, as always, double check to make sure you're still subscribed because that's the thing. YouTube unsubscribes you. And take our like and subscribe poll. Simple. It's a simple question today. Hit the like, hit the subscribe, and then vote in the poll. Will Betty Boo's shenanigans result in a new trial for Murdaugh? Yes, no, or hell no? So far, it's 60% of you say yes. That's a very optimistic number, folks. 32% of you say no, and 8% of you say hell no. Right now, I'm leaning, unless there's some major event that happens, I'm going to lean into the no category. I know that sucks, and that's not what I want to happen. I think he should get a new trial. If any of this is substantiated, I think he deserves a new trial. Will he actually get it? I hope I'm wrong, but my gut is saying no. It's just a gut feeling. We'll have to see how it plays out. I hope so, because again, I don't care personally if he committed these murders or not. It has nothing to do with my life. What I don't like is how he was convicted. I don't like that. I thought the judge was ridiculously unfair. I thought he had so many rulings that were incorrect. This whole however many effing weeks of financial bullshit we had during the trial, I thought was absolutely inappropriate. And I just don't think that the evidence proved beyond a reasonable doubt that he did it. And then if you add into the mix all of this Becky Hill stuff, I think dude needs a new trial. This is a big courtroom. Wow. Hey, there's Fitz from Fitz News. There's the like and subscribe people. They want to say like and subscribe people. The law and crime people, not the like and subscribe people. Still no audio. You got that's a nice courtroom. Now I see Murdaugh's growing his hair out. That's good. And why is that girl behind him not blinking? She hasn't blinked once. The blonde girl. She literally hasn't blinked. Okay, oh God. I thought she was one of those motherfuckers ain't real. I thought it was one of those people. Because she wasn't blinking. That was kind of spooky. All right. Sorry. That was my spectrum talking there. I just noticed she wasn't blinking and it was kind of creeping me out. So we see the Murdaugh's growing his hair back a little bit. That's good. See if there's any other recognizable faces there in the gallery. We saw Fitz from Fitz News, who we are going to have on here eventually at some point. We're talking again, and he wants to just get through this trial. Through this hearing, and then we'll have Mr. Fitz from Fitz News on to talk more about Betty Hill and stuff. Alan Walsh is asking how the feet are. For those of you that are wondering about how my feet are, as some of you may know, I've been suffering from like ridiculously acute extensor tendinitis in my feet. We're about 75-80% recovered. I'm feeling pretty darn good. It's still painful, but nowhere near where it was. So I'm really happy. Right, so we're good. We're all recovering. I'm all locked and loaded. I got my basic ass gin fizz cocktail here. But see, this is one of those problems that I got a few lemon seeds in here, and every time you drink through the straw, it like sucks up one of the lemon seeds and it blocks the straw. So yeah, all right. There, launched it. All right, Alex is sitting there. Not a lot for him to say, is there? Harp, it's Dick Poon. Dick Poon in the house. We had reports from paralegal Liz. If you saw my non-stream stream last Friday, when we thought we were going to be able to watch listen to the audio of the first jurors questioning on Friday, and shortly before we were scheduled to go on air, the judge said, nope, nobody's talking about this. Nobody's going over his testimony till today. We were left with nothing. So we brought in Liz who was in court to tell us what happened while we were in court. She gave us as much information as she could. Who was there, what their attitudes were, what they looked like, what was said to them. And she said that Dick Poon seemed a bit grumpy, which I'd be grumpy if I had to deal with the prosecution too. I'm going to give the little doggos a treat here. Hey, here you go. There you go, Yoda. Becky, here you go. Have a snack. There you go. Doggo's got a snack to keep them chomping on it for a while. So all the chomping noises you're hearing are coming from them. And Duncan, Idaho, has given us our first super chat of the day. Here's contribution number 1 for Doggo Cam. Well, that puts us, we're $95 away from unlocking the achievement there then. So thank you so much for that. That will go to their treat fund. They've just got some bully sticks, which are essentially bull's penises. That's what they're chomping on now. So thanks. Thank you so much for that, Duncan, Idaho. You get the bell for the first super chat of the day. And as we go through once things get underway and once things start, the super chats come in. I'll flash them up on the screen, let you all see them. And then when there's like a natural break between witnesses and whatnot, or when there's a lull in the conversation, I'll read through them then. So we're not talking over the court too much. But we'll also be looking at chewy boners. No. Yes, but no. We'll also be looking at I totally forgot what we are going to be looking at. That chat just threw me off. All right. Meanwhile, the old ladies are staring at me, judging me. All right. Oh, well, see, that's good. You got some smiling lawyers. Smiling lawyers is good. He's like, I can't wait till I get a hold of that Becky Hill. Because this is essentially what the hearing is, to see if what is alleged that she did to influence the jurors, saying things like, you're not allowed to take a smoke break until you come back with a verdict. If you don't come back with a verdict soon, we're going to throw you off in a hotel you're not prepared to go to. Telling that this shouldn't take very long, and don't believe Murdaugh when he testifies, watch his body language, things like that. All these things she's alleged to have said to jurors. That's the focus of this. So, as I said, we're going to hear from the jurors, and then we're going to hear from Becky Hill and one witness from the defense. The judge is hoping to get through everything today. She scheduled 3 days for this, but she's hoping to get through it today. Right there, we have no audio until hearing begins. Well, we're already 15 minutes late for the hearing, so come on. Oh, yes, Becky is going to be here. Becky will be on the stand later. The lady that was judging me, that was Stephen Smith's mom? Oh, wow, I did not know that. Thank you, Haley. I despise saying this, but how do we know she's not going to lie her ass off? Well, you don't. That's why they get cross-examined, to try to trip them up and to break down their credibility. But you don't know. We just assume that because they take an oath and they swear and they promise to tell the truth and the whole truth and nothing but the truth, that they will. But a lot of people do lie their ass off on the stand. But again, there's going to be one witness from the defense and 12 jurors that are also going to be questioned. So we'll see how closely all of their stories align. Yeah, she may not be. Cops. What you gonna do? What you gonna do when they come for you? All right. Hey, we got 450 people here. I'm so grateful for all 458 people. 61 of you now, 461 of you that are here now. Hang tight. We're waiting for the audio to start in the court. They're just effing around, waiting for things to get underway. And yes, as many of you have already mentioned, we do. That is the one thing that we can all agree about in chat. Even that Becky's a hoe name. That's one thing we can agree on. Oddly, even Becky's in chat. We'll kind of agree with that. That's where we are. Love the hat this morning. Well, thank you very much. This was one of the hats I picked up in Texas last August. They're, of course, from Miller Hats, where like all of my cowboy hats come from Miller Hats. All of my flat caps come from the Aran Sweater Market in the Aran Islands. The Aran Islands of Ireland. That wasn't that was difficult to say, wasn't it? Except for the one hat, I have one kind of greenish brown flat cap that was gifted to me by a lovely woman who came all the way from Austria to meet me at Anime Matsuri and give me that hat. So other than the hat that was brought all the way from Ireland to Houston, Texas, all the way from Austria to Houston, Texas to give to me, all the other flat caps are from Ireland, from the Aran Sweater Market. People need to start giving me sponsorships. Damn, as much as I talk about the shit that I have and nobody gives me a sponsorship. Come on. Aran Sweaters, I wear your sweaters. I talk about them. I wear your hats and talk about the Miller hats. I've been wearing your damn hats for like 20 years. I'm talking about them on stream all the damn time. Come on, peeps. Give me some sponsorships here. Show me some love. Ronan Farheit says, man, Austria, Ireland, I always confuse those two. Yeah, not like the easily confusable Austria and Australia, which a lot of Koreans think are the same place. I'm sure a lot of other people in other places think they're the same place too, but yeah. Don't know what the holdup in court is, but something's holding them up. Let's check our poll, see if it's changed. Nope, not much. Only we've dropped 3% in the yes. 57% say yes, there'll be a new trial. 35% say no, and 8% still say hell no. So the change has all been in the yes and the no category. I mean, well, while we've got some time here, what are your thoughts? Just put some thoughts here in chat about where this is going to go, and what they're going to be able to prove, what you think they're not going to be able to prove. Well, yes, and my baseball caps come from everywhere, but yeah, I have my I haven't worn my Sugar House Distillery baseball cap for a long time. We'll have to wear that. I'll try to wear that tomorrow. But we do have Flux's "Don't Tread on Me," the Killdozer hat. We got Flux's Killdozer hat that I'm holding. For her, I guess. I'm acting as steward of her hat, steward of Gondor. I'm steward of the hat for Flux's Killdozer hat. Until she asks for it back, I will take care of it and keep it safe. Is it secret? Is it safe? We'll keep it safe for her. The investigation into Becky Hill is ongoing, right? Lynn's, you're half correct. The investigation. Oh, I'm sorry. Never. You are. I didn't see the S. Yes, the investigations. You are 100% correct. Are still going. Flux, I know you say it's my hat, but it's actually your hat, because I could never take ownership of a hat that awesome. But yeah, the investigations are still ongoing. The one into the jury tampering, the criminal investigation into the potential jury tampering, and the allegations that she's involved in her son's wiretapping of the court people to allegedly learn what they're saying about the other investigations. So Becky Hill, as we speak, is currently under 2 separate criminal investigations by SLED. Hey, Bernice, what's up? Hey, what would happen if other tubers sponsor you, like Legal Vices, brought to you by the Law Pope? Well, as long as the Law Pope is paying me to say brought to you by Law Pope, hell yeah. And sure, why not? I'd take money. Legal Vices is a hoe name. Court will say that while Becky did misconduct, it wasn't enough to affect the outcome, and she will get a slap on the wrist. See, and that's likely. I think that my gut is telling me that's likely what will happen, but that's not the standard. It's just simply whether they made any impact that could have affected the outcome, not whether it did or not, but whether it could have. And so it's frustrating because I desperately want this to, and again, they have to prove that, at least to the judge's satisfaction, that these allegations actually happened. These things actually occurred. If they can prove any of them, I think he gets a new trial. I think he should get a new trial. Whether he does or not, it's the judge, and God knows how it'll work out in the end. But Swan Lake Lady says, Flux, you need to sign over your parental rights to the hat to Jeff. Sovereign Citizen Patrol. Thank you so much, Sovereign Citizens Patrol, Traveler on the Land, Grounds. Learned about you from a different stream. Thank you for streaming the stream. Ooh, what other stream did you learn of me from? I'm curious. Where did you see me? Where did you hear me? I'm always curious how people found me. But thank you for your super chat. Thank you so much. You've put us $5 closer to unleashing and unlocking the doggo can, which may or may not happen at some point in the future. Where is Maritime Monday? Maritime Monday happens when there's not other urgent pressing things going on. This takes precedence over maritime, because that was the origin. Normally, for those of you that don't know, on Mondays we talk about maritime law issues, old sinking vessels, cannibalism, disasters at sea, explosions in ports, deaths by the hundreds, if not the thousands. We talk about maritime related stuff on Monday, and that was born out of the fact that one day I literally had nothing to talk about. There was no news, nothing to talk about. So I said, hey, that's something I know about, maritime law. So let's talk about some ship collisions. And we watched some videos of ships bumping into each other, some collisions, some sinkings, and I was offering my comments, and it just somehow became a thing on Mondays. So when there are other important things, we do those other important things. Oh, it looks like we're getting ready to start, but so this is far more important than a Maritime Monday stream, but don't worry, likely to be back next week. All right, Judge is in. Is Law and Crime going to turn on the volume? Bump up the volume, pump up the volume. Hey, legal-minded friends, Karen Cole, how are you doing? Good to see you here. Hey, Law and Crime. Want to turn the volume on? You saw a Lifetime movie about this case? Hey, now let's see if they're saying, hey, turn on the volume. Volume is all the way up. Wait, what? Are we hearing the volume and I'm not? All right, let me. Really? Is this something that's happening? Okay, Court TV's got the audio. Why are we not getting audio on this? All right, let me back out and then come back in. Hang on.
Into account, but I have already examined one juror using that term, and you now say that term confused the juror. You have that on the record, and certainly would be able to argue that to any of the appellate courts that review what I do here. But my intention is to use the language that I used with the juror I've already interviewed.
But Your Honor, you went and did a follow-up question, our request, which elaborated on what that meant. And certainly after you asked that question, we think that clarified it, and you could use merits or anything else about the case and deal with both issues. I just think
no, that is a baritone woman.
Us, based on statements that these jurors have given to SWAD to ask very specific questions.
I understand what you're asking. Let me ask you this, Mr. Harpootlian. Do you happen to have the transcript of Friday's proceedings?
I don't think so.
State, do you all happen to have a transcript of Friday's proceedings?
Your Honor, we're looking right now.
So it sounds like they used some word that a juror found confusing.
Let me look at it for a minute to see what I did in clarification, and so just pause for a minute. Let me look at that.
So right there, we missed the first part, so we don't know what they're talking about. But apparently, as I said, they used some term that Dick Poon's team said was confusing to the juror they interviewed on Friday. So yes, to answer all of your questions, this is a female judge. She just happens to have a baritone voice. Should we pop back a little bit and see?
Devices, cell phones, iPads, or anything of that nature. Please silence them. Please do not have an arrangement. Sure. Hold for a minute. Yes, sir.
Your Honor, you have a list of questions you've distributed to us, and
yes, sir.
Of course you went through those with juror
Z or X.
X. I knew it was one of those last letters. Juror X. The third question, you say, did you hear Ms. Becky Hill make any comments about the merits of this case before your verdict?
Yes, sir.
And clearly the juror didn't understand what the word merits meant.
I disagree with that, but you may make your record about it.
Okay, so it was about, did the juror understand what the word merits meant? And the merits, see, that's actually, I kind of agree with Dick Poon. Like, if most lay people, if you said, tell us about the merits of the case or what are the merits of the case, they may not be able to answer that.
Per Chief Attorney Waters, please be advised that the attorney for Juror X has told us that his client says that prior to the defendant's testimony, his client did hear Clerk Hill say words to the effect of, quote, looks like the defendant is going to testify. This is an important day, close quote. Or, quote, this is an epic day, close quote. And that there was some statement that it was rare for a defendant to testify. And then I said, Juror X, can you verify that what I've read is something you heard and told your attorney? And she says, yes, ma'am. Very good. Did these statements have any impact on your verdict? No, ma'am. Very good. I will ask that question. I didn't change
Can the court be louder? It sounds like the court is really loud to me.
Do that again.
Your Honor,
isn't the court really loud?
Jurors say different things based on the memorandums we've received.
I won't say you told your attorney or anything like that, but I will ask about that statement having been made.
Your Honor, just for the record, we believe the term merits is a term of art.
The court looks like it's sufficiently loud to me.
Again, if or anything else, we're not asking you to open Pandora's box.
I hear what you say, and I will take it into account.
Okay, thank you, Your Honor.
Mr. Waters, anything on your behalf?
I do not have anything further, Your Honor. We believe the term is self-explanatory.
Thanks, sir.
I don't think the term merits is self-explanatory. In case any of you don't know, I mean, it's just like the validity, the substance of the case, the truthfulness, the value of the subject. It's even hard to explain. So it's like the value, the merits are the merits. That's kind of a dumb way to explain it, isn't it? I'm even having trouble explaining it.
I'll have to go to my screen to do this other, but the third question will read, did you hear Ms. Becky Hill make any comment about this case before the verdict?
Much better question.
That's what I like.
Much better question. Much better question. Take the word merits
out. All right, Mr. Bailiff, bring me the jury.
Yeah, take the word merits out, because I think merits is a term of art that the layperson may not understand what the merits of the case refers to. So, good win for Harpootlian there, I think. Adora the wholesome, perfect chord volume for me. Maybe a wee bit low.
Yes.
Yeah, well, I need to be a little bit louder than the court so that when I have to, I can talk over the court. So I'm always a little bit loud. I try to be a little bit louder than the court. Deputy Sheriff B. Kelly on the scene and properly labeled. Properly labeled. I'm twice the volume of the court? I think everybody's devices are different, because I was listening to it here on my Samsung S20 Ultra phone, and I sounded just a tad bit louder. So I don't know. I'll give it another crack when the jury comes in and make some adjustments if I have to. Let me fire up my phone here. There we go. They have badges for merit.
Mm-hmm. It's the same thing except without.
Yeah.
Basically.
Yeah, so I do like that they took the word merits out of there because that's just not a thing that lay people talk about.
Thank you very much. Good morning, ladies and gentlemen of the State versus Murdaugh jury. I wanted to make a few opening remarks to you before.
Okay, I'm just going to talk over here for just a quick second. Thank you very much. I'll stop that now.
You have done absolutely nothing
Over here for just a
wrong.
quick second.
None of you, not any of you. You didn't ask to serve, but you served and did your duty. This was an unusually difficult trial because of its length. 6 weeks is almost unheard of in South Carolina as the length of a case. It was difficult because of the intense publicity and public interest in the case. It was difficult because of the complexity of testimony and exhibits in the case. And you acquitted yourself honorably. So this question today is not about anything you did wrong. Please be assured of that. I respect you and I respect your service. Today, I'm going to ask you to do something that's difficult. This case is unique. Most of the time, if there's some issue about improper conduct or contact with a juror, it comes up immediately. The judge puts questions to the juror and perhaps to the person who may have made a improper comment, and then you go on to verdict. Or sometimes it's very shortly after the verdict is rendered. And again, the judge questions the affected jurors and the supposed interference and makes a ruling right then and there on either a new trial or a mistrial. Now here, we are almost a year after your beginning of service on this case. And that makes it mighty difficult for you to do something I'm going to ask you to do, and it's this. Today, I ask you to focus your attention. What is that? Mr. Bailiff, what is that noise? Is that the sound system doing that?
I believe it's the court sound system.
This is the funkiest sound system in the world, so you just have to keep up with it. I've had trouble in every case I've ever tried with the sound system. So, jurors, if something happens and the sound system goes haywire, we'll stop for a minute until it stops. Now, as I was saying, I want you to focus your attention as you answer the questions I'm going to ask you on your 6 weeks of experience as a juror in this case, and on the point in the trial where the judge charged you, and on your verdict as you rendered it on March the 2nd, 2023. That's what I want the focus to be. And again, I know I'm asking a lot to have you cast yourself back into that time, but that's what the questions I'm asking are about that time and not about this time. There has been so much drama about this matter since the verdict was rendered. And my heart goes out to everyone, the lawyers and you who are in this trial. That I can't help. But I've been asked by the Supreme Court to take a look at this issue. The appeal is on pause until I do, and I've got to do my duty as I see it. And you do yours as I know you see it. So I thank you very much in advance for, again, the terrible inconvenience of calling you all back together now. But it's very essential to completing the record about this case and placing it before the appellate authorities as it needs to be. So in advance, I thank you. What I'm going to do now is dismiss you to the jury room, and one by one, I will call you, and I will refer to you by a letter that I have just assigned you that isn't your jury number and certainly isn't your name. You know, these people in the media saw y'all all through the trial. They probably know who you are. But I'm trying to do my duty as I see it when I make your appearance here anonymous to the record. And only the clerk, the court reporter will have a sealed document by me indicating what the key means in terms of your juror number and your name. So I'm doing everything I can do about this matter. But it goes without saying that your business is your own business. You don't have to interview with a soul, not lawyers, not media, not anyone after this matter. That choice is purely yours. And I will respect that and protect that to the best I can if anything comes up afterwards. All right, you may go to the jury room.
All right, so the judge is going to head out to the judge. The juries are going to head out to the jurors are going to head out to the I'll get it right one of these times. The jurors are going to head out to the jury room. They're going to bring them in one at a time. I'm not muted. I know. You can't fool me. Yes, Flux, we're positive this is a woman. She's 80 years old. She's an old hat at this, so I don't think she's going to take crap.
Bring me Juror Z.
One other matter.
Uh-oh.
One of the individuals sitting in the jury box called this, the next jury, liar publicly, and asked that that be Mr. Bland and his partner, cohort, not sit behind her or near her while she's testifying.
Yeah.
Well,
Oh, shut up,
Your Honor,
Eric.
I object to him speaking.
One moment.
Shut up, Eric, and wait your fucking turn. God, I hate Eric Bland. He's a
keep your
dick.
seat for a moment, Mr. Harper.
Yes, Your Honor.
Mr. Bland, you do the same. Mr. Bender, is there a seat over next to you?
There is.
Mr. Bland, will you go over and sit next to Mr. Bender, please? Thank you.
Thank you, Your Honor.
Thank you. Eric has no business. Not you, Eric Foams.
For the record, I have some people in the jury box. Two of them are SLED agents. One of them is the media consultant, and one of them is attorney for several of the jurors, Mr.
Bland. Eric Bland he's the lawyer for the jurors.
My direction.
And Justice told you have Scott Mongillo and Blaine Richter also in the jury box.
Very good. Yes, sir. That's fine. All right.
Right. Eric
Bring
Bland's a
me
dick.
Juror Z.
He's a blowhard. Seems cut from the same cloth as Pooter to me. Well, Bland's a media pig. He's just a media hound. He's not representing the family out of any great sense of altruism. He's representing because he gets his name out there. He gets on TV, and it's self-promotion for him. He's a douche. But hey, that's just my opinion. I'm sure he's a great guy. Cough, cough. Eric Bland, yeah, he's the guy that during the sentencing, he gave us some statements on behalf of some of the family members or the victims. He's just slimy. I don't like him.
Juror
He's
Z,
just
you
he
may
didn't
take
do
your seat
anything. He's just an
after you are
unlikable
sworn.
lawyer.
Step over here
To
to the
me.
clerk, and she will administer the oath.
Do you swear or affirm that the testimony you're about to give in this case?
He keeps talking about how he's going to he represents the jurors for free and whatnot. Meanwhile, he's on every show he can get on. He's on every talk show. He's on Law and Crime as much as he can get on, Court TV, everywhere. He's there to promote. He's doing it grandstanding for his own deal.
Juror Z,
Whatever. All right, here we go.
I will ask you some questions, and there are no right or wrong answers. The truth is what I seek, and that is the truth of what you experienced in relation to these questions at the State versus Murdaugh trial. You rendered a verdict on March the 2nd, 2023. That verdict was read in open court by the foreperson of the jury. And then the court said this: Madam Forelady and members of the jury, if that is your verdict of each and every juror, let it be known by raising your hand. The transcript then indicates that the jurors complied. The jury was individually polled. and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate statement about your verdict at that time?
Phoebe Purvis, yes. Here's a
Yes,
question.
ma'am.
Okay.
Right?
Yes, Becky will be on the stand.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, ma'am.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
Yes, ma'am.
Ooh.
If
All right.
yes, what did Ms. Hill say?
To watch his actions.
To watch his actions. What else?
To watch him closely.
To watch him closely. Anything else you remember?
Anything else?
There is, but I can't remember.
Okay, that's fine. And
Wow. Okay.
was your verdict on March the 2nd, 2023, in any way with any influenced in any way with any communications by the clerk of court, Becky Hill, in this case? Want me to
Yes,
read it
ma'am.
again?
Yes. Please.
Oh,
right.
it was
your
influenced.
verdict?
Oh my God. Okay.
Influenced in any way by the communications of the clerk of court in this case?
Yes, ma'am.
And how was it influenced?
To me, it felt like she made it seem like he was already guilty.
All right. And I understand that, that's the tenor of the remarks she made. Did that affect your finding of guilty in this case?
Yes, ma'am.
All right.
And see, again, I don't even think this is a standard. It's just whether or not she made the comment, and it possibly could have. I don't think they have to show that it actually
Those
did
are my
influence.
questions are submitted to the juror. Are there any reactions, further questions, and so forth? If there are, and you would like to voice them, I can ask the juror to retire to the jury room. Just tell me whether I need to do that. All right, sir.
Your Honor, we asked the juror we need to put some things on the record.
All right. Take the juror to the jury room, please.
Wow.
Yeah, that's fine.
Yes, Silent PS, I agree with you.
Mr. Waters.
Yes, ma'am. Your Honor, in the affidavit that was given by this particular juror, paragraph 10 said, I had questions about Mr. Murdaugh's guilt, but I vote guilty because I felt pressured by the other jurors. We would request an inquiry as to that, which is how, when this motion was filed, she expressed the basis for her verdict, which obviously this answer is a little different now. So we would request a brief inquiry from the court as to that specific issue.
All right.
Thank you, Your Honor.
We'll switch out the poll.
Your
We'll
Honor,
give everybody
as
another
to-
chance later.
Two things. The first thing is, he is correct. She gave an affidavit.
Yes.
We would ask Your Honor to let her read her affidavit to refresh her memory of, she said other things. They're very detailed in here. We'd ask you to, and let me hand up to the court a copy of her affidavit and ask you to have her read it before.
Wow.
before she's asked any other.
What I have here from Mr. Waters, for the record, Mr. Waters?
Mr.
What
Waters,
I've been
pay
handed
attention.
For the record is something, affidavit of juror, now referred to as Z. It was taken.
No, she
August
didn't change her
14th,
testimony. She said something
2023.
that in her affidavit,
It
she said she was
was,
influenced by
sworn
the
before
jury, other
Holly
juror
Miller,
members. And here she's saying she was
paralegal for
also
Mr.
influenced
Hartman.
by Becky. So they want to discuss
And
that a
he
little bit
would
more.
like for me to give that to the juror and ask her to read it and then ask her about it. I'm inclined to do that, but I want to hear
I don't
from
know.
you first.
Your Honor, again, if they want to refresh the recollection, that's fine with the state. So we have no objection to that.
Very good. It will be done.
Your Honor, also, we would ask that you not ask the question that that Mr. Waters asked you to ask, because it violates Rule 606B, which provides upon an inquiry into the validity of a verdict or indictment, a juror may not testify to the effect of anything upon that or any other juror's mind or emotions.
What was the question he asked?
If you look at that affidavit,
It's paragraph 10, Your Honor.
Paragraph 10.
It's in the very affidavit.
she said she was influenced by other jurors.
Yeah, I'm
Okay.
gonna ask her about that. I'm gonna give her the affidavit and then I'm gonna question her about it.
And we would, for the record, indicate that we object to that under 606B.
Your Honor, from our perspective, she's put an
You're the
issue.
one that asked me to have her look at this affidavit, but you telling me I can't question about it? I deny that objection.
Your Honor, if it's something that's inadmissible, you should not ask her about it. and that's
Well, you want me
inadmissible.
to admit it and have her examined
No, I
on it.
want you to have her read it to refresh her memory.
We're quibbling, Mr. Harper, we're quibbling about things that I'm not going to take time to quibble about. My ruling is,
I like this
pursuant to
judge.
your request, I am going to allow the juror to examine her affidavit, and then I'm going to question her about it. That's my ruling. Your objection is overruled.
For the record, I just want to note, Your Honor, just for the record,
You noted 606. I hear you noted.
in no way waiving anything or opening any door by asking you to let her
That's
examine.
for a higher court than me to decide.
Well, I understand that, and that's why I want to make sure when they read this transcript, there's no confusion. I'm not asking you to put that into evidence. I'm asking you to
Well,
let
I
the
don't
jury.
see how in the world I can question the juror about something and not put it into evidence.
Well, don't question the juror
You can't
about
have your
it.
cake and eat it too, Mr. Harpootlian. You could have been very satisfied with the answers that were already given, but you have chosen to ask about
Call the
this.
request.
Denied.
Oh,
Your Honor, all the time we ask witnesses to examine a prior statement.
don't talk yourself out of a retrial, buddy.
Please take your seat.
Don't talk yourself out of a retrial.
Bring me Juror Z. Get me another copy.
It's in here.
Yeah.
It's in here.
Yeah.
Wow. This judge is stupid. No, this judge is far from stupid. This is a good judge. This judge is how judges should be. She's making decisions. She's not going, let's just see how it works out later. Let's just see what happens later. Let's just we'll see if this becomes an issue later. She's making the judgments now. She's judging. She's doing what a judge should do. Hey, MG Law, what's up, brother? Are you busy? Are you home? He needs to learn when to talking a little bit much. All right, while they're doing this, let's get through these here. Duncan Knight over $5 says, pretty sure that's John Ratzenberger behind Murdaugh. Good to see he's still finding work. Cliff's put on a little weight, has he? And Duncan Idaho again with a $10 super chat. Ding, 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 ding. Wee, wee, new trial alert. Seriously, though, was not expecting these answers. But if there's going to be a new trial, only better answer than that would be, why are we buffering? Don't do that to me. Don't be buffering to me. Why are you doing that? No. That better be a law and crime problem and not a me problem. All right, well, let's see if it buffers, how long it buffers, and then we'll catch up. And also Duncan Idaho with $5. This judge is awake and alert and so different from the previous judge who just snored through it and allowed everything. Exactly, that's what I'm saying. All right, now I'm concerned. All right, it seems somehow to be a me problem. Let's just quickly hit the refresh. Wow, we haven't had a buffering problem in over a year, but I guess we did. What the? That's too big. All right, well, let's get there to the end. All right, there we go. Hey, Sonny or Chris has just gifted 5 Legal Vices memberships. If you are one of those lucky peeps that got one of the 5 gifted memberships, please give Sonny or Chris a super special thanks. And Tanny, what's up, Tanny? It has been a minute or two. What's up, everybody? Hey, Legal Vices. Yes, it has. I was just saying it's been a minute. It has been a minute. Good to see you here. Thank you so much for the support. How are we doing, by the way? We're about, looks like we're about $60 away from Doggo Camp. Cool. All right. We're about 60 away from unlocking that achievement. All right. Wow. So far we've got one juror saying she was influenced by the by Becky Hill's statements. And she's also said she was pressured by other jurors in her affidavit.
Very good.
All right, the juror's back.
First paragraph, of course, is a statement that you were a juror in the case. Second paragraph says, toward the end of the trial after the President's Day break, but before Mr. Murdaugh testified, the clerk of court, Rebecca Hill, told the jury, quote, not to be fooled, unquote, by the evidence presented by Mr. Murdaugh's attorneys, which I understood to mean that Mr. Murdaugh would lie when he testifies. Is that what your recollection is of that statement?
Yes, ma'am.
Oof.
Is there anything in the statement that on reflection you think is not correct?
No, ma'am.
All right. Number 3, she also instructed the jury to, quote, watch him closely, quote, immediately before he testified, including, quote, look at his actions, quote, and, quote, look at his movements, quote, which I understood to mean he was guilty. Is that an accurate recitation of your view of the matter?
Yes, ma'am.
Number 4, paragraph 4. Immediately after he testified, the foreperson said Mr. Murdaugh was crying on cue. Is that an accurate statement of what you saw and heard?
Yes, ma'am.
5, the foreperson criticized the former foreperson for handing Mr. Murdaugh a box of tissues when he was crying on the stand while testifying about his murdered son. She told the jury, we cannot interact with Mr. Murdaugh because that's what the defense wants us to do. Do you still stand by that recitation of that conversation?
Yes, ma'am.
All right. Number 6, the jury frequently discussed the case during breaks before deliberation. Is that correct?
Yes, ma'am.
All right. Number 7, toward the end of the trial, Ms. Hill came into the jury room a lot. Is that your recollection?
Yes, ma'am.
Ms. Hill and the foreperson had private conversations on multiple occasions. The foreperson.
So far, the questioning is helping Harp.
Ms. Hill would arrive, and then she and the foreperson would go to another room for a private conversation. The conversations typically lasted 5 to 10 minutes. The foreperson never said anything about the content of the conversation. For example, she never communicated logistical information after these conversations. This happened 2 or more times, more frequently towards the end of the trial. Is that still your recollection of the interaction?
Yes, ma'am.
9, when we began deliberations, Ms. Hill told us this shouldn't take us long, quote. And if we deliberated past 11 p.m., we would be taken directly to a hotel. We had driven from our homes that morning and were not prepared to stay overnight. Additionally, smokers on the jury asked to be allowed to take smoke breaks, but they were told they could not smoke until after the deliberations were complete. Did you hear that?
Yes, ma'am.
Telling
Including
drug
business
addicts they can't
smokers?
have their drugs till
Yes,
they come
ma'am.
back
Right.
with a jury verdict.
Number 10, I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors. Is that an accurate statement about your verdict?
Yes, ma'am.
After the verdict and immediately before sentencing, Ms. Hill pressured the jury to speak as a group to reporters from a television show. Is that an accurate statement of what she said?
Yes, ma'am.
And did some jurors decline to do that?
Yes, ma'am.
Retrial. Let's see if we can sneak in some things here. Marv White also gifted 5 Legal Vices memberships. Make sure you give Marv a super special thanks if you got one of those 5 memberships. And Ike, who's been a member for 7 months, says, liking Grandma Judge in her dulcet tones, when will she be breaking into singing Only Fools Rush In? She's not Elvis. Come on. She's not Elvis. And Sonny or Chris with a $50 super chat. The big spender. Thank you so much. Instead of taking the helicopter to work, I had to ride a boat. So take some of the OT hours and cry havoc. We are so close to crying havoc right now. You can't possibly imagine. But thank you so much for your support. Deeply, deeply appreciated. And Knox Fuse says, can I change my no vote to yet? We'll update after 2 or 3 more witnesses. We'll update the poll. We'll change it out again. After Juror Z's testimony, I have no opinion on his guilt or innocence, but the jury was tampered with.
Your verdict on March the 2nd, 2023 influenced in any way by communications from Becky Hill, the clerk of court? You answered that question, yes. In light of what you said in the affidavit, which is I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors. Is that answer that I just read a more accurate statement of how you felt?
Yes.
Overruled.
Yes, ma'am.
All right. So you do stand by the affidavit?
Yes, ma'am.
Very good. Thank you. All right. You may go to the jury room. And let me just explain to you what the procedure will be. I'm calling the rest of the jurors, of course, one by one. When I'm finished with that, I will bring you out as a group one more time, and then you're free to leave. You don't have to stay. Okay? Very good. You may go to the jury room. What's that?
Before this juror is excused, but after she steps out, I'd like to address
All
the
right.
board.
You may be excused.
Wow. All right. That was a little bit interesting there at the end. We'll talk about it here in just a second because Duncan Idaho has also made another $10 super chat as the trials being showcased have moved from state to state in the last few years. South Carolina's justice system has been proved pretty embarrassing. SLED especially, janky ass good old boys.
I do have a redacted copy I can hand up to the court if you want to make that use of the court's exhibit for this witness.
That's good. What I'm going to try to do is redact as I did in the as you did in the document that you sent me. The identifying thing redacted now.
He has an extra copy of the redacted.
Oh, good. That's great. That would be wonderful. Show it to Mr. Harpootlian.
I see.
Very good. Thank you. That's the one I will give to the court reporter, but I think you can see that I asked off of it.
And while she's pausing here, because of your generosity, we have reached that point where it's time to
Your Honor, just to be
clear, that does still have the juror numbers in it. It does not have the letters.
All right. What I'd ask you to do, Elizabeth, is take off the juror numbers, just strike them through, and then.
Okay, now while she's talking about this, Linz has raised the question. Does that mean that she's saying she wasn't influenced by Becky Hill, that the affidavit stands on top of that answer? She did say that the affidavit more accurately
Your
reflects.
Honor, we objected to the questioning because this juror gave two statements under oath, one in an affidavit and one here to you today. The one here today was Becky Hill influenced her verdict.
They're not
The one he
mutually
gave in an
exclusive.
affidavit 6 months ago was based on jurors. It could be both.
Yes,
Your Honor,
exactly.
it picked out the one in the affidavit from 6 months ago and said, is that a more accurate statement? That presupposes and suggests to her what she should say.
I absolutely
And
agree
we
with
believe
Dick
that
here.
This juror's testimony, and Your Honor, I'm afraid what you're going to say is, well, she said the affidavit was more accurate than what she testified under oath here today, and therefore I'm not going to consider her testimony. And I think that's where we're heading here. I'd ask you to bring her back in, explain to her there's nothing wrong with it both being true.
I decline to do that and overrule the objection.
I agree with Dick here. I think that's a bad ruling. They can both be true. They can both
Mr.
be,
Bailey?
absolutely
Yes,
can
sir.
both be true. Okay, I don't like that ruling. I don't like that decision. I think Dick Harputlian was absolutely correct. They can both be correct statements. I don't like that. I'm very unhappy with that. That's what as soon as she said, so would you say this is the more accurate statement? That's when the flag went up. They can both absolutely be true. At that time, she was saying she was pressured by the other jurors, but it can also be true that she was being pressured by also Becky Hill, and Becky Hill could have pressured the other jurors that pressured her as well. So, all right, that finding ways to not give a new trial. See, that's why I was saying at the beginning, I think absolutely he should be given a new trial if any of this is proven. And this is one witness saying it happened, that what they said happened. So, but as I said, although I personally think he should get a new trial, I had to vote no because I don't think that
Counsel,
he'll get it.
I have to report this to you, and I'm very, very unhappy about it, but there's nothing to do but put it on the record, and then I will proceed with questioning the rest of the jurors.
Oh, what did you do?
The jurors' cell phones were not confiscated or taken from them, and they tune this thing in on court TV and listen to all of what just went on.
Oh my God, you fucking jurors.
So you may make whatever statement you like to make, and then I'm going to go on and question the jurors. I will tell you in advance, I am not going to stop the proceedings or do anything to interrupt them. I'm going to get the rest of this on the record. You might imagine that they no longer have their cell phones with them.
Your Honor, we have a 5-minute recess to discuss what we need to put on the record.
Oh my God, what is that
I'm not gonna
shit?
take all day on this thing. I report things as they come to me. I will give you a couple of minutes, and then we're going to, they were late getting here. I didn't get to start on time like I wanted to. So I need to just calm down a little bit. But I tell you, don't take any long period of time. Court will be in recess for 5 minutes.
Well, that's okay. They're late getting there. You not starting on time is not the defense's problem. It's not the defense's problem. How can this happen? How can the jurors be tuning in to court TV and law and crime and shit while this jury questioning is going on? How can this happen? DUI guy, hey, what's up, brother? He's going to get a new trustee. I'm saying absolutely should, but my gut is telling me she's reaching for ways not to. But how the fuck do you get the jurors keeping their cell phones in the jury room and tuning into court TV and Law and Crime and watching the questioning while they're in the jury? How does this happen? That is astounding. That's astounding. I'm actually floored at that, and I don't know how you get around a prejudice issue there, because the whole idea is the jurors are not supposed to hear the questions before they get asked them. So now every juror knows exactly what's going to be asked of them when they come out in the room. They've got however many minutes, hours until they testify to prepare their answers, to come up with whatever answer they think is the answer that they want to give. But I mean, how do you rectify this? How do you rectify this? I don't know how you can make this right. I think just based on that, you have to give him a new trial. That's juror misconduct. I know they're not sworn jurors right now, but holy crap. I don't know how you rectify that. Wow. All right. Damn. Okay, why? Oh no. Well, they're in the jury room all together waiting. They're waiting all together. Apparently, they were not instructed not to do that. It sounds like a serious ball was dropped. Oh my God. How do you forget to take the self? I mean, that's I don't know how you get around this. I don't know how you fix this problem. Okay, for the first time in a long time, good old Jeff here has been struck absolutely speechless. Let's read some super chats, because I got nothing. I'm gonna have to process this here a little bit. Island, thank you so much for the support here. At what point do they just put Becky Boo in cuffs? Well, she is currently under 2 separate criminal investigations, 1 for this and 2 for wiretapping, to find out what they're saying about this. So yeah, she very well could end up in cuffs and spend some time in the Gray Bar Hotel. Imagine that Sled effed up again. Well, we just have the court effed up. Forget Sled messing up again. The court just effed up again. That's not what I wanted to have happen. There we go. How did I do that? Okay. Forget Sled messing up with Becky Hill. The court just made a serious blunder. Oh my God. That is all right. How does a judge not tell the jury no cell phones and to take their cell phones before they go back into the back room? We've got, and she's pissed at herself, so now she's gonna unleash at the probably at the defense lawyers somehow, because she's kind of been leaning that way today. Good grief. The state is a dumpster fire. Thank you so much, Yogi Bear. And Nux Foos, thank you so much for that comment as well. Trent Thoreau, with jurors this stupid, a verdict should be vacated because used people that dumb shouldn't be deciding anything. Again, I'm more freaked out about the judge right now, allowing the jurors to have their cell phones in the jury room while they're waiting to come out, and finding out that they're all just tuning into court TV and Law and Crime and watching this go down. Jake $80, she's ancient and doesn't know what a cell phone is. It's possible. Oh my God. And Knox foos again. Imagine that. Sled screws up again. This was the judge screwing up. She improperly sequestered them. She apparently didn't give them the admonishment not to use their cell phone and didn't actually physically take their cell phones from them, as normally happens when, oh my Lord. And Joe Pottinger, thank you so much for the £5. Is Becky Hill today's clerk of court and encourage the jurors to tune in? No, but that wouldn't be the weirdest thing. If that, okay, God, they're coming back in. Knox foos again. I thought Sled was charged with transporting and monitoring them during the proceeding, but yeah, the judge has to tell them, turn over your cell phones. You're not allowed to look at your cell phone, etc., etc. And that dog in him who's been a member for 5 months. Thank you for your 5 months of support.
You about to do something that I've already said I'm not going to allow to happen. And that is, you've got standing next to you a member of the team that represents the juror. And I can tell you, Mr. Harpootlian, I made a ruling early on that when Mr. McCullough was in court, when Mr. Bland was in court, that I was not going to
that's too big.
allow the attorneys to participate in formulating the procedure for this hearing. But I have not, I indicated that I would not allow the lawyers for jurors to participate in this hearing. And so I'm not going to do that. I can just tell you that. And if what you want to do is by indirection tell me what the lawyers for the juror would say, I'm not going to accept that.
Your Honor, my understanding is she'd like to approach to ask if the juror can be excused.
No, not yet.
Your Honor, I actually approached.
Now, Mr. McCullough can be excused. There's still plenty of you lawyers and you can do it. I didn't want him to come to begin with, so I love him dearly and he can go anytime.
The lawyers can leave anytime.
Amy McCullough, his wife, when I tell you that.
Your Honor, I actually was here to let both of them know that I was going to ask to approach to talk about a security issue very quickly.
Well, come up here. Lord knows, I tell you what, Murphy's Law. What can go wrong will go wrong at the worst possible time.
No, that ain't Murphy's Law. That's your screwing up, Judge. Do not blame Murphy for your failure to instruct the jury and to remove their cell phones. That ain't on Murphy. That's on you, Judge. And Choppy says, Jeff, we need an invoice of lawyers to discuss. And Legally Live, new member. Thank you so much, Legally Live, for being the newest member of the Clean and Sober crew. And Marv White dropping the $5. Judge was too worried about taking charge. She forgot to take charge. Got to agree with you. This is nuts. Wow. All right. Whew. I mean, she can't take the blame. That will destroy her rep and remove her from the bench. No. She drank too much Murphy's last night. Oh, no. Dang. Well, that was not on my Murdaugh trial bingo card, that the judge would make an error like that. Legally Live, thank you so much for the $20 super chat. What the F is happening in courtroom? I don't know. I go to court for 10 minutes and come back to this. I don't know. And that my YouTube studio is telling me to celebrate Legally Live's third super chat on a live stream. Thank you for your third super chat on a live stream, Legally Live. But I don't know what's happening. Everything was going so well until the judge made a crap ruling. And then we find out that not only did she just make what I consider to be a crap ruling, she also forgot to tell the jurors they couldn't have their cell phones in the jury room, and they were all watching the questioning of the first juror on Law and Crime and Court TV on their frickin' phones in the jury room. I know. I vanished behind the banner. Oh my Lord, people. Can this trial get any frickin' weirder? Back to what DUI guy was saying that she can't take the blame, that would destroy her rep and remove her from the bench. I don't know. I mean, God. I've been trying to process this subconsciously while going through it, and I'd be curious what the other lawyers here in chat would think. But I think the only way out of this, as much as I hate to say it, would be what DUI guy's saying: to admit her error, recuse herself, and then they would have to go back and formulate new jury questions with a new judge and do this all over again, which would be horrifically unfair to the jurors. I can't think of any other way to rectify this. I mean, how do we rectify this? I got no idea. That's literally my only idea. Judge says, all right, I effed up, recuses herself, and we do this all over again. Oh, my Lord. She got so caught up in trying to prevent a new trial from happening, it might have backfired completely. That could be a possibility. And C. John, who's been a member for 9 months, says the judge admonishes the people in the courtroom about phones and noise, but not the jury. And what if they're watching you while in the jury room? Yeah, well, she did not apparently tell the jurors that they can't do that. Yeah, I see no other remedy here. Injustice of lawyers, mount up. Invoice of lawyers, mount up.
Please be seated.
And Knox Foos, I re-listened and stand corrected. I thought she said apparently their phones were not confiscated, as if she gave the ruling, but it didn't happen.
Let me place upon the record 2 things.
Well, we're going to find out
First of all,
exactly what happened right here.
I have made certain now that a bailiff will be in the jury room with these jurors. Why that, I announced that many times, that is the way it was to run. Why there wasn't a juror in the jury room is something I don't know. But I have asked that be followed rigidly. I've also asked, I don't go into jury rooms, never have and never will, but I asked the bailiff to tell the jurors that they are not to discuss any testimony that any of them are giving. I asked Juror Z whether she was comfortable, because I would be glad to place her in a separate room so that she's not set upon by the rest of the jurors.
Set upon?
Gave me a big smile and said she was perfectly comfortable. And I said, at any time you're not comfortable, you simply tell me, and I will have you placed in either my office or another jury room. So that's where I left it with Juror Z. I think she's fine, but I just wanted to make sure of that. And again, on the record, the conversation I had with her was outside the jury room. I don't go into the jury room for any reason. Very good. Mr. Bailey? Yes, sir.
For the record, Your Honor, we would ask, as jurors are brought in, we would ask that you ask them if they watched or heard anything this morning from their cell phone or other jurors about what occurred in here this morning with Juror Z. And if so, what was it?
I'm going to say, ask each one of them something about this. Whether it's exactly what you want, I don't know. But I will ask them something about this or make some direction to them about it. I'm not going to get into who shot John about what they said in that jury room today. I'm not going to do that.
Why not?
I will try to,
Why not?
as best I can,
Get into that.
deal with this question of who of them hearing parts of the examination of Juror Z.
Your Honor, this morning, I think you already instructed them not to discuss this matter, these matters themselves. So if they have violated that, again, I think it's important for you to make that inquiry.
I'm going to make it as I see fit.
Thank you, Your Honor.
Yes, sir. All right. Bring me Juror C. C.
All right, let's bring in the next juror and see what these instructions are, see what their questions are. Man, I don't like that at all. I think Dick Harpootlian is on point today. I haven't disagreed with a single thing he's said yet. And while we're waiting, I just want to say, hey, thank you to all 911 people that are watching this. Thank you for being here. You could be anywhere else on planet Earth doing anything right now. You could be watching any other stream of this, and I appreciate that you're here watching this with me. Thank you so much. Get down there and hit that like, please. You've been here for a bit. You're liking this, so please go ahead and hit that like and subscribe button.
Do you swear or affirm that the testimony you're about to give today?
There's like 500 of you who haven't done your job. So get down there and hit that like button. Thanks. Do it. Do it. Let's get up to 600 or 700 likes like that. Come on. It's less than a second. You can do it before she asks her first question. Thanks.
I will address you as Juror C because I've designated from your juror number at Colleton to letters of the alphabet. I'm trying to protect the anonymity of the jurors as best I can. I can't promise you with all the time that they spent seeing you all in the trial of the case that they won't figure out who is who. But on my record here, which is all I can control, I will address you as Juror C.
Yes, ma'am.
And before I begin, I understand that there may have been some cell phones activated in the jury room and the watching of the questioning of Juror Z. Did that take place?
I know people were on cell phones, but I'm not sure of what they were watching.
Were you on a telephone?
No, ma'am, I was not.
Very good. I don't think I have to go any further then. Thank you, sir.
Oh, no. Did he hear somebody? Did he hear what they were? I know
he rendered a verdict on March 2nd, 2022. The verdict was read in open court, signed by the foreperson of the jury. And the court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your hand. The transcript then indicated that the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, ma'am.
Was your verdict based entirely on the testimony, evidence, and law presented to you in the case?
Yes, ma'am.
Did you hear Becky Hill, Clerk of Court, Colleton County, make any comment about this case before your verdict?
No, ma'am. I wasn't privy to any of that.
All right, sir. Was your verdict on March the 2nd, 2023, influenced in any way with any communications by the Clerk of Court, Becky Hill, in this case?
No, ma'am, it was not.
Very good. That completes my questions. You may retire to the jury room.
All right, we got 1 and 1. Need to get a score tab running here so we can keep track. Gotta open up a Word document here so we can keep track of who's voted for what. So we've got yes, influenced. Not influenced. We got 1 and 1. They're going to question 11 jurors today. They questioned 1 on Friday. We're going to get the audio of that and watch that as soon as I can get the audio from Liz, who was my guest last Friday. She's going to send that to me. The audio is apparently crap, but we'll work on it. And this is the second juror they've interviewed
Bring me
today.
Juror F.
So 9 more to go. All 12 jurors are going to be interviewed. 9 more to go. Plus Becky Hill is going to be on the stand. Plus a witness from the defense will be on the stand today. Yes, Friday lady can tell us what juror number 1 said, right? And if they take a lunch break, then I'm going to try to get in touch with her and have her appear via telephone to tell us what happened. And then we can listen to the audio later. But yes, as of 9:30 this morning, 9:30 Eastern time this morning, everybody can talk about juror number 1 and what they talked about. Juror Z, I guess what they were calling them, not juror number 1. That was a different case. Hey, we got 100 more likes. Thank you, guys. We're up to 928 viewers and 558 likes. So keep those likes coming in. I appreciate them. It helps greatly. It greatly helps YouTube know that you're liking what's going on here, and it gets it out in the algorithm. Thank you.
I have designated the jurors by a letter, and that's how I will be addressing you this morning, and I will be addressing you as Juror F. Now, I realize that you folks were on the jury for a long time, over 6 weeks, and people may know who you are, despite my...
The last juror said he didn't hear her talk about anything, so they didn't have to ask about that, because he said he didn't hear him talk about anything.
This record and your anonymity as a juror in this record. So just wanted you to understand why I'm addressing you as Juror F.
The effing juror.
This morning, it was brought to my attention that some jurors were perhaps on their phones listening or looking at a broadcast of the questions to the first juror I examined, Juror Z. Is that something that you know anything about or experienced?
Yes, ma'am.
Did you activate your own phone?
Another juror did.
All right.
And did you hear it?
And will what you saw and what you looked at in any way affect your testimony as you're about to give it?
No, ma'am.
How do we know that? I don't know.
You rendered a verdict on March the 2nd, 2023. The verdict was read in open court and signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript that indicates that the juror complied. The jury was individually polled and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? Each juror answered yes. Was your answer an accurate answer about your verdict at that time?
Yes, ma'am.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Absolutely.
Wow,
Did you hear
absolutely.
Becky Hill make any comment about this case before your verdict?
No, ma'am.
Okay. She's being definitive here.
Was your verdict on March the 2nd, 2023 influenced in any way by any communications by the clerk of court, Becky Hill, in this case?
Absolutely not.
Absolutely not. Wow, again, those are some very definitive statements.
I'd like to discuss the matter with you before we finish with this.
You may go to your jury room and keep yourself ready. I don't know if I'm going to have any further questions, but as far as I'm concerned, the questions that I'm asking are at an end, but I need to consult with the attorneys before I can dismiss you. You may go to your jury room.
So as it stands now, we've got one who says influenced and two who say not influenced by the decision. See, I think she needs to have something written down.
Your Honor, in interviewing the clerk of court for Barnwell County, who worked as an assistant to Ms. Hill during this trial, and interviewing the alternate juror who was not, wasn't needed, wasn't dismissed for any particular reason other than it wasn't needed. Both of them indicate they believe that Ms. Hill transported this juror by her personal vehicle or a bailiff's vehicle at least once during the trial. So I would ask you ask her during the trial, did Becky Hill either drive or ride with you in a vehicle before or after court? If so, what, if anything, did Becky Hill and you discuss?
What's your position on that, Mr. Waters?
Your Honor, I have no objection to that.
See, I think the judge needs to have a written statement regarding what happened with the cell phone, and not just making up shit for each different juror. You can't ask different jurors different questions about what happened previously during the cell phone incident a few minutes ago.
The same juror. Yes.
And Berserker, thank you so much for the $5 super chat. With what's been said already and all the bullshit that's happened in the last 20 minutes, shouldn't that already be enough for an immediate new trial? I think so. I absolutely think so. But we'll have to wait and see what the judge thinks. Marv, why with the $2 super chat? Streaming law and crime or streaming legal vices law?
Thank you, ma'am. Of course, you're still under oath.
If you're streaming legal vices in the jury room, stop it.
During the trial, did Becky Hill either drive or ride with you in a vehicle before or after court? If so, what, if anything, did Becky Hill and you discuss? Do you recall that at all?
Could you please ask that again?
Ma'am?
Could you please ask the question again?
Sure.
Sorry.
During the trial, did Becky Hill either drive or ride with you in a vehicle before or after court?
No, ma'am.
All right, then I don't need to ask the second question. This will conclude your testimony. You are dismissed. I'm going to ask the jurors to stay with me until I've completed this process, and then you are free to go. Thank you so much.
Buster Hyman, stop streaming it no matter who you're watching. Yeah, but if they're not watching me, they don't hear me say it. But if they are watching me, stop streaming it. Chaos Coordinator, who's been a member for 15 months. Thank you so much for the lengthy, and probably girthy support you've given.
Juror F is court's exhibit number 4.
Jeff, this time it wasn't me who messed up in the courtroom, but let the circus roll on. And Kate Serve, you don't need to read this aloud. We'll do it anyway. Painful feet and hats too small go together. Talk to your doctor looking to acromegaly benign. No, it's not that.
L, as in Lima, yes.
The tendinitis in the feet has been diagnosed. It's linked to a specific exercise I was doing a week and a half ago, and it was a straw hat. And straw hats shrink when they get sweaty, and then they dry out and they shrink. This is my beaver pelt hat, and it's actually a little. Oh, you can't see me doing that. This is my beaver pelt hat, and it's actually a little bit big because I cut my hair. But yeah, I appreciate the concern, but yeah, I read your DMs, but not a concern. Thank you so much for your concern, but it's not a concern if that makes sense. Appreciate it. And Duncan, this is such a hilariously horrible mess. This whole trial. It is. All right. Again, 1 influenced, 2 not influenced. Let's see how this goes.
Thank you so much. All right. I have redesignated each of the jurors in the record for this case. And so I will be referring to you as Juror L, as in Lima. And, you know, y'all are all on this jury. If these people saw you for 6 weeks, they may know or be able to identify you, but I'm trying to, as best I can, protect your anonymity. You don't have to talk to
Don't ad lib, read the page.
At all. That's purely your prerogative. Oh, yeah. Juror L, before you came to testify and were sworn, you were in the jury room with the other jurors. I understand that some may have looked at their cell phones and looked at pictures of the proceedings as they involved the first juror who was examined. Did you see any of that?
People have their phones out. Yes, ma'am.
Did you look at any of it?
No, ma'am.
All right. And I don't need to ask you anything further about that. You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury, and the court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript then indicates the jurors complied. The jury was then individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, Madam Justice, yes.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, Justice. Yes, ma'am.
Did you hear Becky Hill, the clerk of court for Colleton County, make any comment about this case before your verdict?
No, ma'am.
Was your verdict on March 2nd, 2023 influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
No, ma'am.
Very good. Juror L, thank you, and you are dismissed. I will send word back by the bailiff if there are any further questions. I always ask the lawyers that before I dismiss the juror completely and go to the next one. Please know that I will keep you in case there's anything I need to have the whole jury for at the end of this proceeding. Then you're free to go, and you don't have to speak to a soul about any of this. Thank you, sir. Anything further?
Nothing from the state, Your Honor.
Nothing from the defense, Your Honor.
Very good. All right, Mr. Bailiff. Bring me juror E. Yes.
Okay, and this is very interesting. That dog in him says, you missed my super chat because the court came back. No worries because YouTube is asshole, and I blame Joe Choi. That's interesting. It didn't show up in the StreamYard feed, but I can see it here in the YouTube YouTube studio. That's weird. For some reason, it didn't even show up in my StreamYard feed. Back a while ago, where'd it go again? That dog in him said, this trial is more rigged than Cosby's. Well, not really, but damn close to it. Thank you so much. I apologize I missed that. It didn't show up in StreamYard. Weird.
The truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Sir, I will be addressing you as Juror E this morning. I've designated the jurors by letter. I realize that you sat on this jury in Colleton County for a lengthy period of time, 6 weeks or better, and people may know who you are, but to the extent I can make this record record that protects your anonymity, I am doing that. You don't have to speak to a soul about this matter after you're finished, and your service will be complete, as I'm sure you thought it would be when you rendered your verdict. I have these questions. You rendered a verdict. Oh, yes. It was brought to my attention that cell phones of the jurors were accessed in the jury room for a time, and that some were able to examine the broadcast of the testimony of the first juror called Juror Z. Was your cell phone one of those activated to look at the proceedings?
No, ma'am.
Did you look at the proceedings on any other cell phone?
No, ma'am.
Thank you. Now, you rendered your verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your hand. The transcript then indicates the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate answer about your verdict at that time?
It was.
Okay, it was.
Was
It
your
was a
verdict
verdict.
based entirely upon the testimony, evidence, and law presented to you in this case?
Yes.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
No.
Was your verdict on March the 2nd, 2023 influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
No.
Thank you, sir. That completes my questions. You may go to the jury room. I always consult with the lawyers to see if there are any further questions. If there are not, please stay with the jury until I dismiss all of you. I'm hoping that won't be too much longer. Thank you, sir.
Thank you.
Okay, so by my count, one person said yes, they were influenced, and
All right.
5 have said no. 1 to 5.
Anything from the state and from the defendant. Very good.
And
Uh,
one
bring
person
me
said they heard a
juror
cell phone,
P as in Paul.
and 4 said they did not hear a cell phone. I hope my count is accurate. But all right, while they're bringing in the next jury, Tank Rat has just gifted 20 Legal Vices memberships. Tank Rat, thank you so much, brother. If you were one of those people that got the 20 Legal Vices gifted memberships, give Tank Rat a super special thanks. Thank you so much for your support. Been there, done that, who has been a supporter for 14 months, says this judge looks like my mom. Just kidding, foil hat. She actually looks like my best friend's mom. Like not ironically, not even a little bit, like a lot like my best friend's mom. Lucentile, however you want me to pronounce that, catching up. Heard the juror say roughly, sounded like Becky thought he was guilty, and that affected my verdict. That's it, new trial. So far we're like 1 said yes, 5 have said no.
Good morning.
Good morning, ma'am.
I will be addressing you as Juror P, as in Paul. I've tried to redesignate the jurors without their number and, of course, without their name. Now, I realize you spent 6 long weeks hearing this case in open court in Colleton, and many people may know who you are anyway. But to the extent that I can make this record such that it protects your anonymity, I'm going to do that.
Yes,
And you certainly are not obligated to talk with one soul about this matter after your testimony is complete.
Okay.
Juror E, I understand that before I began to receive your testimony, that at the beginning when Juror Z was being examined, that some jurors may have had cell phones and accessed the proceedings. Did you have your cell phone?
No, ma'am.
Did you examine any cell phone broadcasts?
There was a couple people, but I have no clue what they were viewing.
Yes, sir. Okay.
A couple people. Okay, so it's more than
Did
one.
any of this activity by other people in viewing this material have any impact on you in terms of your testimony today?
No, ma'am.
All right. You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript then indicates the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, ma'am.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
It was.
Did you hear Becky Hill, Clerk of Court for Clarendon County, make any comment about this case before your verdict?
I did. Yes, ma'am.
What did she say?
Ooh.
It was the day that Mr. Murdaugh was taking the stand.
Yes, sir.
And she made a comment about watch his body language.
About watch his
body language.
His body language, I see.
Yes, ma'am.
And what else?
That's all I can recall.
All right, sir. Was your verdict on March the 2nd, 2023 influenced in any way with any communications by the Clerk of Court, Becky Hill, in this case?
No.
All right. That completes my questions, Juror E. Or
P.
P. Juror P.
P.
You may go to your jury room. You are free to refuse to discuss this with anybody. That's your prerogative. You're not required to talk about this anymore. That's your business. I've tried to do the best I could to confine this thing, but I appreciate your service. Thank you, sir, and you may go to your jury room.
Thank you, ma'am.
See, all right, we've had to open a new category. 1 has said yes, influenced. 5 have said not influenced, and 1 is heard but not influenced. If you heard it, there's conscious influence.
Nothing from the state, Your Honor.
All right, by the defendant.
Nothing, Your Honor.
All
There's
right.
being consciously
bring me
influenced, and there's
your-
subconsciously influenced.
Oh,
So, how do you say they weren't subconsciously influenced by it? Tankrat, who's been a member for 16 months, says drive-by grifting from work. Thank you so much, Tankrat, for the support for the last 16 months. And Jim Satala with a $10 super chat. What happens when every juror says it was others watching the trial on their phones? Wouldn't that be proof they're lying? We're getting there because 1 said they saw, they saw someone with a cell phone, and 5 have said no, they didn't hear anything. I mean, 1, and then this guy just said there's been 2. There's at least a couple of people that had their phones. So far, none of the 6 jurors or 7 jurors it wasn't their phone. We're running out of jurors. And Jana Morgan says the judge almost looks and sounds like Senator John Kennedy from Louisiana, long lost sister. Oh no, thank you so much.
Juror O. I have designated the jurors by letter in this record so as to try to protect your anonymity as best I can. Now, I realize you sat on this case for 6 weeks in open court in Carlton County, and many may know your identity. But to the extent I can, with the record of this matter, I'm trying to preserve your identity from any disclosure in this court.
You're not the only one saying this.
Juror O, I understand that several jurors may have activated their cell phone during the testimony of the first juror and looked at the proceedings. Are you aware of that?
Yes, ma'am.
Did you activate your cell phone?
No, ma'am, I did not.
Did you watch any of the other cell phones?
No, ma'am, I did not.
Very good.
Of course not.
You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript then indicates the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, ma'am, it was.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
No, ma'am, I did not.
Was your verdict on March the 2nd, 2023 influenced in any way with any communications by the clerk of court, Becky Hill, in this matter?
No, ma'am, it was not.
Very good. That concludes my questions. You may return to your jury room. I ask that you stay until I've completed the questioning of the jurors. You don't have to talk to a soul about this matter. It's purely your prerogative. And if you have any difficulties in that matter, let me know.
Yes, ma'am.
You are excused.
All righty.
Very quickly, I think question 2. I don't know that we did question 2.
Resume your seat. Was your verdict based entirely on the testimony presented to you in this case?
Yes, ma'am, it was.
Very good. You're excused.
All right. So by my count, we've got 1 influenced,
Thank you, Mr.
6 not influenced, 1 heard but not influenced. So 2 people have heard so far. Cell phone, yes. 1 said yes. They heard what was on a cell phone.
All right. Bring me
And
juror
6 have said no.
Oh, excuse me. Sorry. All right. Nothing further, Ms. Morris. Thank you.
So they said there's at least 2. One guy said a couple of people had their cell phones out. There's only 3 jurors left. So what if we get here and nobody says it was their phone? Then we've got some problems. Chappie with the $5 says, what happens if none of the jurors admit to watching the stream? That's exactly what I'm saying. 1 has already admitted but said it wasn't their phone. We're down to 3 jurors and at least 2 of them are on their phone. So, you know, we got some problems maybe here. And riding 50. So what will happen if all the jurors say they're not on their phone? Exactly. And thank you. I'm with you. It's like, what happens? Then you've got problems. You've got jurors lying under oath. Sound kid a new trial to me. It sounds like a new trial to me too, but I don't know.
Good morning, sir.
I hope. Thank you, Jensen.
I will be addressing you as Juror Y. I've tried to re-identify the jurors so as to preserve your anonymity in this record. Now, I know that you sat on this case for 6 weeks in open court, and many have seen you. They may know who you are. But as to the extent I can preserve your anonymity in the record of this case, I have tried to do so. You are completely free not to talk to a soul about this matter. That's always your prerogative. I understand that before you came out here, when the first juror to be examined was being examined, that some jurors may have activated their cell phones. Were you one who activated your cell phone?
No, ma'am.
Of course not.
Were you aware that some cell phones might have been activated?
I was aware after that.
All right, so
After the fact.
did you hear anything about the examination of the first juror?
No, ma'am.
Thank you, sir. You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript then indicates the jurors complied. The jury was individually polled and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, ma'am.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, ma'am.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
Not to me, ma'am.
No, that's not what she
Did you
asked.
ever make a comment to anybody else?
Not that I'm aware, ma'am.
All right. So
Oh.
you don't remember any details of any conversation?
No, ma'am.
All right.
I don't know. That was a pretty cagey ass answer there.
Was your verdict on March the 2nd, 2023 influenced in any way by any communications by the clerk of court, Becky Hill, in this case?
No, ma'am.
Thank you, sir. That completes my questions. I'm going to excuse you Stay together with the other jurors until I've completed my examination, and then you will be free to go. Thank you so much.
Yeah, that was a pretty cagey answer. I didn't like that answer. That was, did you? That was a little cagey, a little bit of a long delay there. Joe Pottinger's been
further from the state, from the defense.
Your Honor.
Very good.
Joe Pottinger's been a member for 8 months as clerk of court for Clarendon County. Sounds like a tongue twister to me. Thanks. And
Bring
Duncan,
me juror W.
W. Thank you so much for the additional super chat. I don't really think it matters at all whether a juror believes their verdict was influenced by X or Y in retrospect. How the hell would they know? See, I completely agree that the standard is not whether it did influence them, it's whether they said something that potentially could have influenced them, not whether there was any actual influence. So I think that is the standard. It doesn't matter whether or not they were actually influenced. Was the potential, did they say something that could potentially influence it? Did she say it or not? An island plot twist. It was probably the bailiff's phone. Well, we're running out of jurors. It's got to be somebody's phone.
In this case, to be the truth, the whole truth, and nothing but the truth. So help you God. Yes. Thank you.
And equality, why would you say not to me if she didn't say anything to anybody else? Exactly. I didn't like that answer at all. That was an equivocating answer.
Good morning. Good morning. I'll address you as Juror W. I have redesignated by letter the identities of the jurors as I question them today. Yes, ma'am. You know, you sat on this jury for 6 long weeks, and I'm sure that those who
don't let him out.
They're in the trial for a long period of time may know who you are. I'm just doing the very best I can to make your participation in this matter anonymous, and I will preserve that anonymity. You are free to not talk to one single soul about this if you don't want to. That's purely your prerogative.
You got to talk to the judge, though.
I understand that when the first juror was being questioned, some members of the jury, as you were back in the jury room, may have activated their cell phones. Were you one who activated your cell phone?
No, ma'am. I left my phone in the car.
And did you hear any information coming from anybody else's cell phones about that examination?
I did.
All right.
Okay.
Does that have any impact on the testimony you are going to give today?
No, ma'am.
Very good. You rendered a verdict on March the 2nd, 2023. The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your hand. The transcript then indicates the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? Each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes, ma'am.
All right. Was your verdict based entirely on the testimony, evidence, and law presented to you in this matter?
Yes, ma'am.
Did you hear Ms. Becky Hill, the clerk of court for Clarendon County, make any comment about this case before your verdict?
No, ma'am.
Was your verdict on March the 2nd, 2023 influenced in any way with any communications by the clerk of court, Becky Hill, in this matter?
No, ma'am.
Very good. That is the end of my questions, Madam Juror. You may go to the jury room, stay with the jury until I've completed the questioning, and then you're free to go, and you're free not to say anything you don't want to say. And if anybody upsets you or bothers you in any way about that, you just let the court know.
Yes, ma'am.
Thank you.
All right, we've already reached a problem. There's only one juror left. None of them have said it was their phone. One guy said there were a couple of people had their phones. There's only one left. So that guy is lying about a couple.
Any further questions from the state? Any further questions?
Nothing for the defense, Your Honor.
And this
All right.
this last person
Bring
better
me
cop to it
your
being their
juror
phone or their
cue.
problems. Equality says, why would you say not me if she didn't say anything to anybody else? Exactly. That was a KG effing answer there. That was a KG answer. And JA with the $5 super chat. Who'd want jury duty between this and J Hatch? Our legal system seems deliberately incompetent in favor of the state and corporations. These are very anomalous cases as far as jurors are concerned. It's sad they both came together at the same time. And Denver rigged as much as the trial. Well, we've already had one guy who's apparently not telling the truth when he said a couple of people had their phones out, because we've just had 9 people say it's not their phone. And Duncan Idaho, is someone being biplane flybys outside the courtroom using a leaf blower bees? Oh, I don't hear anything like that. But it's not even that. It could be the dog snoring. I don't know. It could be the dog snoring. This juror better effing say it was her phone or his phone.
Good morning.
His phone.
I will be referring to you as Juror Q. I have redesignated every one of the jurors by a letter. And in that way, I'm trying to protect your anonymity in these proceedings. Now, I realize that you spent 6 long weeks hearing this case in open court in Colleton County. And some folk may know who you are, but I'm trying to protect your anonymity in these proceedings as best I can. You don't have to speak to a soul about these proceedings after you have completed your testimony. That's purely up to you. And if anybody hassles you about anything, the court stands ready to assist. You rendered a verdict on March the 2nd, 2023.
Ask about the cell phone.
The verdict was
Ask
read
about the
in
cell
open
phone.
court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is
Ask
your verdict
about the cell
for
phone.
each and every juror, please let it be known by raising your hand. The transcript then indicates the jurors complied. The jury was individually polled, and each was asked, was that your verdict?
This is why you need
Each
to have this
juror
goddamn
answered yes.
question about the
Each
phone
juror
written
was then
down.
asked, is that still your verdict? Each juror answered yes. Was that an accurate answer
Yes, ma'am, it was.
about your verdict at the time?
Yes.
All right. Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, it was.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
No, ma'am.
Was your verdict on March the 2nd, 2023 influenced in any way with any communication by the clerk of court, Becky Hill, in this case?
No, ma'am, it was not.
Very good. You may be excused.
No.
And, if you just stay in the jury room till
No,
complete
ask about the
examination
phone.
of all the jurors. Thank you, sir.
Thank you.
Very briefly, I know we were doing the cell phone inquiry.
Yes.
Yes.
With various jurors. I
Yes.
don't know if you wanted to have that with this particular juror as well.
Sure.
What do you mean, sure? Say, oops, I fucked up again.
I understand that before I began questioning you or the other jurors, on the questioning of the first jurors, some jurors in the assembly room may have activated their cell phones. Were you one of the jurors that activated your cell phone?
Yes, ma'am.
Oh, he
Right.
did.
And was anything that you heard at that time something that has any influence or effect on the testimony you now give under oath?
No, ma'am.
Hate that question. She asked a different question of the first person, of the 2 people that heard things on the cell phone. See, that's why it needs to be scripted. The questions were not the same for each of the jurors that said they heard it or did it.
For the state.
Nothing, Your Honor. Nothing, Your Honor.
All right. Bring me juror K.
Wait, I thought we were out of jurors. I thought we were out of jurors. Wait, how did I miscount on the jurors? Huh. Yeah, my math isn't mathing. Has anybody else been keeping score? Because that was 11 jurors by my count.
Yes.
All right. Well, my math is all dicked up now. No, it's not the alternates.
Good morning.
The alternates don't matter.
I will be addressing you as Juror K.
Maybe the alternates. I don't know.
Each of you jurors and gave you a letter for purposes of this hearing. I'm trying to protect your anonymity as best I can. Now, I realize you sat for 6 long weeks on this case in Carlton County, and many folk may know who you are.
All right.
On the record of this matter, as best I can, I'm trying to preserve your anonymity. Please know that you don't have to answer anybody's questions about this matter in any way, shape, or form. Purely up to you. And if anything is done that you feel is harassing or makes you uncomfortable, you contact the court. We'll try to do as best I can to help in that situation.
Yes, ma'am.
All right. I understand that during the testimony of the first juror, some opened their cell phones in the jury room, in our jury assembly room here. Were you one who opened her cell phone?
Yes, ma'am.
Did you listen to or watch the broadcast of that first juror's examination?
We were on Facebook.
Ma'am?
I was on Facebook.
It was on Facebook, and you watched it?
When we closed it.
All right. Did anything that you heard in that Facebook cell phone access impact or influence your testimony in this matter in any way?
No.
All right. You rendered a verdict on March the 2nd, 2023.
Okay.
The verdict was read in open court, signed by the foreperson of the jury. The court then said, Madam Forelady and members of the jury, if that is your verdict of each and every juror, please let it be known by raising your right hand. The transcript then indicates the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? Each juror answered yes. Was that an accurate answer about your verdict at that time?
Yes.
Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes.
Did you hear Ms. Becky Hill, the clerk of court for Carlton County, make any comment about this case before your verdict?
No.
Was your verdict on March the 2nd, 2023 influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
No.
Thank you, ma'am. That completes my questions. I'll let you go to the jury room now. I'll then ask the attorneys whether there are any further questions. If there are not, please just stay in the jury assembly room until I give you the word that you are all to come out one more time, and I dismiss you. Thank you, ma'am.
Yeah, it's probably the dog snoring. I can't hear it, but maybe you guys can. All right. Well, shit. Big Daddy's sister-in-law, member for 9 months, says they brought back in one juror for more questions. That we counted her twice, possible.
Very good. This then completes the questioning of the jurors. I will ask the jurors to come into the open courtroom again, thank them, and dismiss them. Anything further before I do that?
None from the state, Your Honor.
Was that potentially criminal? Sean, what's up, brother? What kind of bucktooth hillbilly nonsense was Becky engaging in? She actually drove a juror to court. Did I hear that right? That was one of the questions. Did she drive you to
Your
court?
Honor, I would move for the record that I
said
be
no, I believe.
able to question Juror Z to follow up on what I believe the court is confused about.
What is the court confused about?
Very good. I deny the request. Anything further? All right, bring me the jury.
Bathe them and bring them to me. Chappie with the $2. Juror kink. I see nothing. I know nothing. Oh, juror clink. I read juror kink. Yes. Yeah. Juror clink. I was going to say, hey, it's clink. Juror clink. I see nothing. I know nothing. Exactly. Oh, wow. Right. So I'm presuming that the juror that was questioned on Friday was one of the jurors that said they were influenced by Becky Hill's testimony. Because there was the two affidavits saying there was. And only one of the witnesses here today said they were influenced. Yes.
Thank you.
Yes, the colonel was. I wasn't going to say the colonel was
Ladies
Klink.
and gentlemen of the jury,
The soldier was
concludes,
Schultz.
The court's examination of the jurors in this matter. I can only deeply apologize to you for having to inconvenience you so long after the trial of this case to come here, and I very much appreciate your candor. There are no right or wrong answers to the questions I asked you, but I think
There are
you
just
did
truth and lies.
the best of your ability, answered the questions, and I am deeply grateful for that, as is the state of South Carolina, as is the defendant. You don't have to speak to a soul about this matter if you don't want to. That's purely your prerogative. If there's any difficulty you encounter about this hearing that I can help with, please contact the court, and I'll be happy to do so. You're dismissed this time. You may go. Thank you for your service. Excuse the jurors.
Okay, I think Becky's up next. I think Becky Hill is next in the hot seat. We've got 1,020 people here watching. Thank you so much, everybody, for being here and watching here on Legal Vices. And just if you're so inclined, please reach down there and hit the like. Give us a like. We've got 666 likes. We got devil likes, 666 likes. Get down there and get us up to 1,000 likes. We should be at 1,000 likes.
All right, Mr. Waters, is the clerk of court available?
Yes, ma'am. It's my understanding she is, and state's prepared to call her when the court is ready.
Let's do it.
All right.
But I believe she's at a location. Mr. Lewis is here just a block or two away. So if we take a brief recess, we'd be prepared to present her after that.
Well, I will entertain going on and taking an early lunch break.
No.
I don't know how long Ms. Hill's testimony is going to take, but if that might be a better thing than hanging around here, I think that's what I would prefer to do. Mr. Harpootlian?
Your Honor, I need sustenance.
Okay. Well, good. I think I would join you in that. What I will do is I will recess court until 1:15.
1:15?
Thank you, Your Honor.
That's an hour and a half for lunch? An hour and a half for lunch, really? Now, see, now I'm torn. I'm torn here because that's a ridiculously long lunch. I mean, go for a 30. Well, we can't change the lunch time. Now, we've got 1,015 people here. My fear is that if I shut this down now and then we come back in an hour and a half, we're not gonna have all of you guys hanging out here. We'll lose our momentum. But on the other hand, what are we going to talk about for an hour and a half? And I wonder if there was someone that was making sure Becky wasn't watching the proceedings. I doubt it. The judge needs to take a nap as well. Thank you, Jennifer, for that. All right. Well, Alec is out of the courtroom. Well, we've got an hour and a half break here. I don't know what to do. I'm torn. Catch up on Koberger. I haven't been following the Koberger case because I don't want to get involved in all the motions and all the other crap because that trial's not going to happen for at least another year in my estimation.
High-speed chases.
Whoa, Dick, shut up. All right, hang on. Be quiet. There we go. All right. Had law and crime yelling at me here. Right. I'm at a loss as to where we go. Do we take? Let's look at our poll here. Our poll was 63% said yes, new trial, 29% said no trial, and 8% said hell no for a new trial. Let's do a quick poll here while we've got 900. See, we've already lost 100 people and said, we're going to go to lunch. Let's put up a quick poll here for what we should do. Should we take a break for 1.5 hours or plow through? Take a break and continue. Our choice. Let's put this. The poll is up here. We'll give us a few minutes to look at the poll while we talk about what just happened. First of all, we have the absolute nightmare of the jurors listening to the first juror that was questioned today. Talk about what was going on. They were at least two of them said it was their phone, and another person said that they heard. Two other people said they heard the cell phones. So 2 people were listening. 2 additional people said they heard them, but nobody was influenced by it. Of course, whether they know it or not, they were not influenced. I'm seeing if Liz, paralegal Liz, who was the guest last Friday, is available to tell us what the juror on Friday testified about. We could talk about how amazing the narrator is for the wager audiobook. If you weren't reading or listening, you're missing out. Yeah, he was a very, very good narrator for the audiobook about the wager. I agree. Except for his pronunciation of Don Juan was Don Juan, and that kind of irked me a little bit, but that's just me. All right. Well, looks like we've got 64% saying continue. Oh Lord, what are we going to talk about for an hour and a half? What? All right. We'll do what we can to continue, I guess. I've sent out a text regarding whether or not we can get paralegal Liz, who's in the courtroom today, to bring us up to speed on what happened with the first juror that was questioned on Friday. But so we. Okay, it says here, I'm sorry to do this live. And she is available. I'm asking her if she has time to download the StreamYard app for her phone and join us. We'll just kind of, I'll do this as long as we can. It's 2 a.m. here, so I like the judge could use some sustenance and a nap, but seems like y'all want me to continue, so we'll continue as long as we can. Let's recap. We started off with the jurors listening to the first witness testify. And she said yes, she heard the judge, sorry, she heard Becky Hill say these things that she said she heard in the affidavit, and she said she was influenced by Becky Hill's affidavit. Sorry. All right, okay, I was really freaked out by that 1.5 hour thing. Let me regroup my brain here, reset. Okay, the first juror that was questioned said yes, Becky Hill said all the things that she said Becky Hill said in the juror's affidavit. And she said that what Becky Hill said influenced her decision. She felt pressured by Becky Hill's statements. And then they said, well, her affidavit says she was influenced by the other jurors. But what the judge didn't allow was the question about whether, because the judge questioned her about that and said, well, so would you say your affidavit that you were influenced by the other jurors is more accurate than you were influenced by Becky Hill? And she said yes to that. But Dick Harpootlian made the objection and argued that both can be correct, and she should ask the juror whether both were correct. And the judge denied that, which I think was the wrong decision, because absolutely it's possible to be influenced by Becky Hill as well as to be pressured by other jurors. All right, so it looks like Liz is available, so she's gonna get ready here, and then as soon as she's available, we'll have her on. Friday's juror. All right. And so by my tally, which may not be accurate because somehow I had an extra juror in somewhere, one person said yes, they were influenced, and 9 jurors said they were not influenced. And one said they heard Becky Hill say things but were not influenced. And then whatever the juror on Friday said, and I'm going to presume that the juror on Friday was the other juror that said that they heard Becky Hill say these things and was influenced. Because there was 3 affidavits, one from Egg Lady, who we didn't hear from. The judge specifically said we're not calling Egg Lady juror, and then there was 2 others that said that they heard these statements. And DCV Titan with the $5 super chat. Regardless of the decision, I'm bouncing over to Midnight Edge in 25 minutes. Well, fine. Don't let the door hit you in the butt on the way out. We're all gonna stay here. We don't care where other people go, because this is the only show on the internet right now. While I'm on, I'm the only channel that's on, and the only channel that means anything. Damn it! And Judge Megan and join Megan and show her stream. What's Megan doing? We'll see how that goes. We'll see how long it takes to get through all of this. Well, so what about you guys? Let's throw it open here. Let's throw it open to chat. Give me your thoughts on what we've seen here today. I'm curious to see what you're all feeling. I know I've seen some of the chats go by. Let me make sure I got everything out of the way. Yep, we do have all the super chats taken care of. So come on, chat. Give me your thoughts. Is this hearing appealable? Yes. The judge made that clear when she overruled a bunch of objections and of Dick Harpootlian, and also refused to grant some of his questions. And yeah, these are if you have a problem with it, it's an issue for a higher court than me. Who is Egg Lady? Egg Lady was a juror that was excused right before deliberations. And that's part of the allegations, was that Becky Hill knew that she was pro defense, and then set up this whole elaborate fake email from Egg Lady's ex-husband about how he talked to the juror and she was drunk, and talking about how she was pro defense and whatnot, which turned out to be an absolute falsity. And as she was leaving the courtroom, she asked the judge if she could go back to the jury room and get the eggs that she had left in. She had like a dozen eggs in there. And so then she's been called the Egg Lady. I think we should call her the Monkey Lady, because she actually worked at a monkey farm, was her job. So I think she should be called the Monkey Lady, not the Egg Lady. But She got nicknamed the Egg Lady by people. I mean, come on, isn't Monkey Lady cooler? I think it is. That's just me. All right, it looks like Liz is now available. So let me bring up our in-court layperson, paralegal Liz, when she joins. I've just sent her the link. Ken D says, "Do I think he's guilty? Yes. Do I think he deserves a new trial? Yes." I'm still not completely convinced on the murder charges. On the financial crimes, yes, but there was way too much financial crime BS in the murder trial. So I think that's the problem. Do they produce monkey meat? No, it was apparently a monkey farm for research monkeys. Well, it should be enough for a mistrial, but we have to prove it. That's the problem. I always thought monkeys don't lay eggs. Scrambled monkey and spider eggs. Ah! Yeah, Becky doxed Egg Lady. There's only so many monkey farms. Yeah, probably one. I would guess there's one monkey farm. That would be my guess. All righty. So what do we got here? No doubt Murdaugh is a supreme asshole, but murdered his family. Still not sure either. I think there was a lot of evidence that that proves he couldn't have done it. Just the angles and weird things like that, and the timeline doesn't work out, and the cell phones don't work out. I don't know. Yeah, there was way too much financial stuff in the trial, especially being, if I remembered right, they never proved he had insurance on either two. Well, if you murder somebody, you don't get to claim the insurance anyway. So we had the brainwater testify, the brainwater testimony. We have a monkey farm outside Shreveport. So okay, there's one in South Carolina and one in Louisiana. All right. Now I know of two monkey farms in the United States. It was all a pile of sled effery. Yeah. Well, we do have the sled agent who essentially admitted that he lied to the grand jury in getting the indictments. So yeah, there is that problem as well. But this is only dealing specifically with the Becky Hill issue. So I think it's a mob thing. That's kind of where I'm not even necessarily a mob thing, but it's some sort of organized mob cartel, whatever thing. That's the way I'm leaning in this trial, actually. I have a problem with the mystery hair, tire, and footprints, not to mention they never found the gun. Do they milk the monkeys on the farm? No, they don't. I think Murdaugh deserves a retrial, says Devins Moore. Yeah, evidence doesn't add up. I was not convinced he was guilty of the murder. But boy, the jurors sure were. I guess. Oh, what's up, dogs? Getting all stretchy there? And you have to zoom out on the dogs here so we can get some more of them in. Or just get sleeping Yoda. Drug thing? Likely there's at least reasonable doubt that it could have been that. I agree drug dealers killed his wife and son because of the drugs. I think cartel. And Duncan, Idaho. I think Murdaugh was involved in an Ozark type situation with drugs, money laundering, knows who killed his family, but won't say who, has a surviving son. That is a reasonable conclusion in my book. Now, all right, we're gonna quickly bring up our guest. This is paralegal Liz, a paralegal who is in court today. She was in court Friday, and so we're going to bring her up and talk to her about Friday. So let's see here. Let's bring her in. Here we go. Let's move the dogs down here. Liz, can you hear us? Can you hear us, Liz? We've got no audio from you. There's no audio from you, unfortunately, Liz. I don't know what the deal is, but we have no audio from you. So we're gonna pop you out there and check the audio in your settings, in the StreamYard settings, to see how the audio is set up. And just as a suggestion, a lot of times StreamYard doesn't work well with wireless headphones. So give me some sort of hand sign if you think you've worked out the audio deal. Oh, she says she's got a deal here. We're still are we here? We're still not hearing you. All right.
Can you hear me now?
Now we've got you here. Can I just ask that you stop walking? The background shaking is really, it's like motion sickness.
Let me walk.
Okay, there.
Let me just walk there
Right.
because I'm not behind this car.
Okay.
I don't want to get run over.
All right. Yeah, don't get run over.
But I'm sorry. I will stop walking in just a second. I'm almost to the sidewalk.
She's outside because everybody's outside. It's lunchtime, Mary Jane. That's why everybody's outside.
Everyone is outside. Well, hello, friends.
All right. Do you have your notebooks ready from last Friday?
Well, it's actually saving my spot right now.
Ah.
So, no, but I have it all here and I'm ready.
All right. Well, let's thank you for taking your lunch hour. I know you probably need sustenance, as does the judge and Dick Harpootlian. So we'll try to keep it short.
I packed snacks in my purse, so I plan on shoving them in my throat. Becky shouldn't take long, I don't think, so I'll get substance after.
Well, all right. Let's see here. We're good to go. I guess we can hear you just fine. All right. So you were in the court last Friday. We had you on last Friday. We couldn't talk about any. We only found out we couldn't talk about anything last Friday just before we started last Friday.
Yeah, that was fun, wasn't it?
But now we can.
Now we can. Did y'all see, though, that like the jurors were back there watching their phones?
Oh yeah, that was all the big thing. So let's talk about last Friday. Who was the juror Z? Male or female?
Female. It was the foreperson.
Okay. So the foreperson was the juror that was questioned last Friday, who for some reason couldn't be in court today.
Bible study priorities. That's what the priority was.
All right. Well, so the questions now, Chad, help me out with these questions here, because I know we've only been listening to them for 2.5 hours with 11 other jurors. But so the big question were, when you were asked at the end of the trial whether this was your verdict, you answered yes. Is that correct? What was her answer to that question?
Yes, it was.
Okay, so yeah, I would assume that would be her answer, because they were asked right then and there. Mm-hmm. So, well, that was the then. Did you hear any communication that Becky Hill had with any jurors at any point? What was her answer to hearing Becky Hill say anything?
No, she denied it. It was very boring. No.
Oh, she said she didn't hear anything.
Yes, you're right. I'm letting you lead this, and then you'll get to the tea. But
all right, so then I guess there was so was she influenced by anything she heard about the trial?
Well, she said no, but then did you hear the memorandum, the email from?
No.
Okay.
We have no idea what happened Friday. So that she answered the questions, and then what happened after she answered the questions, all no. She wasn't influenced by Becky Hill.
No, she wasn't. And what happened was then Harpootlian got up and said that morning, which I saw it happen, transfer of paper, Creighton Waters handed a supplemental memorandum, which was basically a fancy word of saying an email that he printed out to just give to the defense, because, you know, you're an attorney. When one side gets something, you're supposed to share it with the other one. So apparently Eric Bland who represents like half the jury or more, emailed Creighton Waters to let him know that his client would be testifying that she did hear Becky Hill say something before court, before the deliberation, but it's like she denied it and said it didn't affect her. And
and that was the witness on Friday.
Yeah, not today, Friday.
So her testimony in court was different than what she said, than what Bland said in the email she would be testifying to.
That's my understanding. Yeah.
Okay. Well, and how did that all pan out?
Were you guys? I don't know what y'all have seen, but were y'all
Nothing
live
about
at the
Friday.
court? Oh, okay.
We saw everything today. Nothing about Friday.
Well, Eric Bland wasn't allowed to talk on Friday.
Okay, and he was told to sit somewhere else today.
Yes. Did y'all see the fire that happened this morning about this? Well, about the next juror he represented?
What fire?
When he objected to Poot. You had to have, because it was right before the examination of the juror today, the first one.
Yeah, and then the judge said, shut up and go sit somewhere else.
Oh, great. I didn't hear what you said.
Yes, no, he told him he wasn't going to be speaking and to go sit somewhere else.
Yeah, and then
Yeah, we saw and heard everything that happened today, from the time the judge walked in, and they were asking the questions about merit, and they took the word merit out of the question, which I thought was the right thing to do.
Which is what he asked for this whole time.
Is there anything else that happened on Friday that we haven't talked about?
I guess no, not really. Just everything has changed so much since last week, since Friday. But no, nothing is. That was like everybody said in your show Friday. It was the most uninformative thing because there really wasn't much to talk about. And
yeah, we couldn't talk about much.
And the jurors. What the? I'm just sorry. Look at what's going on. It's just
no image.
Oh, is that the black preacher guy?
No, but I took pictures with him. He's around. I'm literally right here by the circus. Those are, I don't know what's going on with that, but the media is everywhere out here.
So who's all in court? I mean, Court TV's there. Obviously, Law and Crime is there.
Yeah, Court TV, Law and Crime, Fitz News, all the other smaller local outlets. There's some YouTubers here. I don't really want to name drop on your stream. That's not fair.
Nah,
but
we don't care
there's
who's
some
there.
here for sure.
They're lame. We don't care.
I've met a lot of new cool people. I'll have to do a selfie drop later.
So who have you talked? You've talked to Gigi from Law and Crime today, or?
Mm-hmm. Yeah, and well, I don't really want to name drop so much, but I did. It was actually she saw your stream, so I'm sitting in court.
What?
I don't know if yeah, so watch this. So I'm sitting in court, and I know who all these people are because I'm like on the internet watching.
Hi, Gigi.
Right?
Yeah.
Yeah. Well, this isn't. I'm not talking about Gigi. I'm talking now about lawyer Lori. She was sitting in front of me in court, and she bent over and had her little booty up in the air, and I was like, "Ooh, girl!" Like, had to restrain myself because she put it there. I wanted to spank her.
Okay. Well, we don't need that.
I don't know her, and whenever she turned around, she laughed. She's like, "I heard that," and she was like, "Liz," and I was like, "What?" And I was like, "How embarrassing! You know who I am?" And she was like, "Yeah, I watched your interview." I was like, "Oh, this is not."
Oh well. Well, there you go. Hi, people watching my stream from the lawyers' tables.
Yeah.
So what is the other? Have you talked to? I know you just came out very, very quickly right after the trial, right after the hearing broke for this weirdly long hour and a 15-minute, hour and a half lunch or whatever it is.
Mm-hmm.
Did you talk to anybody else, or what was the feeling from the other big media folks? Any particular reactions from them?
Yeah, I was like not every time, but when the first juror, was it Juror Z today, was
Yeah.
telling her truth, I literally stared straight over at like Will, and then I'm sitting next to one of their attorney correspondents in court too right now. So we actually like held hands down on the pew, like on the church, like not the church pew, the the seat.
Okay,
we
well, what were we talking about? But was there any talking between witnesses? Like while they were moving the witnesses around, was anybody in the gallery talking that you could hear?
Oh yeah, I'm also sitting behind the attorneys for Becky Hill in court right now. Well, for some of them. So it's interesting because whenever they pulled out like different affidavits, they're shuffling and pulling out the same affidavits, and I'm getting they're like, oh shit, where's that affidavit? They're flustered. They're like doing their lawyering from not the actual lawyer table, but from the gallery, and it's kind of interesting to see their reactions and hear their stress.
All right. So what have you heard anything from the law and crime reporters or the court TV reporters about what they were saying or thinking during the thing, or have you had time yet?
I haven't even seen them. We were going to do lunch, but they're all on their live streams too right now.
Yeah.
So no, I haven't really got to. We were all just kind of like making side eye at each other, trying not to be distracting. But oh my gosh, like,
okay,
big deal.
So are you enjoying the time in court?
My butt hurts real bad from sitting on that hard bench. But yes, this is very exciting.
Okay, other than that.
Yeah, I'm really enjoying it. I think it's going to go by really fast. I'm interested to see how this judge is going to handle her potentially pleading the fifth,
That's a lot trickier to do in this type of a situation, but that'd be interesting if she did. Now,
I mean, I'd expect her to, but it's just so interesting. Justice Toll seems to be very just not here for the bullshit and fuckery today. She even excused her one time.
Well, although she did create this problem by not telling the jurors not to watch their cell phones.
She said on Friday she was going to make sure, and I told you all this, that no attorneys would be back there, and there would be a bailiff. That is what she said.
Yeah. Well, that didn't happen, I guess. But so, well, that is what that is. Now, you from what you said on Friday, Becky Hill is going to testify, and then the defense is going to be calling one witness.
Yeah. And I don't know if it's going to be, did y'all hear Poot talk about her, Becky Hill's friend at another county courthouse? Do you think maybe it could be her? I really don't know.
Well, it said Becky's what? She was 2 blocks. I don't know why she wasn't in the courtroom. I mean, in the court building. I don't know why she was 2 blocks away.
Yeah, she's just 2 blocks away. That's what I'm trying to. Yeah. I'm dying. After we get back, I'm going back in there to like eat a kind bar and just sit in the front row with my purse. So some nice strangers are watching my spot.
That's very nice. So all right, well, so there's only 2 witnesses left basically for the day, and however long that takes, I guess, is however long it's going to take. Yes. We'll let you get back to doing whatever you needed to do. Thank you so much for giving us the details finally of what happened last Friday. We can finally talk about it.
I know, and I will be much more prepared and less frazzled, or it's a little dangerous out here.
Yeah, well, get back into the courtroom where there's bailiffs with guns.
Yes, I will. I'll show you all the media people real fast, and then you can go. So here's beautiful downtown, all the media, and that's where I'm going back in. So
that's the courthouse entrance there, and they got the media tent set up, I guess.
Yeah, she's one of my new friends. This is Court TV right here. That guy right there with Court TV was so rude to me. He was like, "There's plenty of room next to you," and I was like, "No." He's like, "Yeah, there is." I was like, "No, there's not." Rude.
Be nice to big media, man. They can be your friends. So if you hear anything interesting over the next hour, message me, and we'll make sure we find out what's happening. If anybody has anybody from the big
inside. Whenever I get back in, I'll send you some pictures of what's going on at lunchtime.
All right. Well, thank you, Liz, so much for taking time out of your lunch to give us a little bit of the details on what happened last Friday. We can finally talk about it. Appreciate that, and we'll be getting the audio later and talking about that at some point. Now that we can do
use my
all
laptop later. So
yeah. All right. Thank you so much. Enjoy your lunch. Take care.
too. Bye.
Bye, Liz. All right. So we finally found out what happened last Friday. It was the jury foreman. And she apparently she's represented by Eric Bland, who sent an email to the prosecution saying that she would be testifying that she heard stuff but wasn't influenced. But then when she got into the courtroom, she apparently testified that she didn't hear anything and wasn't influenced. Well, that's interesting. So we'll have to, we got about an hour left before they come back into court. And we'll go with Becky Hill and then whoever the whoever the defense puts on as their witness. All right. So you've all said to stay here. So, all right, we'll just plow through. Screw sleep. I don't need sleep. I will have to step away at some point, I guess, and get some caffeine. But we've still got some time here. Let's put up another poll, shall we? Now that we've heard from the jurors, let's put up the poll that I don't think we can put up the same poll because I did copy and paste, and then I promptly, I knew I copied and pasted something else over it. So, see if we can scroll back up here to find out what the. I can copy and paste the last poll. Nope, it's too far up. All right, so hit the like, subscribe, and vote. Got to put those words in there: like, comma, subscribe, and vote. Will Becky Hill's alleged shenanigans result in a new trial? Yes, no, and we'll put the hell no option back in. Great, there we go. Here's the new poll is up for a new round of voting after hearing from all 12 if we rely on the statements that Liz gave us about what happened in court on Friday. So we've heard from all 12 jurors. Let's see what y'all think. And we have Sandy B, where the jurors told they couldn't have their phones. Apparently not. Apparently they were just told not to talk about it. They weren't told not to watch it. Is this what we think should happen or what will happen? What do you think will happen? This is what you think will actually happen. Tom Nash Music with a question. Just watched back it of EDB stream Legal Devices from earlier when Juror Z and the phones came up. They're losing it over there. Well, they should lose it. But Emily is Emily. I'm better and more interesting than Emily because I am the king of my stream time. So anytime I'm on, I'm better than anyone else that's doing anything ever. So that's just me. All right. Well, shoot. What I want to do. I want to go back, I think, and let's see what I want to see what Law and Crime and what Court TV are talking about right now. So let's do that. Looking at Law and Crime. Get rid of that document. Oh, hang on. And let me fast forward here. Okay, Law and Crime. All right. Let's bring up Law and Crime here for a bit, shall we, folks? Well, as soon as the dogs return to the room, we'll bring up Doggo Cam. Here we are.
up to the Supreme Court, of course. The Chief Justice Beatty would have to figure that out if this even happened. Ellie from Twitter, Cherry Austin, asks, why was the clerk saying anything to the jury? They shouldn't be joking or talking to them at all. Sounds very unprofessional.
It does.
Well, you are absolutely right. It was very unprofessional. And she should know, as the clerk of the court, that you are not supposed to have any conversations with the jurors, whether you're inside that courtroom or outside the courtroom. You should avoid any kind of contact, whether or not you are going up the stairs or in an elevator. You certainly should not be driving those jurors in a car, because of course you will have some sort of conversation with them. So I definitely think that she was wrong for initiating those conversations, if in fact it did occur. And it does sound as though there were these conversations consistent with what the affidavit, at least of Juror Z, had to say. And so, the judge is going to have to really determine whether or not it is enough to grant a new trial. One thing I'll say, Anjanette, is even if Alex Murdaugh receives a new trial, he still has 27 years for those financial crimes. He's now 55 years old.
That's only the federal crimes. There's the state financial crimes.
All intents and purposes, he's going to spend the rest of his life in jail, even if
it was 27 for federal and then like a bunch more for state. So yeah.
And don't forget the federal case, Terry. He hasn't even been.
It was 27 for state.
I mean, so
it was 27 for state and a lot more for federal
as well.
Right.
And I've heard through the grapevine it could be around 40 years. And so it depends on how much time you're required to serve, both in federal prison and on the state side. State, he has to serve, I think, 85%. Let's get to our next question from YouTube. This one is from 007 from YouTube. Lori,
well, of course
it's for
it's 007.
Why isn't the very first juror's answer enough to stop the proceedings and the judge to decide on a new trial?
Okay, I was going to actually address.
First of all, she was going to hear from everybody, but the affidavit that this juror signed said that she felt pressure from the jurors. Okay, we can't go into the jury room. The rules don't allow us to go into the province, the sacredness of the jury room. Mm-hmm. We can only talk about outside forces from Becky Hill.
Yes.
So when she came back, when Justice Toll came back with that affidavit, she reminded her that she had testified in her affidavit that it was the jury room that influenced her, not Becky Hill. And so once you have Becky Hill pushed aside from that, you're comparing two different testimonies, testimony from her affidavit and the testimony from this morning. Justice Toll made sure to ask her the questions and remind her, basically impeached her with her own affidavit, reminded her what she said in her affidavit.
See, it's not an impeachment thing. They can both be correct.
Her testimony is not going to have any bearing.
No, they can both be correct. She can be influenced by Becky Hill and be pressured by the jury. That's why the judge was wrong in not asking whether both were true.
Personally affected, except for the first juror, and she was impeached with her own affidavit by Justice Toll. And I think that's enough, and that's going to be enough to say your affidavit weighs, because it was more recent, it was more primary, it wasn't done in the pressures of a courtroom. I think she's going to go with the affidavit.
Interesting. And it wouldn't surprise me one little bit, because Dick Harpootlian tried to withdraw that whole request about the affidavit, and she said, no, you asked for it, you're getting it. So it was kind of interesting.
It was just such a bad moment. And it really, I feel like she's doing everything she can to not grant this new trial. And that's okay. She's the judicial system. She's protecting the system, but
you can't protect the system.
He asked for it for a specific purpose. This is what I mentioned earlier. He asked for it to refresh her recollection. When you do that under the rules of our civil procedure and our criminal procedure, you hand the person the document, they can look at it, read it, and then you say, did that refresh your memory? And the witness says yes or no. And if they say yes, then you say, okay, and take it back. It's not in evidence. So that affidavit was never moved into evidence.
Right.
So I think we're going to have a problem there down the road, because Justice Toll used it to impeach the witness and the juror whenever it wasn't in evidence.
Yep.
Chris Adams, this next question is for you.
I believe the judge was wrong.
Kristen Davis from YouTube. She asks, how could the state prep Becky Hill for testimony when the state would be prosecuting her for jury misconduct or jury tampering? Interesting question, because Creighton Waters said it in open court last Friday that they spent, I think, about 6 hours with Becky Hill prepping her. Meanwhile, SLED is investigating her for possible criminal misconduct,
different
including
prosecutors,
the jury tampering.
different system.
How do you prep her when you might be prosecuting her?
Well, if this were a true investigation of her that was being conducted by SLED, and the goal wasn't to try to do whatever you could to preserve the conviction, but if you were really doing an independent investigation, then she would have her lawyers there and you can negotiate over the scope of the questioning. She might not answer all the questions. In this situation, by contrast, Kristen on YouTube, I suggest to you that SLED is doing everything in their power to try to affirm this conviction.
Yeah.
And that she is not under any real risk of being indicted within the state of South Carolina. I would be stunned if that were to change. So I think that she knows, and her lawyers would know, that if she just cooperates and
do you really think SLED is going to be doing a great job investigating?
And they would like for her to testify and to help affirm the conviction of Mr. Murdaugh.
Right. Yeah.
Terry,
do you really think SLED is going to be doing a great job proving that she caused problems?
Wasn't the jury polled at the conclusion of the verdict to verify that they independently arrived at their conclusion? And Terry, that was actually one of the questions that Justice Toll posed today.
That's exactly right. And this viewer is so correct. At the end of every trial, the attorneys can ask that the jury be polled, and they did. And when the jury was asked, each one of them individually said, yes, that was my verdict. So I do think that there is a problem here when, in fact, right after the verdict, they didn't mention it. They really should have. Now, obviously, there's no liability for doing that. There's no criminal responsibility for doing that. But this really should have been something that was raised closer to the time of the verdict and not, as the judge has already said, so much later. She's apologized for the fact that this really has been a very long trial. The trial itself took weeks, and now this is, more than a year later. And in fact, she doesn't want to continue taking the time of that jury. But if the jury had mentioned it before, we probably would not be in this position as we are today.
SLED is the South Carolina Law Enforcement Division.
We are going to take a quick
Basically
break.
the cops.
Keep those questions coming to us on Twitter, Facebook, YouTube, of course, and wherever else you're watching us. I'm Anjanette Levy.
So they're going to take a break. Well, now that they're taking a break, let's go back and just watch. Let's watch this again. We can talk more about it as we go through here. Let's see. Where's the start?
About the case.
Okay, so the audio is going to pop in here any second now. Somewhere.
But I don't want any photographs. I don't want any photographs taken of the jurors by the media.
By the media.
With respect to the rest of the audience, if you have devices, cell phones, iPads, or anything of that nature, please silence them. Please do not use them. The press is allowed to use their devices in order to make notes, but the press is not making any photographs either.
Yeah, so it was very nice of her to tell the people in the courtroom not to use their devices. She just seems to have forgotten to tell the jurors not to use theirs to watch the damn proceedings. Exactly, listen to exactly.
I have a pool photographer as well as a pool court TV arrangement, and that's what will be used to photograph, and that those materials will of course be fed and available to the press. I think if there's anything else. All right. All right, the jurors are in place in the jury room, Mr. Bailiff.
Yes, Your Honor.
Very good. Bring me the jurors. Sure. Hold for a minute. Yes, sir.
Your Honor, you have a list of questions you've distributed to us. And
yes, sir.
Of course, you went through those with juror
Z or X.
X. I knew it was one of those
yes.
last letters. Juror X. The third question, you say, did you hear Ms. Becky Hill make any comments about the merits of this case before your verdict?
Yes, sir.
And clearly the juror didn't understand what the word merits meant.
I disagree with that, but
So, and I don't know. We haven't actually heard Juror Z yet, or Juror X, what Juror X had said on Friday. But he's saying it was clear that she didn't understand what merits of the case meant, and I think that's a legitimate issue, because that's something that lawyers say. You know, we talk about the merits of the case, but the average human being may not know or understand what the term merits of the case means. It means, I mean, it's even hard to explain. Like, the merits of the case are just the whole picture, the whole, you know, the value of the testimony, the facts versus the evidence, versus opinion. It's just kind of everything. The main points, the proper parts of the testimony. And I think it's good to remove merits of the case. If it was a bunch of lawyers that were being asked and questioned, you wouldn't have a problem. So, when you say, does the case have any merit? Is there any value to the claims? Is there any value to the assertions? That's what they're talking about. And so I think it was proper to remove the word merits from the question. Potentially criminal says they're carrying the brain water for the state.
you may make your record about that. I think the juror understood what was being asked. And frankly, in some of the materials that we exchanged back and forth about questions, you yourself have used the word merit. So
yeah, but see, that argument doesn't hold, because it's lawyers talking to judges using the word merits. We all, as lawyers, understand what merits of the case mean, whereas the average lay person, the juror, may not understand.
I don't think she was confused.
Well, Your Honor, occasionally I make a mistake. I think in this case, perhaps you've made a mistake. And if you would just respectfully use the words, did make any comment about the case before your verdict. Just leaves out their judgment about merits. They don't know if merits is a legal word.
I will take what you say into account, but I have already examined one juror using that term, and you now say that term confused the juror. You have that on the record, and certainly would be able to argue that to any of the appellate courts that review what I do here. But my intention is to use the language that I used with the juror I've already interviewed.
But Your Honor, you went and did a follow-up question, our request, which elaborated on what that meant. And certainly after you asked that question, we think that clarified it, and you could use merits or anything else about the case and deal with both issues. I just think it's going to require us, based on statements that these jurors have given to SLED, to ask very specific questions.
I understand what you're asking. Let me ask you this, Mr. Harpootlian. Do you happen to have the transcript of Friday's proceedings?
Okay, we have a good question here. What court is this judge? Thanks. This is I'm not sure exactly which court this is, where this court is located, but it's a different judge than the trial judge, because the trial judge is potentially a witness in the Becky Hill saga, because he was in the room when there was some issues about Becky Hill taking matters into her own hands. And so he essentially can't oversee this Becky Hill portion of the trial, because he's part of it. he was kind of part of it in this. But he's also said that he wasn't going to be doing other parts of the criminal aspects of the case. He wasn't going to be doing any of it. He recused himself from all of that. So all of this is being handled by a different judge. And this is our Judge Toll is her name. She's apparently like 80 years old. She was allegedly, from what people in chat are saying, which I didn't know, saying she was brought out of retirement for this. I don't know if that's true or not. That's just what people here in chat are saying. I know it's a different courtroom. This is a completely different courtroom, obviously. Tinfoil Hat says William Brown with the $5 super chat. A tinfoil hat. Her saying you can make the argument to a higher court makes you think she's already made up her mind. Well, about that issue. Anyways, like, if you have a problem with that issue, take it up with a higher court. Because each issue, each objection is a separate potential appeal. So, you know, if that issue, take it up with a higher court, is what she's saying if you disagree with me. I don't know if that's just what a few people in chat said that. I don't know if they were just making fun of her or she actually is being brought out. Okay, JKD Book says she was brought out of the Dark Ages. What are you talking about? She wasn't brought out of the Dark Ages. She just has kind of been around since then.
I don't think so.
State, do you all happen to have a transcript for Friday's proceedings?
Your Honor, we're looking right now.
Belay that. I've got a copy. Let me look at it for a minute to see what I did in clarification. And
well, that's interesting. I didn't hear that the first time around. You know, she said belay that. That makes me wonder if, like, back in the Dark Ages, if she wasn't like in the military in World War II or something around there. Yeah, belay that is something I've only heard people in the military ever say. I've never heard anyone that wasn't in the military say belay that. So that's it. Yeah, that's interesting.
So just pause for a minute. Let me look at that.
She was the Chief Justice of the South Carolina Supreme Court. Wow. All right. War of 1812. Again, as people that are just joining can see here from the scroll, this is we're on the lunch break. We're just going back and we're watching the first few questions, because I do have a few questions about the first two or three jurors that were questioned. Questions about questions of people being questioned. But we do have the ability to fast forward through these pauses.
Yes, Your Honor.
I look at this transcript, and the only thing I know.
Wait, there's
Hang
okay. Okay, these were the follow-up questions.
Okay, all right. I said this. I asked the attorneys for any further commentary about the questions I asked, and I have been asked to ask one more question, and I'm going to do that. I'm going to read you a memorandum by the state to counsel for the defense and then ask you about it, all right? And then here's what I read. Per Chief Attorney Waters, please be advised that the attorney for Juror X has told us that his client says that prior to the defendant's testimony, his client did hear Clerk Hill say words to the effect of, quote, looks like the defendant is going to testify. This is an important day, close quote. Or, quote, this is an epic day, close quote. And that there was some statement that it was rare for a defendant to testify. And then I said, Juror X, can you verify that what I've read is something you heard and told your attorney? And she says, yes, ma'am. Very good. Do these statements have any impact on your verdict? No, ma'am. Very good. I will ask that question. I didn't change well, I've read you what I asked. I will be glad to do that again.
Your Honor, different jurors say different things based on the memorandums we've received.
I won't say you told your attorney or anything like that, but I will ask about that statement having been made.
Your Honor, just for the record, we believe the term merits is a term of art, just as if you asked it was a probable cause. Again, or anything else, we're not asking you to open Pandora's box.
I hear what you say, and I will take it into account.
Okay, thank you, Your Honor.
Mr. Waters, anything on your behalf?
I do not have anything further, Your Honor. We believe the term is self-explanatory.
Thanks, sir.
Okay, well, we'll kind of pause that there for a quick second. The Judge Toll does have a Wikipedia page. So let me bring up Judge Toll's Wikipedia page, and we can learn a little bit more about her. How does that sound? All right. Let's share the screen. Uh, let's see. Before we get into this here, we do have William Brown. Okay, we read William Brown. Thank you so much for that super chat, William. We almost gave you two for William. Thank you. And Duncan Ida with a $5 super chat. Paralegal Liz seems pretty fun with her reaction to a random well-formed booty interface. She's single. Inquiring minds want to know. No, she's not. She is married. Sorry, Duncan. Tell your friend that she's not available. Degens. Okay, let's see here. Can we embiggen this? Let's embiggen Judge Toll here. Judge Toll was born August 11th, 1943, as a former Chief Justice of the Supreme Court of South Carolina. She was the first woman and the first Roman Catholic to serve as Chief Justice. Okay. In 2013, she became the first Chief Justice on the Supreme Court of South Carolina since the 1800s to run opposed in their reelection. Okay. That's interesting. That's interesting as well, that the first judge since the first Supreme Court judge or first Chief Justice of the Supreme Court to run opposed since the 1800s. Toll has continued to serve in the judiciary as a senior judge since her retirement from the Supreme Court. So she retired from the Supreme Court, but not from being a judge, right? That makes sense. John Hoffer was born on, okay, we already read that. The daughter of Herbert W. and Lila Farrell Hoffer. She married William Thomas Toll, and they have two children. She graduated from Agnes Scott College, University of South Carolina School of Law in 1968. See, you all call me an old fuck. You all call me an old son of a bitch. You all tell me I'm an ancient boomer. She graduated from law school the year before I was born. So there you go. She's been a lawyer longer than Yoel Lorax has been on planet Earth. That's a long time. Where she was a managing editor of the South Carolina Law Review. Ooh, she was a law reviewer. Her early career and tenure on the Supreme Court of South Carolina. When she graduated, she was one of 11 women in South Carolina actively practicing the law. That's actually a pretty damn good achievement. I mean, back when she graduated, there was 11 female lawyers in South Carolina. Dang. And now we have more women graduating from law school than men. You're our boomer, Jeff. Okay, and I'm not. Thanks. Yes, she is 80 years old. As a lawyer, she argued on behalf of the United States Supreme Court. She argued before the United States Supreme Court on behalf of the Catawba Nation. Okay, in 1975, she was elected to the South Carolina House, representing Richland County. So she's a politician as well as a Democrat. She was a state House representative for 13 years before being elected to the South Carolina Supreme Court in 1988 and sworn in on March 17th, 1988. The first woman elected to this position. She was re-elected over Tom Irvin in 1996. And Toll was elected Chief Justice in 2000. How old is Jeff? Jeff is 54. I'm 54. I am well in Gen X territory. Toll was elected Chief Justice in 2000 and served until December 31st, 2015, after reaching the mandatory retirement ages for judges in South Carolina. Okay, so she retires. All right. Here it says she retired from there, but she still served as a senior judge. All right, we'll see. We'll see how this all works out in the end. In 2013, she was first elected Chief Justice. We already read all that. Right? I hate Wikipedia. It's just so repetitive. After reaching the mandate, we already heard that in 2013, she was the first Chief Justice of the Supreme Court not to run opposed in the election since the 1800s. So that's totally contradictory what it says above. Or did I read it wrong above? Did I read that wrong above? Whatever. I don't care. It's Wikipedia. Wikipedia sucks. She took part in a number of landmark cases. In 2000, she chose to use the internet to organize court records instead of mainframe computers, a first in South Carolina. Oh, so see, she's on the cutting edge of technology back in 2000. She served as the president of the Conference of Chief Justices from 2007 to 2008, life after the Supreme Court of South Carolina. Toll oversaw the court cases involving Santee Cooper following the Nukegate scandal. Must mean something to people in South Carolina. Doesn't mean anything to me. She was required to sign off Santee Cooper's $520 million settlement with ratepayers. Yikes. She has also overseen all asbestos-related litigation in South Carolina since leaving the South Carolina Supreme Court. Wow, that's interesting. She hears all of the asbestos cases. I love judges that are super specialized in things. Like Utah, we have like water law wizards in Utah, where water law is a huge thing. She's the South Carolina asbestos judge. She's the subject of Madam Chief Justice, a collection of essays about Toll which span her career. December 2023, it was announced that Toll would take over all matters relating to the murder conviction of Alex Murdaugh. All right, well, there we go. That's what we know about her. Interesting. All right. Got a little bit of background on the judge. Rowan, no. The judge could be Pontius Pilate's wife. Come on, people. She's only 80. Dracula. No, she's only 80 years old. Be nice. Let's bring back up the core here. Where'd we go? The questioning of the jurors. Looks like we got about 30 more minutes before they start back in. And all right, let's bring up the screen at least. And currently, we've still got 812 of you sticking around. God bless you guys. Oh, 798. I lied. 798 of you sticking around. We're going to be going back live in about 30 minutes from now. 25, 30 minutes from now, we're going to be going back live. We got 810 likes. Wow, that is really good. Thank you so much, peeps. Appreciate the 810 likes. Let's keep the likes coming in. And if any of you haven't subscribed, I would appreciate it deeply if you would do the honor of subscribing to the channel. Do me that honor. I would be gratefully indebted to you forever, and I would be the best Law Rex that I could possibly be. I appreciate that. Costs nothing. It's nothing out of your pocket. It takes you it costs whatever micro amounts of energy required to scroll down and click the subscribe button. And if you are subscribed, please just look down there, double check, make sure you're still subscribed, because occasionally YouTube will just unsubscribe a bunch of people for no reason at all. It happened to a bunch of people last week. I get all the emails about that. Daily Quick Bites is correcting my pronunciation. It's jurors, not juror. You are corrected. It is jurors. I apologize. I've been saying jurors. It's jurors. I need to get that right. So like and subscribe. I would appreciate that. So let's check back in on the poll here real quick. We've reset the poll. Will Becky Hill's alleged shenanigans result in a new trial? Okay, we're still about where we were. We ended with 69% the last time we closed the poll. We started the poll during the questioning of the jurors. After the questioning of the jurors, we're still almost exactly the same. 60% yes, 32% no, and 8 hell no. All right. We'll continue checking on that and seeing how it goes as time goes on. All right, back to the replay. All right, let's get to something here. Sorry, that's not what I want to do. I want to do this.
I'll have to go to my screen to do this other, but the third question will read, did you hear Ms. Becky Hill make any comment about this case before the verdict?
Yes, Your Honor.
Okay, that's what I'll ask. All right. All right, Mr. Bailiff, bring me the jury.
Bring in the jury so we can hear her not tell them to not look at their phones.
Good morning, ladies and gentlemen of the State versus Murdaugh jury. I wanted to make a few opening remarks to you before I question each of you about the matter. You have done absolutely nothing wrong. None of you, not any of you. You didn't ask to serve, but you served and did your duty. This was an unusually difficult trial because of its length. 6 weeks is almost unheard of in South Carolina as the length of a case.
South Carolina.
It was difficult because of the intense publicity and public interest in the case. It was difficult because of the complexity of testimony and exhibits in the case.
Thank you so much for the spell check there,
And
Mary
you
Jane.
acquitted
You are
yourself
correct.
honorably. So this question today is not about anything you did wrong. Please be assured of that. I respect you and I respect your service. Today, I'm going to ask you to do something that's difficult. This case is unique. Most of the time, if there's some issue about improper conduct or contact with a juror, it comes up immediately. The judge puts questions to the juror and perhaps to the person who may have made a improper comment, and then you go on to verdict. Or sometimes it's very shortly after the verdict is rendered. And again, the judge questions the affected jurors and the supposed interference and makes a ruling right then and there on either a new trial or a mistrial. Now here, we are almost a year after your beginning of service.
Guess I can take that off now, huh? There we go.
And that makes it mighty difficult for you to do something I'm going to ask you to do, and it's this. Today, I ask you to focus your attention.
We've confused her with white noise. We're confused with white noise. What is that noise? Potentially criminal Sean. If you're free, if you're free to join, let me know. We'll shoot you the link.
What is that? What is that noise?
Man, I would have given anything for everybody in the courtroom to go, what noise? What noise? We're not hearing any noise. What noise, Judge?
Is that the sound system doing that?
I believe it's the court sound system.
This is the funkiest sound system in the world, so you just have to keep up with it.
It wasn't really that funny.
Now, as I was saying, I want you to focus your attention as you answer the questions I'm going to ask you on your 6 weeks of experience as a juror in this case.
Yeah, she needed to focus on her own damn questions.
On the point in the trial where the judge charged you, and on your verdict as you rendered it on March the 2nd, 2023. That's what I want the focus to be. Again, I know I'm asking a lot to have you cast yourself back into that time, but that's what the questions I'm asking are about that time and not about this time. There's been so much drama about this matter since the verdict was rendered, and my heart goes out to everyone, the lawyers and you who are in this
doctors
trial,
and lawyers and such.
That I can't help. But I've been asked by the Supreme Court to take a look at this issue. The appeal is on pause until I do, and I've got to do my duty as I see it. And you do yours as I know you see it. So I thank you very much in advance for, again, the terrible inconvenience of calling you all back together now. But it's very essential to completing the record about this case and placing it before the appellate authorities as it needs to be. So in advance, I thank you. What I'm going to do now is dismiss you to the jury room, and one by one, I will call you, and I will refer to you by a letter that I have just assigned you that isn't your jury number and certainly isn't your name. You know, these people in the media saw y'all all through the trial. They probably know who you are. But I'm trying to do my duty as I see it when I make your appearance here anonymous to the record. And only the clerk, the court reporter will have a sealed document by me indicating what the key means in terms of your juror number and your name. So I'm doing everything I can do about this matter. But But it goes without saying that your business is your own business. You don't have to interview with a soul, not lawyers, not media, not anyone after this matter. That choice is purely yours. And I will respect that and protect that to the best I can if anything comes up afterwards. All right, you may go to the jury room.
All right, let's do it.
Mr. Bailiff.
Bring Z.
Juror Z.
One other matter.
Yes.
One of the individuals sitting in the jury box and called this, the next jury, liar publicly, and asked that he.
Yeah. Get Bland out of there. Get Eric Bland out of there. This has actually been my favorite part of the day.
Jury box and called this, the next jury, liar publicly, and asked that that be Mr. Bland and his partner, cohort, not sit behind her or near her while she's testifying.
I
object.
Well,
yeah, we don't care if you object, Eric Bland. This is the absolute truth. Eric Bland called Juror Z a liar publicly, and now he wants to sit behind her, sit right next to her. That doesn't sound at all intimidating, does it? Yeah, you shouldn't be sitting right behind the person you called a liar.
Your Honor, I object to him speaking.
One moment.
And you can tell Harpootlian does not like Eric Bland. Stand in line. Stand in line for people that don't like Eric Bland. EB. I object to him talking. I love Dick Poon. We might not agree politically, but yeah, I like him. I like him as a lawyer. I object to Bland talking.
I object.
Well, just a minute.
Your Honor, I object to him speaking.
One moment. We're not going to have a big colloquy about this. Keep your seat for a moment, Mr. Harpootlian.
Colloquy.
And you do the same. Mr. Bender, is there a seat over next to you?
There is.
Mr. Bland, will you go over and sit next to Mr. Bender, please? Thank you.
Thank you, Your Honor.
That was absolutely the correct thing. Get Bland's ass out of there.
For the record, I have some people in the jury box. Two of them are SLED agents. One of them is the media consultant, and one of them is attorney for several of the jurors, Mr. Bland. And that's being done at my direction.
And Justice told you have Scott Mongillo playing Richter also in the jury box.
Very good. Yes, sir.
What is a colloquy? A colloquy is a loquacious discussion, an eloquent discussion. It's a palaver, if you will. It would have been cooler. It would have been cooler if she would have said palaver instead of colloquy, but we'll take colloquy. As long as you're using antiquated terms.
That's fine. All right. Bring me Juror Z.
World War Z. Bring on the zombies. Have fun, paralegal Liz. Looks like we got about 15 minutes before we start. Bring in jury Z. I got to bring up a separate window to make sure we don't miss the start of the court here. Hang on. Law and crime.
Juror Z, you may take the witness box after you are sworn. Step over here to the clerk and she will administer the oath.
Do you swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth, so help you God? I do.
No, we're still on lunch.
Juror Z, I will ask you some questions.
Well, as I love Eric Bland, so there, you're a totally defense-sided guy. Nah, I'm not a total defense-sided guy. I just don't like him. If he was on the defense, I wouldn't like him. It has nothing to do with what side he's on. I just don't like him. It's a thing. But hey, that's the great thing. We can all disagree. We can all have different opinions, but we can still like each other. You know, you're more than entitled to like him, and I'm entitled not to. Just my thing. I don't like. 10 Gauge Cheesehead, new member. The 10 Gauge Cheesehead. Thank you so much for being the newest member of the Legal Vices Clean and Sober crew. Thank you so much.
And there are no right or wrong answers. The truth is
Yeah, it's
what I
easier
seek,
that way.
and that is the truth of what you experienced in relation to these questions at the State versus Murdaugh trial. You rendered a verdict on March the 2nd, 2023. That verdict was read in open court by the foreperson of the jury. And then the court said this: Madam Forelady and members of the jury, if that is your verdict of each and every juror, let it be known by raising your hand. The transcript then indicates that the jurors complied. The jury was individually polled, and each was asked, was that your verdict? Each juror answered yes. Each juror was then asked, is that still your verdict? And each juror answered yes. Was that an accurate statement about your verdict at that time?
Yes, ma'am.
Right. Was your verdict based entirely on the testimony, evidence, and law presented to you in this case?
Yes, ma'am.
Did you hear Ms. Becky Hill make any comment about this case before your verdict?
Yes, ma'am.
If yes, what did Ms. Hill say?
To watch his actions.
To watch his actions. What else?
To watch him closely.
To watch him closely. Anything else you remember?
There is, but I can't remember.
Okay, that's fine. And
that's perfectly fine not to remember. So
was your verdict on March the 2nd, 2023, in any way with any influenced in any way with any communications by the clerk of court, Becky Hill, in this case?
Yes, ma'am. Yes, please.
See that, and that is a perfectly acceptable answer. The question is so broad. Was it in any way affected by what Becky Hill said? See, and now I'm even angrier about this, because she impeached her with her affidavit that says she was pressured by the jury. Well, that can still be in any way prejudiced by what Becky Hill said. The other jurors could have been subconsciously affected by what Becky Hill said, which also influenced her through their pressure, which would be in any way affected by Becky Hill. But also, she can be directly affected and influenced in any way by Becky Hill's statements and also be pressured by the jury. That really pisses me off that the judge ruled this way on this issue.
All right. Was your verdict influenced in any way by the communications of the clerk of court?
Exactly.
In this case?
Yes, ma'am.
And how was it influenced?
How was it influenced?
To me, it felt like she made it seem like he was already guilty.
All right, and I understand that, that's the tenor of the remarks she made.
No, that's
Did
how she was
affect
influenced.
Your
Yes.
finding of guilty in this case.
Yes, ma'am.
All right.
Jennifer Okotok says, shake your fist at the sky. It helps.
Be at ease.
It does.
Those are my questions are submitted to the juror. Are there any reactions, further questions, and so forth? If there are, and you would like to voice them, I can ask the juror to retire to the jury room. Just tell me whether I need to do that. All right, sir.
Your Honor, we asked the juror, we need to put some things on the record.
All right. Take the juror to the jury room, please.
All right, let's fast forward to the jury leaving. And we're about 10 minutes away from the start of court.
Mr. Waters.
Yes, ma'am. Your Honor, in the affidavit that was given by this particular juror.
No, the foreperson was the one that was questioned on Friday. This is just random juror Z. Juror X that was questioned on Friday was the foreperson.
Paragraph 10 said, I had questions about Mr. Murdaugh's guilt, but I voted guilty because I felt pressured by the other jurors. We would request an inquiry as to that, which is how, when this motion was filed, she expressed the basis for her verdict, which obviously this answer is a little different now. So we would request.
It's not a different answer, it's an additional answer.
Thank you, Your Honor.
Your Honor, as to two things. The first thing is, he is correct. She gave an affidavit. We would ask Your Honor to let her read her affidavit to refresh her memory of, she said other things. They're very detailed in here. We'd ask you to, and let me hand up to the court a copy of her affidavit and ask you to have her read it before.
See, he's not entering this into evidence. He is using this, he's trying to use this to refresh her memory, which is something that he should be allowed to do, and she should be allowed to look at that to refresh her memory about what was said earlier without introducing it into evidence. He's not trying to introduce it into evidence.
Waters, for the record.
I think this is wrong.
What I've been handed for the record is something, affidavit of juror, now referred to as Z. It was taken August the 14th, 2023. It was sworn before Holly Miller, paralegal for Mr. Harpootlian, and he would like for me to give that to the juror and ask her to read it and then ask her about it. I'm inclined to do that, but I want to hear from you first.
Your Honor, again, if they want to refresh the recollection, that's fine with the state, so we have no objection to that.
Very good. It will be done.
Your Honor, also we would ask that you not ask the question that that Mr. Waters asked you to ask, because it violates Rule 606B, which provides upon an inquiry into the validity of a verdict or indictment, a juror may not testify to the effect of anything upon that or any other juror's mind or emotions.
What was the question he asked?
If you look at that affidavit,
it's paragraph 10, Your Honor.
Paragraph 10.
It's in the very affidavit.
She said she was influenced. She was influenced by other jurors.
Yeah, okay. I'm gonna ask her about that. I'm gonna give her the affidavit and then I'm gonna question her about it.
And we would, for the record, indicate that we object to that under 606B.
Your Honor, from our perspective, she's put an
And
issue.
you're the one that asked me to have her look at this affidavit, but you're telling me I can't question about it. I deny that objection.
Your Honor, if it's something that's inadmissible, you should not ask her about it.
Well, you want me to admit it and have her examined on it.
I want you to have her read it to refresh her memory.
We're quibbling, Mr. Harper, we're quibbling about things that I'm not going to take time to quibble about. My ruling is pursuant to your request.
I was checking the volume when I was muted.
To examine her affidavit.
I was just ranting about how he was not trying to introduce this into evidence. He was trying to use it to refresh her memory, which can be done. It doesn't have to be entered into evidence. That's what I was ranting about while I was muted. While I was mooted. I can't even pronounce mute right.
And then I'm going to question her about it. That's my ruling. Your objection is overruled.
For the record, I just want to note, Your Honor, just for the record.
You noted 606. I hear you noted.
And in no way waiving anything or opening any door by asking you to let her examine.
That's for a higher court than me to decide.
And I don't know. This seems like there might be something here for a higher court to decide on this particular issue, because I don't think that was appropriate at all. I don't think that was appropriate at all for her to cross-examine or impeach the juror with an affidavit that he was not trying to enter into evidence as any proof that anything happened. It was simply to refresh her memory on what she previously said.
I understand that, and that's why I want to make sure when they read this transcript, there's no confusion. I'm not asking you to put that into evidence. I'm asking you to let the jury.
I don't see how in the world I can question the juror about something and not put it into evidence. You can't have your cake and eat it
question
too,
her
Mr.
about it.
Harpoon. You could have been very satisfied with the answers that were already given, but you have chosen to ask about this.
Request.
Denied.
Your Honor, all the time we ask witnesses to examine a prior statement.
Mr. Harpoon, I made my ruling. Please take your seat. All right, bring me Juror Z. Get me another copy.
It's in here.
Yeah.
It's in here.
Yeah.
All right, I'm watching the court feed. They're starting to assemble in the courtroom. So in another couple of minutes, we'll pop back over. And as soon as the court comes back, and hopefully I'll get back before Becky Hill does, I have to dash across the house and grab me some caffeine. All right, let's fast forward here.
Of course, is a statement that you are a juror in the case. Second paragraph says, toward the end of the trial after the President's Day break, but before Mr. Murdaugh testified,
looks like the judge is coming back. She hasn't sat down yet.
Told the jury, quote, not to be fooled, unquote, by the evidence presented by Mr. Murdaugh's attorneys.
All right, the judge is coming back here.
To mean that Mr. Murdaugh would lie when he testifies. Is that what your recollection is of that statement?
Yes, ma'am.
Is there anything in the statement that, on reflection, you think is not correct?
No, ma'am.
All right. Number 3, she also instructed the jury to, quote,
I hate to cut her off in the mid-sentence because this is that's what I wanted to hear. But the court is back.
Once he's seated, I have a matter I need to put on the record.
All right, sure.
All right, we are now live. I wonder what they want to put on the record.
Yes, sir.
Your Honor, we last week discussed the standard by which you would proceed during this proceeding and evaluate the evidence. We argued that you should use a case called Bremer. You rejected that. But under any standard, as I understand it, the burden of proof is on the defendant to show certain statements were made or certain conduct happened.
Yes.
So far, Your Honor has called as court witnesses 12 witnesses. We were not offered the opportunity to cross-examine them. And so we've not had the opportunity to present any evidence whatsoever. And before the state presents evidence, I believe that we should be able to call witnesses. And I would ask the court to allow us to present some evidence before the state comes up with rebuttal. And by the way, under the cases you cited, they have no affirmative obligation to present anything at this point. There's no requirement they present anything.
Good argument, Dick.
So I would ask you to allow us to call a witness or two.
Yes, we are
before
live.
you make a decision as to whether or not they need to call a witness.
State?
Your Honor, we obviously have argued very extensively some of the cases, and I think the South Carolina jurisprudence is very clear that while an evidentiary hearing is appropriate, and that's
I'll be
what
back
we're
as
doing
soon as
here,
possible. Give me a minute.
that manner of inquiry is purely within the discretion as the trial judge sees fit. This is not a criminal trial where we're here with the jury to present the normal criminal trial process. This is a inquiry that is very much directed by the trial court and what the trial court thinks is appropriate. And so the state certainly is comfortable with the inquiry the court is conducting. And my understanding is, as far as putting up Ms. Hill, this is the manner in which the court wanted that evidence presented. And so we're happy to comply in that regard. But we think that this inquiry is within your discretion, and we have no issue with the manner in which Your Honor's proposed to conduct it.
Please, the court, Your Honor. Certainly, the conduct of this hearing is within your discretion. What is not is who has the burden of proof. We do. And we can't meet that burden if we can't call witnesses. And so I'd ask the court to allow us to call witnesses. And if at the conclusion of us presenting those, you believe the state is required to present evidence to contradict that evidence, or in some way, I'm not quite sure, since Remmer is not the standard, I'm not quite sure what they have to prove, but that's an argument down the line. I believe we ought to be able to call witnesses now, and we have witnesses which would substantiate the burden we have to show you that statements were made by the clerk of court, and that those statements had impact on a juror or jurors.
All right. I've got a couple of reactions to that. Number one, the pretrial was the time to figure out exactly what we were going to do here. And I think it comes at the last minute for you to now come and say, we want to present witnesses. You briefed the matter of witnesses. We had a long pretrial. After I made my rulings on what I thought the scenario was that should be used based on State versus Green, you lodged objections to that, but you did not offer at that time any information about who you wanted to call, other than this lengthy filing in one of your briefs. It comes pretty late in time for, in my view, for you to do that now. Second thing is, I gave the defense a big break when I allowed you to be the cross-examiner and the state to be the presenter of Becky Hill. She's really a witness that each side needs to prove their view of what happened in this matter. The state puts her up to try to show that there was no impact by anything she said, and that some of the things your witnesses say were said, she says were not. So there's a conflict in the evidence there. I'm not going to rearrange the situation and go to any witnesses of yours right now. I'm going to see what Ms. Hill has to say. And then afterwards, we can talk about whether there's any need for any other witnesses.
Your Honor, just factually argue this with you. We did not understand. We assumed you'd adopt Remmer because that was.
Well, I don't know why you assumed that, when
because
the South Carolina Supreme Court said very clearly that we do not go by the guidance of the 1950s case of U.S. v. Remmer.
We do not believe that's what Justice Kittredge has said in.
They said it straight out, as clear as a bell can be, but I've ruled on that.
Yes, ma'am.
And,
All I'm saying is,
and the South Carolina Supreme Court's going to have plenty of chances to decide that they want to modify green.
well, when we were somewhat taken aback by a ruling as a result, and that ruling came at a point where we didn't know what these witnesses were going to testify to. So we now, and by the way, you've set aside 3 days for this. What's the hurry? This gentleman is facing life with no parole. We should take this in a very deliberate way. He's got a 14th Amendment right to ensure that he had a fair trial.
All these arguments should have been made before this time,
Why?
Mr. Mark. Well, Mr. Harcourt, I've told you how I'm going to handle this thing. Your objections are noted and they're on the record. But right now, what I'm going to do,
there's going to be some appeals on this.
We're going to call Ms. Hill and see what she has to say. I have no idea who all you want to call as witnesses or whether they're here in the courtroom at the present time. But we'll get to that after Ms. Hill testifies.
Yes, Your Honor.
All right.
Just
Yep.
your attention on this email.
There's going to be some appeals on this. Huh. All right.
Go to a little something here that
Her voice is not
getting an
deeper
email
than
on,
Jeff's.
and put this on the record right now. I have a communication from Mr. McCullough
The 19 today.
that's only that is copied to Mr. Harpootlian, Mr. Griffin, Mr. Waters, and Attorney General Wilson. And basically says his client, Juror Z, wants to enhance the testimony she gave with some sort of affidavit that he wants me to look at, and I have looked at. I want to hear from the state and the defense, but I can tell you, I'm not inclined to get back into the testimony that's already been taken by these jurors.
Juror Z is a special case.
Whatever they are in the record.
Juror Z is a special case because
another bite at the apple.
you forced her to choose between whether she told the truth in the affidavit or told the truth during trial when they could both be true.
The court conducted the inquiry that needed to be conducted. She answered the questions. I would agree with Your Honor that multiple bites at the apple are not warranted. So we believe we should proceed forward as the court.
If you can take 2 bites from the apple, you take it.
Mr. Harpootlian?
Your Honor, I note 2 things. The first thing is we asked to be able to examine this juror. You denied that request.
You
Number
need
2,
clarity on this issue.
she's not our witness. She's not Mr. Waters' witness. She was the court's witness and a juror that, and you commended all of them on their honesty. She's attempting to be honest. This process we're going through is an effort to seek the truth. This is the truth. I don't understand why it can't come in.
I think I understand what your position is, Mr.
So we'd ask you to make it a part of the record. You can say you're going to consider it. You're not going to consider it, but it should be a part of the record.
Well, I'll give some thought to whether this thing should be a part of the record, but I can tell you this. Witnesses don't get to get on the stand and testify under oath and then seek to add or change or.
You asked an inappropriate question, Judge.
Very open-ended questions that asked for her responses, and she gave them. If they're inconsistent, she can't come up now and try to close the loop of consistency by some additional testimony. I am not thinking about allowing that to be done.
With all due respect, Your Honor, we believe, we said at the time, the way you questioned her put her in a position of saying, yes, that was my verdict then. We think, and we couldn't examine her, and Your Honor, To say now that this affidavit doesn't accurately depict her position is to deny fact, the truth.
You've already said that once. I know your position on that matter, but I decline to adopt it. All right.
We'd make this an exhibit as a proffer for our case. This affidavit, we proffer it for our case. We have the burden.
I'll give some thought to it. I'm not ready to deal with that right now. I have looked at it just in the moment right before I put it
Dick
on
is
the record.
100% in the right
Research
here,
about
as far
that,
as I'm
and
concerned.
We'll close that loop before the end of the day.
Your Honor, again, I indicate we have 2 more days. We don't have to wrap everything up today. Thank you.
Yes, sir. All right. Mr. Waters.
Thank you, Your Honor. The state calls Rebecca Hill.
Let's go, Becky. I really hate that. I really hate what she said there. I didn't like the way she questioned during the Juror Z's questioning. I don't like what she said here. I think she's a good judge in that she makes decisions. She doesn't defer till later to make up her mind on objections and how she's going to handle shit. I just think she's horribly wrong with this decision she's made. I honestly don't think she's paying attention to what Dick Harpootlian is saying. Because if she's listening to him and comprehending what he's asking, I don't know how she can reject it. These are not mutually exclusive or inconsistent statements. That she was influenced by Becky Hill and she was influenced by other jurors. Frustrating.
Do you swear or affirm that the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good afternoon, Ms. Hill. How are you?
I'm fine.
I want to get started, if you would. If you could state your full name for the record and spell it for the court reporter, please.
My name is Becky Hill, last name Hill, Hill.
Is your real name Becky or is it Rebecca?
And if you would, just give us, you're currently the clerk of court for Colleton County, is that correct?
That's correct.
And just very quickly, if you would, what year were you elected as clerk?
Flux says Becky's a hoe name.
At the end of 2020.
Why are you smiling?
And prior to that, did you have any involvement or experience with the state judicial system?
I did.
And could you tell the court what that was, please?
I was a South Carolina official court reporter for about 14 years.
All right. And were you, in being an official court reporter, you would serve in the courtroom, which is Ms. Harris is here today, is that correct?
That's
what
correct.
Was your, and was that primarily in the 14th Circuit?
It was primarily in the 14th Circuit. However, I did travel throughout the state.
It's an elected position.
Did you have any other experience in professional experience prior to becoming a court reporter or clerk of court?
I was a court reporter freelance for 2 years before that.
Okay. And then any other professional pursuits you've had over the course of your career?
I was able to be a middle school teacher, and I worked for the Board of Disabilities for a few years as well.
Let me go ahead and just kind of get straight to it. In your capacity as clerk of court and in your previous experience being a court reporter, were you familiar with the rules that apply to court staff as it comes to interactions with jurors in the course of a criminal trial or a civil trial?
She looks like the woman who tried to rule Hogwarts the Iron.
And could you tell the court generally what those rules are as far as what contact is permissible and what contact is not permissible, just very quickly?
The judge gives the law and gives the instructions for a jury, and the attorneys will state their opening argument, their opening statements, their closing arguments, and basically the clerk of court and anyone else, court reporter, we're there to, my understanding would be to make sure that everyone's taken care of. Do you need some Kleenex? Do you need some water? Different things like that, just to make sure that they're.
Do you need to change your verdict? Do you need to find him guilty?
Clerks of court to have interaction with jurors during the course of a trial to see to those various logistical needs that you just described?
Yes,
And did that happen in the Murdaugh case?
it did.
And can you give us an example of some of the logistical things that you, or other things that you would see to deal with any needs that the jurors may have? I mean, did you provide them food, coffee, make sure they were comfortable, things like that?
Yes, all of that.
Provide blankets for them if they were cold?
Our courtroom was very cold in Colleton County, yes.
Yes.
Did you provide them with aspirin or Tylenol if they needed, make sure coffee and snacks were available?
Yes.
Chat makes me laugh.
Did you take lunch orders for them so that they were fed each day?
Yes.
Right.
At any time, did you
don't make me laugh when I'm
interact
inhaling a
with
cigar?
any juror
God.
in an attempt to influence their view of the facts in the State v. Murdaugh case?
No.
Liar.
All right. Now I want to ask you some specifics about that and some allegations that have been raised. At any time, did you tell the jury not to be fooled by evidence presented by Mr. Murdaugh's attorneys?
I did not.
At any time, did you instruct the jury to watch him closely and look at his actions?
I did not.
At any time, did you instruct the jury or tell the jury to look at his movements?
No.
At any time, as the jury moved to deliberate, did you tell the jury this shouldn't take long?
No.
At any time, did you tell the jury that the defense case, watch out for the defense case, they're going to try to throw you off, or anything along those lines that was meant to influence the jurors against Mr. Murdaugh?
No.
Well, somebody's lying here. Becky's lying or the juror's lying?
Let me ask you.
Under oath. Both of them are under oath.
Made any
One of them's
comment
lying.
to the jurors about the fact that the defendant was going to testify? Did you have a conversation in the presence of the jurors prior to the defendant testifying about the fact that he was about to testify?
It wasn't directly related to the jurors. I was talking to Mr. Bill, who was our bailiff foreman, our bailiff over the jury, and I was talking to him about that.
All right. And what did you say?
I told him what I had just come from downstairs telling my security and bailiff office, that Judge Newman had allowed more testimony in regarding the financials, and that also the defendant had decided that he may testify.
All right. And where were the jurors at the point that that conversation occurred?
There were a few jurors standing in line, and there were some in the bathroom, I'm sure, because they said they were waiting on jurors to get out of the bathroom. And there were some in the jury room just milling around from what I could see, looking down the hallway.
And again, what were the words that you said during that conversation? What were the effect of them?
To Mr. Bill.
Yeah. And what did you say?
I told him that that Judge Newman was allowing more of the financial evidence in, which would prolong the testimony in the trial a little bit, and also that the defendant had decided that he was going to testify.
Did you say anything about this being an important day? Pay attention. We'll get coffee for you. Things like that during that?
I usually give a little pep talk to the jurors. It's sometimes hard sitting a long time, but my usual, and I do remember saying, pay attention. It's a big day today. Whatever you need, let Mr. Bill know, or one of the other bailiffs, and they'll be glad to get it for you.
Okay, she
Did your
shouldn't be
comments,
saying,
or were your comments
"Pay
in any way
attention, it's an
phrased in
important day."
favor of one side or against another side, or were they more of a neutral comment about paying attention?
No.
She shouldn't
was
be
not
telling jurors
for
to
one
pay
side or
attention.
the other.
That's an admission. She's telling him to pay attention. Today is a special day for some reason. It's more special than other days, and to pay attention. I think she just admitted right there. That's enough for me right there. She told the jurors to pay attention. It's a special day. She should not have said that. Oh no, Mr. Bill.
Were you
You're old.
present when the jury went to the Moselle property to conduct the jury view?
I was.
All right. And was Judge Newman there as well?
He was.
During the time that you were on the property, traveling there, traveling back, did you have any conversation with the jurors where you made any comment about the substance of any testimony or any comment about the merits or the strength of the case?
No, no.
Did you have a quick comment to the forelady about how the property was beautiful and there were tea olive trees there that bloom and smell good, or words to that effect?
I did.
All right. And was there any other conversation related that you had where you made any comment about the case or the merits or anything like that?
Oh, no, no.
During the course of this trial, did you have a bailiff employee whose primary job it was to see to the jury and their security and keep them separate from everyone else that was involved in this trial?
I did.
And who was that?
Mr. Bill Polk.
All right. And he was ultimately the jury coordinator in this particular case?
That's correct.
During the course of the deliberations, once the jury went back there, did you have any contact with the juries or have any substantive discussion with them?
Not at all.
Did you have any discussion with them about logistics, about staying in a hotel or anything like that?
I did not.
Did you have any interaction with the jurors or anything to do with them having smoke breaks or anything like that?
I did not.
Yes, Poot gets to cross-examine this, so, and it's going to be good, I hope.
During the course of the trial, did you have any discussion or interaction with the jurors about them giving any interviews to the media or making themselves available to the media? I'm asking during the course of the trial.
No, not during the course of the trial.
After the verdict had been reached and the case was in sentencing, did you have any conversation with any jurors at that time after they had already entered their verdict and been individually polled?
Yes, after the sentencing.
All right, and tell the court what that interaction was at that time.
There were several outlets, news outlets, that wanted to interview the jury as a whole and really wanted to get them up to New York. And so I was trying to get a hold of all the jurors to talk about that. That was something we had not prepared for.
Did you at all pressure the jurors to speak, or did you just tell them that it was their option to speak or not, and here's the contact information?
I did not pressure the jury to speak. No.
Did you advise them that it was their decision and their decision alone whether or not they wish to speak to the media?
It was totally their decision.
And did you advise them?
If this was after everything, then why were some of the jurors wearing suits the last day? Anyway, just listen. Shut up, Larax, and listen.
Ask it again, but I just want to be sure. At any time, did you make any comment to any juror or in the presence of any juror in which you at all tried to influence them in favor of one side or against another?
I did not.
Did you understand, being a longtime court employee and clerk of court, that is outside the boundaries of what is appropriate interactions with the jurors during the course of the trial?
Absolutely.
And at any time did you violate?
No, it's not, Christina. That's the problem.
I did not.
Christine, it is absolutely not her job to arrange for media interviews. That was quick. All right. I hope Dick Poon eviscerates her on cross-X.
Nothing further this time, Your Honor.
Please, court, Your Honor.
Mr. Harpootlian, on cross-examination.
Yeah, looks like Poon, not Jim, is doing the cross-X. Let's go, Dick Poon, Mocha Dick Poon.
Ms. Hill, we spent 6 weeks together, didn't we?
We did.
And during those 6 weeks, you were as helpful to me as you could be, correct?
I was.
Accommodated just about every request I made.
Yes, sir.
Wait.
I got more white noise. Court white noise is acting up again. Well, His name is Dick Harpootlian, but we just call him Dick Poon. Flux gave him that nickname, Dick Poon. Yeah, her smile's gone. Poon's going, I want the truth.
Where were we?
That'd be funny if she did.
We're old
You
friends.
can't handle the truth.
Heard, that was the microphone that was supposed to, you're fine where you are. Absolutely fine.
Well, she's doing that. Jonathan Drennan of the $5 super chat said, so she's too old to be on the South Carolina Supreme Court, but she can make bad rulings at lower courts, and that's okay. South Carolina local government corrupt AF. Right.
Yeah, that would be good.
And 10 gauge cheesehead, glad I finally caught a live. Few hours personal driving time today. Usually listen to Maritime Monday and Trials. Great work. Free Zechariah Anderson. Thank you so much for your super
I
chat.
assume they can hear us. Court reporter, I'm sorry. She's more important, not as important as you.
Yes, I agree.
She's more important than you.
Oh yeah, we're old friends, right?
Well, he's doing this
We
one
spent
last
6 weeks together.
Island. One last thing here. Ask if she has a generational
Pressure-filled
feud with the
situation,
Murdaughs.
correct?
That's a thing.
It's a long 6 weeks.
Right, there we go. Thank you so much, Eileen.
6 weeks. And during those 6 weeks, you were helpful to me in a number of different ways. Accommodating friends that I had that wanted to come watch the trial, for instance. Correct?
That's correct.
You even allowed me to use the private restroom down on the first floor, so I didn't have to stand in line with the
riffraff
rest of the people.
with the riffraff.
Trying
Is
to
that
get breaks? Correct.
You wanted to say riffraff, didn't you? Dave?
So we have no animosity towards each other. You didn't do something to me, and I didn't do something to you during that trial, right?
Absolutely.
Okay. Now, given that, I'm going to ask you some questions today that may indicate to you that I have some antagonism towards you. Let me disabuse you of that. I'm here doing a job representing my client, and you've been around the court system for decades, correct?
Yes, sir.
So you understand what we're doing here today.
Yes.
Now, let me understand a couple of things. I think, and I've read your book, some editions of your book. There's several. We got a bunch of emails in which you have drafts that you forwarded to your co-author, correct?
Correct. Objection. I believe I would object to relevance. I believe any draft she sent to her co-author with the book is beyond the scope of this inquiry here.
No, it isn't.
Overruled.
Yeah, sit your ass down, Creighton.
And in those drafts, you say certain things about the trial, about the process, which you later did not include in the final version. It's called editing. Is that correct?
Yes.
I would agree with that.
Okay.
Well, thank you.
Let's talk about this book for just a second. When did you first decide you were going to write a book?
I think a thought was there, a very fleeting thought before the trial.
Did you take any steps before the trial or at the initiation of the trial to begin writing this book or working with somebody on this book?
Oh, no, sir.
When did you and your co-author get together?
It was several weeks after the trial.
Okay. Did you talk to anybody about the fact you were going to write a book before the trial?
There were several anchors and several journalists that I did speak with about the possibility of writing a book.
Oh, that sounds more than a fleeting thought.
I'm so disorganized. I apologize.
Oh, Dick, don't do that.
Did you seek assistance in this trial from other clerks of court?
Yes, sir, I did.
And who were they?
Rhonda McElveen, who is the Barnwell County Clerk of Court, and Renee Elvis from the Horry County Clerk of Court.
And were they there with you the entire 6 weeks?
No.
I mean, how long were they there? How often were they there?
Rhonda McElveen was there as often as she could be, probably several times a
So
week.
Rhonda helped her. Help me, Rhonda.
Renee
help me,
Elvis
Rhonda.
helped me during
Help
the
me,
jury
Rhonda,
selection.
Get her out of my heart. Sorry. Help me, Rhonda. Oh, David, great minds think alike. Sorry, that was just in my head. Great minds.
And did she begin, that is, Ms. McElveen, did she begin working with you prior to jury selection?
Can you repeat that question?
We began jury selection, I think, on January 23rd, correct?
Correct.
Was she working with you or consulting with you prior to the 23rd?
No, sir.
Did you have any conversation with her about the trial?
Not until she got to the trial on what, I can't remember the exact day she came.
Okay.
Phrasing.
Now, is she a friend of yours?
She was a friend, yes.
Was?
Well, she is a friend.
Okay.
Yes.
So she's done nothing to make you any less a friend?
No, sir.
Now,
I do. I feel better. Thank you, Dana.
did you tell her about the time of the trial that you were going to write a book? That you had thought about and were going to write a book?
I can't remember exactly.
Oh.
I think we did have a conversation about a book possibly in the future.
In the future. Oh, yes, of course.
And did you tell her you're going to write a book because you thought it would make a lot of money?
Oh, no, sir.
You never said that.
No, sir.
And did you tell her that you were going to write a book to make a bunch of money so you could buy a lake lot and build a house on it?
No, sir.
Okay. Now, did you ever tell her that you had given a juror a ride home, that you had accompanied Mr. Bill, what's his last name?
Bill Polk.
You're right. That you and he took a juror home one night? Did you tell her that? Did you take a juror home?
Yes or no?
I didn't take a juror home one night.
Did
No,
Mr.
sir.
Polk and you take a juror home one night?
No, sir. We did.
You never gave a juror a ride in a car with Mr. Polk or without?
No, sir.
Oh, I bet he's got evidence they did.
Now, also, during the trial, your daughter ended up on the Venari, is that right?
She did.
On the what?
And she was coming up, and did you talk to me and Mr. Waters about putting her on the jury if at all possible?
I'm not sure that we wanted her to be on the jury if at all possible, but I think the question was, would she make a good juror? And I said she sure would.
Now, I don't think we asked you. I think you told us she would make a great juror, did you not?
I remember you asking.
Okay.
Uh,
I was considering putting your daughter on the jury.
Yes, sir.
And who does she work for?
Her daughter
She
got
works
called
for
as a juror?
Compass South.
Did she
That's
work for
some
the
shit
sheriff's
right
department
there.
at some point?
No, sir.
Okay. Did she work in law enforcement at all?
No, sir.
Okay. Now, let me
That's the
ask you
question I
this.
have right there.
How many jury rooms were there?
We have 2 jury rooms in Colleton.
In this trial, how many jury rooms did you have? How many?
2.
Okay, so the entire jury wasn't together at any one time? They were separated into 2 rooms?
Yes.
Okay. And when they're separated into 2 jury rooms like that, are they next door to each other? Are they down the hall from each other?
They are next door to each other.
Okay, so but if you close the door to one, can they hear what's going on in the other one?
Some women probably have very good hearing, and men too.
What?
But I would say probably not.
What shit kind of answer
Are
is
there
that?
restrooms in both of the jury's rooms?
There are.
Okay. Are there 2 restrooms or just one?
Women
There's
have
one
good
restroom
hearing?
in each jury room.
Okay. Were either one of those restrooms designated men and women, or did everybody use the same one?
They were unisex.
They were unisex. Okay. Now, prior to your testimony here today, have you met with the Attorney General's office in SLED?
I have.
On how many occasions?
A lot, because
I'd
I'm
say
being
twice.
investigated by them.
And remember when the first time was?
I think the first time was in September.
Okay. And the second time was last week?
Yes, sir.
And that was in Walterboro?
Yes, right.
And y'all spent about 4.5 hours together?
I'm going to say maybe 2 hours together.
Okay. And in those 2 hours, you went over your testimony here today?
They asked me questions
Did they ever correct your answers or suggest you answer differently?
Oh, no.
No. So you just went through what you went through in 20 minutes here. It took 2 hours to go through when you were with that.
There were times when I would step out of the room and come back in. But I would say we were there for about 2 hours.
Now, you have described in your book your role as Switzerland. Is that correct?
Correct.
Okay. And that is that you should not be in any way opinionated about what's going on in the trial. Is that correct?
That's true.
Okay. Yet in your book, you indicated a number of different points during the trial you had concluded he was guilty. Is that correct?
I think.
Your Honor, I object at this point. I don't know if her conclusions in the book are in any way relevant to what occurred during the trial and whether
Yes,
or
they
not
are
there was
relevant.
any communications with the jurors, which is the sole issue that we're here for today. is
No,
whether
they're
or not,
relevant. Shut up.
Ms. Hill had any extraneous influence on the jurors. And so I think this is going a little far afield. We object to the relevance, Your Honor.
Overruled.
Let me give you an example. You indicate riding back from Moselle that you and 3 other people were in a car and you all decided adamantly, I think was the word you used, that he was guilty, that he had killed his wife and son. Is that what you put in the book?
Yep.
I can't remember if I put that in the book.
Oh, you
but if
lying
say I
sack of
did,
shit.
then I will
Did
agree
that
with
happen?
you. We did have a conversation
You
about
lying sack
what
of
each of us
shit.
thought.
You know
And
it's
all
in your
4
book.
agreed that he was guilty, correct?
And none of us were jurors.
Doesn't matter.
Trust me, I know that. But you had an abiding conviction, at least by the time of the Moselle visit, that he was guilty. And the other people in the car with you were bailiffs, were they not?
No.
Who were they?
Some were not bailiffs. One was a court reporter. One was our security officer, head security, and another was a deputy sheriff.
Settle down, says
But the 4 of
Goldenrod.
y'all rode out there, and based on what, and I mean, I can, you want me to read to you how chilled you were and how you felt that poor Paul and Maggie had been executed by him on that scene, that visiting the scene convinced you that he was a horrible, horrible murderer? You want me to read that to you? Or you
Yeah, read it
concede
to
that's
us.
what you wrote?
I will concede that's what I wrote, but if I may, I would
not.
say that a lot of that is poetic license in writing
Poetic
a book
license?
and in making it sound like that.
So you're a
Some of
liar.
it's poetic license.
So you're a
And Some
liar.
of it you just stole. You purloined it from that BBC writer, right?
Again, I object to.
No,
not only the
she
relevance
opened the
of
fucking door.
Cross, I would object also under Rule 608. I don't believe that's appropriate cross-examination.
She opened the door.
You may continue, Mr. Harpootlian.
Did you steal part of the book?
I did plagiarize,
Okay,
Mr. Hartfield.
that's stealing, isn't it?
And it is, and for
Okay.
that, I'm very sorry, and I have apologized.
Okay.
Boom.
That makes it okay?
What I did, and I apologized for that.
And part of the book is, you say, literary license, exaggeration.
Lies?
I wouldn't call it exaggeration.
You said poetic license. It's the truth,
let
or
me
it's
ask you, this
poetic
is
license, which
Switzerland.
is a lie.
And this is, you're saying this is happening while you're supposed to be Switzerland. You decided the defendant's guilty. And if Ms. McElmeen says that it's going to make you more money if he's found guilty, don't you think it's reasonable to assume that you may have crossed the line from time to time?
Your Honor, I object to the form of the question, assuming facts not in evidence.
Overruled.
Can you
Overruled.
repeat that question one more time,
I'm
Mr.
not going to repeat
Hartfield?
it. Let me just move on to something else.
I made
let me
my
ask
point.
you,
Let's move on.
You had interactions with some jurors, and I believe in a
To be Flair,
conference in judges'
spot
chambers,
on.
you indicated that you had seen a
Spot on.
post on, was it Walterboro Word of Mouth?
Yeah.
Your Honor, again, I object. I think he's delving now into the Facebook inquiry.
No, it goes to her credibility, her bias, which she
I
then.
will allow limited, he's, as I understand it, trying to impeach her testimony.
Exactly.
And,
He's trying to show that she was biased. She made up her mind, and
explore
then
her
she
credibility.
projected
And,
that bias to the
I think
jury.
I've already told Mr. Harpootlian that I don't want a whole trial about the business of Facebook and the egg juror, but I will allow limited examination on this point. You may proceed, Mr. Harcourt.
Am I oversimplifying that? I mean, it's in your book. You saw something on Walterboro word of mouth, which appeared to you to be from the ex-husband of one of your jurors. Is that correct? Am I oversimplifying that?
I remember reading one night something on Walterboro word of mouth. And when I was in the courtroom on a Monday morning, listening to the judge and the attorneys talking about a matter, it sounded like it was relevant to each other.
It wasn't though, was it?
And you became aware somehow that this juror had a restraining order out for her ex-husband?
She told me that herself.
Okay. And tell me how it came for her to tell you about that. Where did she tell you?
She was very talkative. And when I was instructed by Judge Newman to go and get her from out of the jury room with a deputy following me, she was talking to me all the way back to the judge's chambers. And she mentioned that there were restraining orders out when they had divorced.
So how did the judge, who brought it to the judge's attention about this Walterboro word of mouth thing?
I let the judge know, thinking that it could be related.
Okay, and you let the judge know what?
That I had read something on Walterboro word of mouth.
Okay, and that you knew it was tied to that juror?
I didn't know that it was. I wasn't sure at all.
Who do you think it was tied to?
From what y'all were talking about at the bench, I felt like I needed to let him know, just in case it was related. There was something about an ex-husband and an ex-wife and somebody being on the jury.
You didn't tell the judge that you had found what we call the apology post?
Holy
you didn't
shit.
tell the judge that?
I didn't call it that, no.
You don't remember producing it, saying that producing it to the judge, saying this is a post in which the guy that posted it on Friday night says the devil got in him and drinking and he apologized for what he posted. You didn't produce that?
My staff did. One of my staff.
That's you.
Gave that to the judge and gave it to us, did you not?
Yes, we did.
As
That's
if it
you,
were
sweet
from
baby Jesus, you liar.
that juror's ex-husband,
Sweet
correct?
baby dumpster Jesus.
Correct.
And you know it wasn't?
I don't know that, Mr. Hart-Julian. No.
So, and this, you did not take that juror out and talk to her before you took her to the judge? Is that
I never talked to that juror about stuff like that.
Okay. Did you ever talk to the forelady of the jury, separate from the
In
jury?
the bathroom.
I did.
Okay. And tell us, where did that occur?
Yeah, drink that water and think long and hard.
When I would go into the jury room and I would speak with the forelady, we would be in like the hallway in the two jury rooms were side by side, and the opening to the jury room went out into the hallway, and we would be surrounded by the jurors at all times. Mr. Bill would be very nearby, or another bailiff as well, when we would speak.
And what did you speak to her about?
There were several instances. One was there was a juror who needed some feminine products. There was another time when Band-Aids were needed. There were times when Tylenol would be needed.
Other than items that were needed by the jury's health object, did you ever discuss, did she ever discuss with you, if some issues jurors had emotionally or some issues with dissension in the jury room?
She only told me that there were some loud jurors, and it made some of the other jurors a little upset.
Why are
But
you
other than
having
that,
this conversation with
what
her
did you tell her to
anyway?
do?
I told her if it got out of hand to write a note to the judge, and that she could sign the note and get Mr. Bill to give it to the judge, and the judge would handle that for her.
Okay. Now, you did publish a book after this trial, is that correct?
We did.
And you went to New York and took some of the jurors to the Today Show.
And they brought us
The Today Show did invite us.
black,
Now,
big
one
black
of those jurors
SUVs, and they
that
gave
went
us
up there with you
pizza.
the day of the verdict, wore, for the first time I can remember, wore a suit to court. Do you remember that?
Your Honor, again, I would object to
Nope.
discussion of the jurors wearing a suit or
Nope.
a post-trial trip.
That goes to whether she, because the allegations were that she talked to them before, gave them business cards of media people and said they wanted to talk to them before trial ended.
All right, overruled. You may continue, Mr. Albuquerque.
Shut up.
Did you
Creighton.
text, email, or communicate on the morning before final arguments were completed that to people that this was on a Thursday, that they probably, if they're going to see the trial, should come on that Thursday because it'd be over by the next day. It would be, the jury would not be out very long. Did you ever communicate that? Email, text, or verbally?
Fellow
I do
old
remember saying that.
Divins bringing
Yes.
the Mr.
And why did
Sluggo
you
blast.
think
Nice.
The jury would not be out very long. Had you communicated with jurors?
I had not communicated with jurors about anything related to this trial at all. I've been a court reporter for at least 14 years. I was clerk of court for 3. And you just get to where you kind of see things happen as they progress. And it's a guess. It's a gut feeling. And that's all that I meant by that.
Well, why are you telling this young man who wanted passes for the next day in an email, it won't be happening tomorrow? That was or did you say, you didn't say, I don't think, you just said, you better come today if you're coming. Remember doing that?
I don't remember that. But, if he wanted to come, I knew that the trial would be ending shortly as far as testimony. So if he wanted to come, he needed to come.
Why wouldn't the jury have been out a week on a 6-week trial?
They could have.
But
They could have.
you apparently were telling the press and others that there'd be a quick verdict. Were you not?
That was just a gut feeling that I had.
But you told them
and that was my opinion.
Your opinion, you were right. Jury was out 3 hours on a 6-week trial, correct?
Oh my God.
That's true.
How much money did you make off that book?
Oh my God. You were right.
There was not a whole lot of money made off of the book after paying different things and paying for some expenses that went along with that. But I want to say roughly around $100,000.
Okay. That's not a lot of money.
No, especially when you publish your own book.
But that was $100,000 you made.
With my co-author.
Okay.
Didn't he say in an interview that they lost money on it?
I would say 6 months, yes.
When was the book published?
August 1st.
Okay. Trial was over. That's 6 months after the trial's over, you've published a book, correct?
Correct.
And then I believe you've recently stopped selling the book because of the plagiarism you've admitted to, correct?
Correct.
And so there's no more money?
Ain't no more money. It's off the table.
Now, you also indicate in the book that the Murdaughs had a reputation of criminality, I think is kindly what you put.
So does Becky Hill now.
Mr. Hartpooley and my grandfather and Old Man Buster were very close.
Well, were they criminals?
I wouldn't know.
You wouldn't know, but you believed and you published that the Murdaugh family had run that part of the state and they'd been participated in criminal conduct, correct?
Your Honor, again, I would object to general testimony about the alleged criminality of this family. I'm not sure how that has any bearing on the focused inquiry.
She's a generational criminal.
I was asking about what she said in the book. I'm going to allow it.
Yes, sir. Did you say that in the book, that they were criminals?
In the book, that was more of the literary ease that we take, I think, to make a story a little more interesting.
Hey, Steve. How you doing?
Calling people criminals. I guess what I'm saying is this.
Bitch.
Were they criminals?
Your Honor, again, I object to that particular question.
Overruled.
Were they criminals?
I wouldn't know that.
Okay, so
You said
either
they
made
were.
it up or you're lying about it?
Yes.
About the reputation
Great
of people
question.
that can't defend themselves? They're dead? You're going to call them criminals? You did that in the book so you could sell a book?
Little bad drink, but I'll allow it.
What'd you do it for? Made it more readable, you said? Which sells books.
Little argumentative.
What?
I'll allow it.
Literary.
Literary what?
Bullshit.
The literary ease that you can take with when writing a book.
Literary ease you can take with writing a book. You can make stuff up. You can
Literary
lie.
bullshit.
You can lie about people.
Not with that. I think the public perception was one that it was very interesting during this time.
So you're feeding the monster out there that wants to believe bad things about the Murdaugh.
Yep.
And you'll make stuff up to do it. Let me give you another example. I read your
Dick
book, and I
Boone
found
is
somewhat
hitting some
humorous.
home runs
My
today.
co-counsel did not. In describing myself and Mr. Griffin, in the book you say that I neutered him. We've both been very interested in what you meant by that.
Yeah.
What you mean by neutering Jim Griffin?
Mr. Hartpoolian, it was a book.
Did you make it up?
So you fucking lied about everything.
I know it was a book. The Bible's a book. I mean, just because it's a book doesn't mean you can lie in it.
It's just a word that was used.
Nature of that exchange.
Don't argue with the witness, but the witness, Ms. Hill, you're instructed to answer his questions. You may proceed, Mr. Hartpoolian.
So let me get this straight. The book, and I'll see if I can cut to the chase on this. I could read you chapter after chapter, verse after verse, which is not true. Okay, not true based on my experience of being in a courtroom, and not true based on knowing some of the people you described. You say that is.
Mr. Hartpoolian.
I object. The counsel is just testifying right now as to his observations about the book.
Question, Mr. Hartpoolian, please.
You've conceded there are things in the book that you don't know to be true.
I love the
correct?
judge now. I hated her before. Now I like her.
Okay. You would concede then that you have lied in the book.
It's only because I wasn't there at the time. I can't interview my dead grandfather. I can't interview Mr. Buster. There's just things that we can't interview them on. We can go by what was written in a newspaper and get facts from that.
Is that what you did, or did you make it up?
And take the inference that one of the Murdaughs was a pedophile. You could have printed that, and they're not here to contradict it. You could have printed anything you wanted and made it up to sell books. That's what this whole scheme was about, selling books. As you told Rhonda McElveen, if him being found guilty would sell more books.
Your Honor,
Isn't that true?
I'd object to the argumentative nature of the question, the compound question, and assuming facts not evidence.
Compound question. If what you're asking is what she told Ms. McElveen, go on and ask that, but don't precede it with
Yes, Your Honor.
testimony.
Beg the court's indulgence for just a moment.
All right. Well, wow. Dick Poone's bringing the heat. While he's doing that, and before we get too far afield, I want to bring Nick Starro Trial Watch hits the nail on the head here. With this, we can conclude that either jurors are lying under oath or Miss Hill is lying under oath. In both circumstances, it should warrant a new trial. I cannot agree with you more. And Magician Sapphire, Pootie Tang isn't playing no games. Shut-a-tay. Dang. Dick is not playing around, seriously.
Write your book about that juror whose ex-husband had posted something we now know probably wasn't her ex-husband. Did she have any other ex-husbands that you found out about?
I have no idea.
Well, you wrote, we learned later the ex-spouses hadn't seen each other in 14 years and she had 3 restraining orders against him. Did she have 3 restraining orders against him?
I don't know. That's what she said.
Okay.
He is destroying her credibility here. Kim Hunter with just the $10. Thank you so much, Kim Hunter. Oh, what a cute little doggo you got there. My dogs have gone off and
tell jurors
gone to sleep on my bed, I saw when I went to get my
at the end of
drink.
the trial after President's Day break. President's Day break would have been a Monday, correct?
Correct.
But before Mr. Murdaugh testified, did you tell the jury not to be fooled by the evidence presented by Mr. Murdaugh's lawyers?
Mr. Hartpoolian, I never talked to the jurors about any of the evidence.
Okay, the answer would be yes or no. Then you can explain. Yep. Did you say that?
No.
Okay. Did you ever instruct the jury to watch him closely immediately before he testified, looking at his actions, looking at his movements? Did you ever tell a jury to do that?
No.
Did you ever tell the jury to pay attention to Mr. Murdaugh's testimony?
To pay attention, not specifically to his testimony. I did tell the jury to pay attention,
To what?
just generally in the hallway when I was speaking.
Not to him.
Why on that day
Just
did they
any
have to
witness.
pay attention?
Right.
Okay.
Why on that day did they have to pay attention? Why didn't they have to pay attention the day before, or the day before, or the day before, or the previous
Did
5
you-
frickin' weeks? Why was she speaking to the jury, telling them to pay attention anyway? That's not her job as clerk of
Did
court.
you ever warn the jurors the defense is about to do their side? This is right before, right at the beginning of the defense case. They are going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off. Did you ever tell the jury that?
No, sir.
Okay. Did you ever tell the jury, if you get emotional, we want to see your face because that is what they want to see? You ever tell them that?
No, sir.
Did you ever tell the jury that Mr. Murdaugh was about to testify?
I didn't tell the jurors that.
Now, did you tell the jury that if they didn't reach a verdict by 10 o'clock, they were going to have to spend the night?
No, sir, I did not.
Did you ever tell them they were going to have to spend the night at
No,
some
sir.
point? Did you ever tell them that they couldn't smoke?
No, sir.
Okay.
Okay.
You got any other books in the works?
No, sir.
I mean, doesn't this make a good book?
Yeah, smile because you got nothing else to say. Whew. JKD Buck, Beck Eagles Dunning-Kruger personified. She can't understand how dumb she sounds. Go Poot! And Island.
Yes, sir.
Pull out the book and read it back to her. I need it. Oh, I don't want to hear that. That book is so bad. Apparently she didn't write it. How do you have an introduction that's longer than 12 pages? And how do you actually plagiarize 12 pages of the introduction to your book? Good Lord.
Your Honor, there were a few matters that came up on cross, obviously, that I'd objected to.
You won't waive your, you may reserve your rights to object to the entire line of testimony, but you may offer cross-examination subject to the assertion of your objection about the testimony.
Clearly you, Steve, because I mentioned in most of your books introductions. So
one of the things you
clearly
were
you
asked
have the best
about
book introductions.
is finding this Facebook post, and you brought that to the court's attention after a different issue had already arisen related to a juror. Is that correct?
Correct.
All right. And are you technically capable of manufacturing a Facebook post? Is that anything that you have any capability to do?
She didn't manufacture it. She didn't
And
show it.
did
It
you,
didn't
ask your
exist.
staff member to go see if she could find this post?
I did.
Did you tell her just generally what you recalled reviewing?
Yes.
And did you give her any further instruction other than that?
No.
Were you sitting behind her as she was doing this particular search or anything like that, or did she eventually report back to you?
She is very, very techie. And then she reported back to me.
All right, so you weren't there when she was searching anything like that?
No.
Well, you know how to
She was like, "I
copy
couldn't
and
find
paste
that post,
12
but I did
pages
find
of
this,"
your
and handed
introduction.
you the Facebook post, is that
Correct.
correct?
Correct.
And then you provided that to Judge Newman, and ultimately it was provided to the parties, is that
Right.
correct?
Correct.
You were asked about conversations that you had with the forelady. Did those involve logistical issues and things like that for the jury?
The conversations with the forelady was everything. There was nothing regarding the defendant and this trial.
All right, so they were logistical issues, not anything to do with the substance of the trial, is that correct?
Absolutely, yes.
As techie as her
You were asked
alleged
about whether or not you had texted some
wiretapping
people,
son.
this won't be long. Was that at all in any way based on any conversation you had with a juror as to their internal thinking or anything like that? Or was that just your assessment being an experienced person in the court?
Absolutely not.
It was based on just your assessment?
Just my assessments, yes.
Did you ever communicate with the jurors on how long they would be, or did any juror ever tell you how long they thought they would be?
I never talked to any jurors about anything like that.
You were asked about your book, and I don't want to get into too much detail about that, but you were asked about some of the assertions that you made in the book, and you were asked if these were lies. Were they lies, or were they ultimately things that were based on inferences from newspapers and community stories?
You are leading by, this is your witness, Mr. Waters, so please ask a direct question.
Thank you. Some of the statements that you were asked about in your book, were they lies, or were they based on your inferences from just general community knowledge and things that you had researched and knew?
Still leading, but I'm not going to object.
All right.
Thank you.
He's right about that, Mr. Waters. Just ask a direct question.
Did you lie in your book?
No, I did not.
Then what the fuck did you do? You just said
you were asked about
literary license. What you just said you lied, but you used different words.
Pay attention.
Was it the truth or was it
not? Did you also mention anything about
oh my God
for you or things like that?
I knew that Mr. Bill would take care of that. And the jurors knew too. Coffee, we had done some Dunkin' Donut runs. We had provided coffee, different other things to help stay awake in the cold courtroom that we found ourselves in. And so I knew anything that they needed, Mr. Bill would see that they got, because that's what he did.
At any time, did you have any conversation with any juror in which you tried to influence their decision?
I did not have a conversation with any juror about anything related to this case.
You just told them to pay attention. That has something to do with the case.
All right. Ms. Hill? I want you to turn your attention to a hearing that Judge Newman had.
Ooh, the judge has got some questions.
The alternate who was dismissed, sometimes called the egg juror. Do you recall that hearing?
Yes, ma'am.
She is the Eggman. She is the Walrus. Ari, what's up, Ari? Ari Jacob. She's under criminal investigation for doing this and for allegedly having her son wiretap the court staff.
Her. Do you recall that?
So they could hear what they're saying about this. So she could face some
Let's
criminal
go back
punishment.
and talk about that juror. You on examination in this courtroom, you said that she talked about a lot of things to you, but you didn't ask her any questions. But that's not completely accurate, is it?
Yes, ma'am, that is true.
Well, you asked her direct questions, and that came out in the hearing that Judge Newman had. You asked her questions before she was even examined by the judge, did you not?
Your Honor, I did not ask her any questions.
That wasn't the question. Really, was it? Judge is looking for something.
The juror was examined by the judge in a hearing. Do you recall that hearing? It's the second hearing on this matter.
I do recall that hearing, yes.
And the court
her discussion with Judge Newman is on the record. That's where he said that he was a bit
Asked
upset
you
or
about-
whatever he
the
said that
court
a
asked this
juror,
juror about
the
postings on
clerk of
Facebook.
court was
Did he
talking
not?
and admonishing the
Correct.
juror rather than the court.
And the juror said she gave Miss Becky my full access to my Facebook. I put positive posts on it. I've done that for the past 3 years. Do you recall her testifying in that regard?
I do remember reading that.
And the judge said, has anyone posted anything on Facebook about you? And the juror answered, I was not aware of it until Miss Becky told me today. Do you recall that?
Yep.
I do remember her saying that.
And do you recall the judge saying, what did she tell me? And the juror said, she asked me if I had an ex-husband, and I said, yeah. Did you ask her that?
I remember her saying this, Your Honor, but I did not ask her any of these questions.
And she further says, she asked me if I had talked to him about the case or being on jury duty, and I said no. I had questioned her about why she was asking me that. I haven't seen my husband since 2014. Do you recall her testifying to that?
I do remember that, yes.
And with that, having jarred your memory, do you recall asking her about
Jarred
her
your
husband
memory?
and his post?
Your Honor, I don't remember saying anything about that.
Well, what was the post that you read in the Walterboro
Whatever it was. Thing.
Word of mouth.
Word of mouth? What was the nature? You read that, did you not?
I did.
What did it say?
My memory is a little fuzzy with that, but it was about a ex-husband who found out that his ex-wife was on a jury, and he didn't think that she would be a good juror. And it just sounded very similar to what I had heard the judge and the attorneys speaking
So
about.
you then went to that juror and questioned her about that, did you not?
I did not, Your Honor.
Well, she says in this testimony that she didn't know about the Facebook until Miss Becky told me. Was that incorrect?
I'm not saying.
Some kind of conversation went between the two of her for her to know about that post.
Yep.
Correct?
That's true. And I'm thinking that it could have been someone, it wasn't me. I just know that it's not me that she talked to about that.
Well, when the judge, the judge was questioning the juror about this, she also said that she had 3 restraining orders against him. And she also said, I was very upset after she told me that. Like I said, I have 3 restraining orders against him, and I wouldn't have anything to do with him if I didn't have a child with him. But I haven't seen him since 2014. Y'all didn't discuss that, the restraining orders?
On the way from the jury room to the back chambers where the judge was, she was very scared. She was talking
So you
about
talked to the juror.
the 3 restraining orders that she had out on her husband at the time that they were divorcing. And she was scared that he would be trying to get back in contact with her again.
Well, how do you know that? Did she tell you that?
She was talking about that on the way to the jury room, to the chambers with the judge.
Uh-huh.
And in the court, in this hearing now,
As Farrell says, an AH clone here, everyone lies except me, right?
They're asking about
Thank
this
you.
Facebook post, and she said, Miss Becky said she had went to look for the post again and that it had been deleted. I don't know who she talked to or anything else, but she said apparently, do you recall her saying that?
I do remember her saying that.
And the court then said, what did she tell you about that? And the juror said, it was after you let us go on the last break. I was very upset. This is what you're talking about. And she came down and talked to me and said that apparently, I don't know who talked to him, but he said he was drunk and he removed the post. Do you recall that?
Well, she didn't tell me that.
Who told
and
you
I
that?
didn't talk with her about
Then
that.
who told you that?
Well, you saw that post, the so-called apology post, did you not?
Right, I did.
And you assumed that was a post from her husband, did you not?
Right.
And then you talked to the juror about that, did you not?
I did not talk with the juror about that.
Well, who did you talk to about it? Did you bring it to the judge's attention?
No, we didn't get a chance to
And
talk.
how
to
did the judge
about
find
that.
out about it? She didn't tell you. You didn't tell the judge. How did the judge find out about it? Trent Thoreau, seems to me Becky's strategy is deny everything and play dumb if she's caught. Right.
Discussed
Thank
anything
you so
about the
much.
case with anyone on the jury? The juror said, not that I'm aware of. The judge said, okay, she was just discussing with juror. She pulled me aside when we went downstairs after the last break. I want to say it was after lunch, and we came back, and that's when she first told me about it, about this, what we now know.
All right, Becky, call Judge Newman a liar now. Call Judge Newman a liar.
You assumed it was a post at the time, and y'all had a conversation about it, correct? Don't just nod. Answer the question.
Yes, sir. Yes, ma'am. I believe that it was one of my staff that she talked to, but it was not me that she talked to.
But the juror says, and I want to say it was after lunch we came back, and that's when she first told me about it. She's talking about you.
Correct.
Then we went back into the court, and I never even got to sit on the jury. The judge says, the judge then stops the questioning and she exits the room. Mr. Griffin, Your Honor, I think that satisfies it. She hadn't talked to anybody, hadn't expressed an opinion, hadn't made up an opinion. She's got an ex-husband and she has 3 restraining orders against him. The court said, Mr. Waters, just obviously we're all invested in this. My main concern, I certainly would love to, but not love to, but want to hear, what one of these individuals said. But, she answered the questions as she did, talking about the juror. They then have a colloquy about this juror and whether this was really her husband that put this post in that you talked to her about and apparently talked with the court about at some point. Am I right?
That's right.
Yeah, the captions are kind of amusing at times.
And then at the end, the judge said that he was not too happy with your having talked to the juror before you talked to him. Do you recall the judge saying that?
Yes, ma'am, I do.
And did you pop right up there and say what you're saying now, that you never talked to her?
We never talked about it after that. I wasn't in the room. when he
After
said
that? Oh, come on. Everybody's lying. Everybody's lying. Even the judge is lying.
The judge brought up another thing right after sentencing that I want to explore with you briefly. One of the big responsibilities of the clerk of court is to take control of the exhibits that are presented in court. Isn't that correct?
Yes, ma'am.
And there were sealed exhibits presented in this case that were photographs of the 2 decedents at Moselle when the law enforcement authorities first investigated the murders. You recall that?
Yes, ma'am.
And those photographs were sealed by the judge, were they not?
Correct.
And when the testimony about them was completed, they were under your control as the clerk of court, were they not?
That's correct.
How was it that those photographs came into public view?
Are you talking about after the?
I'm talking about the fact he alluded to it on sentencing, and said that he was frustrated about it and was going to try to look into it. Those photographs that were sealed court exhibits under your control found their way into the public media, did they not?
I believe they did. And I think what happened, it was someone from the gallery took a picture from a screen that had some of the pictures on it, if I'm remembering correctly.
What?
Did you ever allow anyone from the press to view these sealed exhibits?
No, ma'am.
Did you allow Netflix to ever examine the exhibits for trial?
No, ma'am.
How did you handle exhibits? Because you did have the press have great access to the exhibits, and you say several times in your book that you had to stay after to be sure that you interacted with the press about these exhibits. That's true, is it not?
That is true. We had Mr. Jay Bender, and then we had the pool photographers and someone from maybe the state, I believe, or the Posting Courier, along with the court reporters, someone from court administration, and then someone from the clerk's office every night that would go over the exhibits to make sure everything was correct and within our domain.
Were any press people ever allowed to view the exhibits, even the sealed exhibits that you had on file?
No, ma'am. No, ma'am.
What was the methodology for allowing them to examine the exhibits? How'd you handle that?
I wasn't there a whole lot when we did this every night, but it's my understanding that the people that were involved with the exhibits, and especially the court reporters, and there was a certain time frame that they were allowed to take their pictures, and everything was, all of the pictures were looked at by the court reporters that were there, and the lady from court administration, along with someone from my office and Mr. Jay Bender, to make sure that everything was done correctly.
What I'm asking is how you handle having them, the press, view these exhibits.
If I remember correctly, the press, we had certain designated photographers, and then someone, I think, from the state of or the Posting Courier, and they were responsible for putting it out on a stream for the rest of the media to access.
And would they do that by photographing the exhibits as they were in your possession after court was over that day?
That is correct.
All right. And how did you handle the sealed exhibits in terms of their availability when these press people are there photographing exhibits?
They stayed sealed.
And so you think that you're aware of the fact that some of these on the scene photographs of the two decedents found their way into the public press. You're aware of that, are you not?
Yes, ma'am, I am. Yes.
And you contend that they photographed them in the courtroom?
That is what I heard.
All right. Finally, you have indicated about your book that some things that you put in there were, you called it literary license, not literally true, correct?
That means a lie. That means a lie. A lie.
Did you ever, by any kind of email communication or in any way, shape, or form, indicate or state that you wanted a guilty verdict because it would increase the sales of the book? Did you ever say that in an email or verbally or in any other way?
No, ma'am.
I don't believe that
It
for a
didn't matter
damn
to me
second.
if it was guilty. not guilty, or a mistrial.
I don't believe that for a damn second.
Well,
not
in your
a
book, you
second.
suggest that the guilty verdict was what you wanted, and you were fearful that that a guilty verdict would not be rendered. You say that a lot about your feeling about wanting a guilty verdict, do you not?
I do agree that that is said in the book. And part of that is because I think it was a guilty verdict.
Well, this is that you were describing a time way before the verdict was rendered when you wrote about those things in the book. Isn't that correct?
It is, yes.
And you even have something where you said your eyes met with jurors and others at Moselle, and y'all have an understanding, unspoken, that he was guilty. You said that in the book, did you not?
I did say that in the book, and I would consider that part of the literary
lies. Oh my God.
The word that we just said. But there was nothing spoken with a juror at all at Moselle or anywhere else at the courthouse or anywhere. I think that's part of that poetic license that we write to make something more apparent.
You mean lie? You mean
but
lie?
At no time did I read or try to read someone else's eyes, and
you said you did.
That was just one of those gut feelings that I wrote in the book.
You're caught. You're busted. Wow. So she can explain all of her lies away as literary license. This is a bunch of crap. It's just literary ease, literary license, literary ease.
Wrote in the book, speaking of a time before the jury verdict was rendered.
Of course, it makes her a liar. She just doesn't want to say the L word.
About knowing the Murdaugh family and about having so many people watching and listening to me as I read the verdict. I was mostly concerned about Alex being found innocent when I knew in my heart he was guilty. I had this fear that the goodwill the Murdaughs had built up in the community would influence the jury. You wrote that, did you not?
Yes, ma'am.
So you had those feelings well before the verdict was announced in this case. You had some definite opinions and feelings about what the verdict should be, did you not?
I did have a certain way that I felt.
But that's not any poetic license, what was said there. That's how you felt, correct?
Correct.
All right.
Yep.
Those are my questions. Anything further from the state, Mr. Waters?
Her questions were way more brutal than Poots was. Oh my God. Was your book fiction or nonfiction?
Very briefly, Your Honor.
Yes, sir.
You were asked a number of questions about the interactions during the in-camera proceedings with the juror who was excluded. Were you in the room during the entirety of those interactions, or just were brought in here or there as those occurred?
No, I was only brought in for my asking of my questions from Judge Newman.
And you were asked a little bit about sealed exhibits and about Judge Newman's comments at sentencing at the end of trial. And just to clarify, those were not pictures of any sealed exhibits. It was a picture that someone had taken in the gallery that had actually been disclosed. And that's what Judge Newman was talking about, to your understanding?
That was my understanding. Yes.
That's what the judge is here to decide. This judge will decide whether this warrants a new trial or not.
About the fact that some body cam videos had not been sealed, and Judge Newman fixed that problem after the trial. Is that correct?
Correct.
Nothing further, Your Honor.
That was short.
Let me understand this correctly. You would agree that you did release all of the exhibits in this case, sealed and unsealed, to the Texas film crew. Is that correct?
No, sir. No, sir, I did not release the sealed exhibits.
What about to Netflix? Didn't you indicate to the judge they'd been mistakenly released and you're getting them back?
As an error, when we realized everything, yes, those two did go, and Netflix had not even, they said they had not even looked at them.
So you did do
Get
it.
them back.
We did get them back, yes.
And what about a Japanese film crew? Did they get exhibits, the sealed exhibits?
They did not get any sealed exhibits.
What about NBC Universal?
No sealed exhibits.
I didn't release the sealed ones.
But
I
you
just
do
released
concede
them.
that Netflix did get sealed exhibits.
They did it as an error. It wasn't
Whose
listed.
error?
So
Well,
you released
I
them.
would say the court reporter didn't mark it on the listing.
Well, why were you in such,
Jesus.
why were you so accommodating to these national documentary folks? I mean, is this good for the book? I mean, the more documentaries out there about the Murdaugh thing, the better your book sales are. I mean, there was money in this for you, right?
Yes.
Again, it's about the money, right?
Yep.
What's your question now?
Isn't it financially beneficial to you at the time to get more of these photographs out, more publicity, more Netflix, more HBOs, more Japanese? Doesn't that sell books for you? Didn't you see a financial advantage?
Not at all.
Okay.
Oh, you bullshit.
Thank you. No further questions.
Bullshit. Nobody believes that.
Ms. Hill, you may step down.
Holy God. Nicholas Starr, Trial Watch with the Sexy 100. Thank you so much. Ms. Hill is a bad liar, in my opinion.
Let's say.
Nope.
Hang on for a moment. Mr. Lewis.
She's using her subpoena. I just wanted to make sure she's not excused.
Oh, well, I wanted to step down. Yes, she's still under subpoena. I haven't heard what's going to be said. Mr. Harpootlian still has some things he wants to raise about other witnesses and so forth. So what I would prefer is that she remain with you, Mr. Lewis, until we see what else is going to happen. You may step down.
Wow. How would the juror know about the ex-husband and the Facebook post when Ms. Hill led her to the judge if Ms. Hill didn't tell her about it? Yeah.
All right, Mr. Harpootlian.
Good.
Your
Spot
Honor,
on, Nick.
We've got literally millions of pages of documents in this case. Ms. Miller just uncovered an email relevant to what you asked. We don't have it printed out. But what it is an email from Rebecca Hill to Miho Takachuchi, something.
Don't try it.
Miho, first name, the Buford McDowell body cam should not have gone to you. Please get rid of it. Do not use it. The judge, Judge Newman, specifically ordered that body cam not be used if it got out. Apparently, it's still on the videos we were saved. I appreciate your attention. What about what about the other body cam video we could see on many news documentaries? Can you provide it? It seems the camera was on the other police personnel. I mean, here she's having emails between this Japanese production company about body cams telling them to get rid of it. I think that's important, and I can have a copy of this printed out for you when we can get it to a printer for you for the record.
That would be fine, but do you want to offer it as an exhibit?
I do.
All right, Mr. Waters?
I have no objection. If I could just ask the date of that.
The date is July 17th, 2023. July.
All right, that's one thing. What else? I will admit it. I will allow it. That is a.
There you go.
Impeachment of her testimony to me.
Yep.
She did not send any emails.
Yep.
Or release anything.
That's a lie.
In fact, she changed that testimony on redirect when she
That's
said
a lie.
she did, so-called by accident, release some things.
That doesn't appear to be by accident. So we'd like that made part of the record. Secondly, I have sitting outside the courtroom the clerk of court for Barnwell County, Rhonda McElvey. She specifically denied saying certain things to the clerk of court of Barnwell County. and denied doing certain things, I think you're going to find her testimony extraordinarily instructive and educational. And it shouldn't take, I would be shocked if it took 20 minutes.
In light of the answers she gave to my questions and some of yours in that regard, I'm going to allow it. Now, I want to know what else we're looking at here.
Dang. Bring her on in. Yep.
Do we have only one copy of this?
Having good breath is always a good thing, regardless of whether you're in court or not. I did not expect the judge to be that aggressive.
Your Honor, I want to hand up to you an affidavit from a witness we would propose to provide in addition to court recording. This is a alternate juror, not the egg lady. This is the alternate juror who was dismissed when she was not needed for deliberations. And she is here also ready to testify. And I would expect her testimony would take about the same time as one of those jurors this morning.
Sir?
I would expect her testimony would take about as much time as one of those jurors this morning.
This is your offer in refutation of the testimony Ms. Hill has given today.
She denied saying any
She
of it.
denies saying anything. That's correct.
Yes, Your Honor.
Now, is this juror, alternate juror, going to testify?
She's here. Yes, Your Honor. She's sitting.
Well, you just say she's here. She's available.
Yes, ma'am.
All right, Mr. Waters.
Your Honor, a couple things on this particular alternate juror. We've just been handed this particular affidavit. Your Honor, I believe that Your Honor had correctly ruled that the focus again was on those jurors, and the inquiry has been made to those particular jurors. I don't know why we would go into detail with an alternate juror that ultimately did not.
Because it goes to Becky Hill's credibility
as to any effect on the verdict, which is the ultimate inquiry before Your Honor. And so we would object to this particular testimony as far as it relates to the alternate juror.
Here's the one thing that gives me some heartburn, and you can help me with
Heartburn.
this. I stand by the rulings I have made that only jurors can be questioned about the effect on their verdict. And that is why I did not allow the testimony of the egg juror in that regard. He is now offering this testimony, and it's testimony of certain things that were said to the jurors as a whole, rather than just to this particular juror. And I would, as I say, I would ordinarily not allow this, but Ms. Hill testified several times during the course of her
say it, Judge,
just concluded appearance, that she never told any jurors anything along the lines of what has been asked here, particularly the comments about they're going to say things that will try to confuse you or throw you off, things of that nature. She was asked about that, and she denied she ever said anything like that. So this is an attempt to impeach as I see it, and that's what's giving me a little heartburn about just turning him down flat.
Well, a couple things as to that, Your Honor. First of all, I think that we have some very specific statements and a specific individual that's mentioned here. And so if we're looking at Rule 613, B, which is essentially where they're operating, I don't know that there was an appropriate foundation laid as to the specific time and to whom these specific statements were made. I think that it needed to be cleaner with regards to that as to mentioning this particular person and as much as you
Overruled.
can, the
Sit
time
down.
and place and the very specific statements that were made. I think Mr. Harpootlian, again, we had these general allegations and kind of went through those, but I don't know that now that we've just been handed this affidavit, that they were set forth as an appropriate clarity that's required by 613B. So I think there's a failure there.
Mr. Waters, look for a minute at paragraph 3.
Oof. Oh, we get to hear some of it.
4,
Cool.
5, 6.
Read it, Judge. Let us know what it says. Is that what you're saying? Is that what you're saying, Creighton? Is that what you're saying? Denied. Sit down.
All address things that have been asked her, and they are pretty specific as to time and place. And the content of this testimony is an attempt to impeach her, Ms. Hill's testimony.
Yep.
That's why as I guess colloquially I said, I'm having a little heartburn about excluding this, is because she was asked directly about these matters. And this testimony would be in conflict with that, which would be permitted to impeach someone.
Right. And Your Honor, I certainly understand the point. I guess I would have just 2 points to that. Number one is that, as we've already talked about, this evidentiary hearing is within your discretion in the manner, particularly when you're talking about jurors and the manner to be conducting that.
You're damn right,
talking about
Creighton.
putting the juror on the stand and having attorney examination. And I think under the case law, that's within your discretion as to how that inquiry should go, as opposed to were we purely in a trial setting and
He does kind of look like Droopy.
Applying to evidentiary rules again, strictly applied, I think that I don't
Does
know
look like
that
Droopy
they
Dog.
laid the foundation with enough clarity to offer extrinsic evidence under 613B, and that would be our argument there, that we just had generally discussion of some of these concepts, but not the place, time, and person to whom it was made with the specificity that 613B requires. So that would be our evidentiary objection in the event that Your Honor is addressing those. So that would be our position. I do also, before we get started, I do want to go back and address the sealed exhibits issue.
That would be well deserved.
If now, I'm happy to go.
Mr. Harpootlian, slow for a minute. I'm turning to Mr. Waters to try to get some clarity about why he objects to this testimony. One is the 613 issue that he's explored, and I understand that. He now wants to say something about the sealed exhibits. So I want to hear from him on that, and then you can reply to both of them.
I'm sorry, Your Honor.
That's all right.
Distracted by Mr. Barber.
Sure, I understand.
And, finally, going back to the juror issue, we would also raise 403 as well, just because of the nature of the inquiry that we're here to assess. Going back to the sealed exhibits, I just want to clarify for Your Honor, Mr. Griffin and Mr. Harpootlian were at this hearing. After the trial, there was a release of, and these were publicly filed exhibits, of a number of exhibits. What also got released at the time were 2 body cam exhibits, which had images of the victims at the scene. Those had inadvertently not been marked as sealed exhibits. And ultimately, then we had a hearing in front of Judge Newman, and essentially those were clawed back. And so I just want to be clear that when we're having testimony about that particular thing, as it relates to what Ms. Hill was saying, those were the sealed exhibits that were released. And again, at the time, they had not been marked sealed, and that was sort of retroactively fixed. And then the other issue, of course, is, Your Honor, is again that the issue that Judge Newman was talking about after sentencing was a gallery photo. It was not what apparently would be maybe a press photo of the exact exhibits. And what we did at trial, and Mr. Harpootlian can speak to this, and Mr. Bender could as well, is at the end of each day, first of all, the sealed exhibits would have a cover sheet or a folder that they would be in, and then they would verify with the parties that these are the okay exhibits, these are the sealed exhibits, and then at that point, after court was concluded, the media would then be allowed to review and or photograph or get copies of the unsealed exhibits. So that's just how the procedure was working at the trial.
That's very helpful to clarify this, because I now see this in perspective that there were that the materials that were photographs at the scene or depictions at the scene of the 2 victims. What you're telling me is that those were inadvertently released after the trial by I guess by the, well, it would have to be by the clerk of court. She's the one that had them. And then they were, and they weren't properly marked. And they were then clawed back.
Yeah, they were the two body cam videos. And so in those videos, it weren't physical images, but they were the body cam videos. And then in those videos, you could see the victims at the scene. And those two exhibits, to my recollection, were the only two that should have been sealed, but they, in fairness, were not marked sealed. And that's how they got released. The second we realized it was a problem, we took care of it and clawed those back.
That clarifies that issue for me. So I frankly, that puts my mind at ease about what happened there. Now, Mr. Harputen, I'll come to you momentarily. Anything else?
No, ma'am, Your
Honor. Okay, now, Mr. Harputen.
A couple of things I'd point out. The first is this, in terms of the statement by this alternate juror. She was interviewed by SLED on video, said exactly the same thing as she's saying in this affidavit weeks, if not months ago. So they know exactly what she said. I can assume they reviewed it. By the way, I asked, basically read from this affidavit as I cross-examined the clerk, and she denied each one of these statements. The second piece of that is this.
I know it's on that basis that I'm even pursuing the idea of you're offering something by way of impeachment. So I understand that.
And secondly, as to the sealed exhibits, I think we're going to hear testimony from Ms. McElveen that may elaborate on your concerns based on our interview with her this morning.
All right. Well, here's what we're going to do. It's about 3 minutes of 3, which is when I generally take my afternoon break. I'm going to adjourn the court or recess the court, and we come back at 3:15. And I will allow you to offer Ms. McElveen and the alternate.
Wow, she's going to allow the witness,
that the
juror.
They will be offered on what we've talked about, matters about which Ms. Hill testified that you think are impeached by Ms. McElveen's testimony and that you think are impeached by the alternate juror's testimony. So and the alternate juror's testimony, as I look at it, is the part about which impeachment would lie would begin at paragraph 3.
Yes, ma'am.
So do you understand what I'm saying?
Yes, ma'am. Can I make you one other offer?
Yes, sir.
Today and today only. Egg Lady is across the street.
Well,
no. If you want to put her on the stand.
No. I've made my position quite clear about that. I think we've got in the record what is needed in terms of what she says, Ms. Hill says, and what Ms. Hill says she says.
I agree. We did not intend on calling her. I just didn't want you to miss the opportunity if you wanted the opportunity to examine her.
Thank you, Mr. Harputen. All right, court will be in recess until 3:15.
Wow. Wow. That was heated. Holy cow. All right. Damn. That's fascinating. I'm excited for this. Hurry up. This 15 minutes has got to go quick. We got to hurry through this next 15 minutes because I really want to see what's going on. Oh my gosh, that was great. Oof. Now I'm trying to find this here on Twitter, but it's reported that Fitz News had said that just as Juror Z was being sworn in, we had all the back and forth about Eric Bland can't sit behind Juror Z and had to go sit somewhere else. it was reported to me on Twitter that Fitz News had reported that Eric Bland mouthed motherfucker towards Harpootlian. I'm trying to find that on Fitz News and I can't. That would be awesome if that was true. I just asked where that came from just to be sure. Because that would be awesome if Bland was mouthing mother effer to Harpootlian after he was forced to move seats. Wow. It would not surprise me. The judge, I can't imagine the judge making a ruling today. I assume it will be pretty quick because the whole entire appeals process and everything else is being held up by this issue. So she's going to get her decision out fairly quickly, I'd imagine. So we'll just, I would guess within a week or two, but I can't imagine it taking any more than that because she wants this to go. Jennifer with 2 pounds says, knock me down with a feather. Right. This took a turn. The judge seemed to be fairly anti-Dick Poon here in the earlier stages. Now, she took Becky to the woodshed, and now she's allowing other witnesses she wouldn't normally have allowed to come and testify to impeach Becky Hill. So the tables seem to have turned a little bit here. Becky Hill's testimony was terrible. Terrible. I don't know any other words that I like. I can use other words, but they would basically all be terrible. Is how that would all break down. That was just bad testimony. She clearly, to me, was lying through her damn teeth. Whew. And she was being called on the carpet for it. As I mentioned, I think the judge was asking tougher questions than Harpootlian was there. Exactly. Judge went hard on the paint there with Becky. Good grief. And again, we saw the whole thing with Becky. It was everybody else.
Speed chases.
All right, hang on.
We got unruly suspects.
I will kill that motherfucker.
Turn off the law and crime. What is that? The law and crime commercials that are on. Yeah, so it was. She never did anything. It was everybody else her clerk was doing this. Another clerk was doing that. A staff member was doing that. Everything she got pinned down on, it was poetic license. It was literary license. It was literary ease. It was just me kind of exaggerating in my book. That's how she's getting around lying about all this shit. She's trying to say it's just her exaggerating for literary purposes, which means lie. That's what it means. It means lie. Wow. I was not expecting this kind of twist here at the end. I wasn't expecting the judge to do this. So can you take the fifth if you're not charged or no jeopardy? Well, Becky Hill is being investigated. There's 2 separate investigations ongoing into Becky Hill by SLED. And one of them is whether she tampered with the jurors, which is kind of a crime. Jury tampering is a crime. They're investigating that. And also, her and her son are being investigated in relation to alleged wiretapping of the various people's in the court system's phones, allegedly so that they could monitor what they were saying about the other investigation into jury tampering. So she actually is potentially facing criminal charges arising not only from jury tampering, but wiretapping to find out information about the jury tampering investigation. So it's possible to take the fifth, but she lied instead. That's what she did. She answered the question. Oh, wow. Yeah, imagine if her, yeah, 'cause she was talking about how her daughter would have been a good juror. Her daughter was in the jury pool, apparently. Yeah, that's why I was going to ask if the book is fiction or fact. Well, it was probably fact until she got on the stand. Now it's fiction. Now, okay, Nick found it. Thanks, Nick. I want to read this just to be sure. Wait, did I close it? No, I brought it over here. Hang on. Where are we at here? Nick. Yeah. Hang on. I'm looking over here. Oh, okay. I was looking on the Fitz News Twitter page. This is the Fitz News page. Okay. Let's bring this up. This is interesting. And the timestamp was 10:07, right? Let me bring up the, and we're, as I mentioned at the beginning of the show, once this hearing is over, so hopefully it'll get all done today, and maybe tomorrow, if not tomorrow, early next week, we'll have Mr. Fitz on from Fitz News to talk more about this, to kind of break this down. I have to remove that. I didn't want to stop the screen, so I wanted to remove it. I have to bring it back up, then I have to remove it again. Just stop the screen. And we want to present this one. So this is his, he gets to use his phone there in court because he's media. So he gets to tweet. 9:40 a.m. Where are we at here? What was the timestamp again? 10:07. So the jury is being brought into the courtroom. 10:04. The sound system is acting up, and Toll remarks, "This is the funkiest sound system in the world." The court erupts into laughter. Juror Z has been brought in to testify. As she walks in, Attorney Bland mouths to Dick Harpootlian, "Motherfucker, Juror Z has been sworn in." You want another reason why I don't like Eric Bland? This. He has to go sit somewhere else, and that's his reaction to Dick Poon. He's been brought in to testify. She walks in. Eric Bland mouths to Dick Harpootlian, "Mother effer, Juror Z has been sworn in." Thanks, Nick, for bringing the actual quote there. Let's see what he says about the judge's questioning, shall we? Scrolling. That's Mr. Fitz there. He'll be on the show hopefully very, very soon. Toll asks Hill if she had definite opinions and feelings about the verdict and what the verdict should be, and Hill agrees that she did, but didn't state them. Toll has completed her questioning of Hill. Toll is continuing to question Hill about the inconsistencies in the court transcripts and her testimony. She keeps returning to Newman's statement that he wasn't happy with the clerk interrogating a juror. Right. Toll asks Hill about the sealed photographs as exhibits that were under her control and got out into public view during a post-trial hearing. Hill agrees they did, and the exhibits were taken during testimony. Yeeps. Yes, I like Fitz. Fitz News it's good local news coverage. So thank you so much for bringing that, for bringing the link. Attaboy, Nick. Thanks, Nick. Yeah, Dick Harpootlian. We just call him Dick Poon for short. It's just easier to call him Dick Poon than Richard Harpootlian. Wow. Got about 5 or 6 more minutes here of the break. Becky's going to add perjury to her list of charges. Perjury is unfortunately very under prosecuted because it's just not worth anybody's time really to prosecute it. So when someone is charged and prosecuted with perjury, it's a really serious perjury. Let's look at the state of the stream. We currently have 1,100 people here now, and 984. We're 16 likes away from 1,000. Everybody, get down there and smash that like button. Let's get us up to 1,000 likes. It's not often we get 1,000 likes during the middle of a live stream, so that'd be cool. I'd like that. I mean, it's just for me. We've had 32 new members sign up. Most of those are from Tank Rat's gifted memberships and a couple of other gifted memberships. Thank you so much for all of that. All right, let's see how our poll is doing now. Will Becky Hill's alleged shenanigans result in a new trial? I think we need to redo this question again. The first one turned out almost exactly the same as the first time around. Almost exactly, which was 64% said yes, 30% said no, and 7% said hell no. Those were close. And what I'm going to do is I'm going to put up exactly the same poll again to see if anybody's view changed after the judge finished questioning Becky Hill. So I'm literally going to put up exactly the same poll and see, because we were consistent before the jurors testified and then up till now. And so let's see what we think now, shall we? Let me add the hell no option. And there we go. There is the third time we've put up exactly the same poll. Let's see if it's changed anybody's opinion. Lucentil says, yeah, my view changed. I think the judge was looking for an out, but instead found an in after an in after an in. I think you're right. I mean, I think she wanted to go into this without having to do a retrial, was kind of leaning that way, and now I think it's hard for her not to just go, oh my God, we've got a retrial. Because if there is a retrial, this judge apparently is going to be handling the retrial. And if there is a retrial and if she handles it, it's going to be a hell of a lot different than Judge Newman's shit show of a trial that he put on for however many weeks it was. I would actually like to see this judge do a retrial of this case, because I didn't like her rulings at the beginning. I liked her rulings at the end, but one thing that consistently, I liked the fact that she made the rulings. She made the decisions. She did what a judge is supposed to do, to judge, to make decisions, not to defer them until later, not to just go, all right, we'll allow it, and if it becomes an issue later, we'll deal with it then. I like that she didn't do that. So I think it would be very, very interesting. Exactly, MG. That's what I was just saying. At least this judge is making decisions and not waiting. But yeah, whether I agree with him or disagree with him, I like the fact she's making them. Dang. Well, guess who's not getting any sleep tonight? If you guessed me, you're correct. It is currently 5:13 a.m. here in South Korea, where I am. So I'm assuming this is going to go a little bit longer, and I might get an hour or two in before I have to go to the office. But looks like it'll be a sleepless night. Have to stock up on some really strong coffee before I go to the office and kind of sneak in a nap at lunchtime, I suppose. Oh, that's the first yawn. Excuse me. I didn't get to mute myself. When does work start? Work starts 4 hours from now, but I can bump it back an hour to 5 hours from now. Oh no, I'm not shutting this down now. Now we get the defense witnesses. There's no way I'm shutting this down now. Y'all made me sit here through lunch. I wanted to take a nap during lunch, but y'all made me sit here. So there's no way I'm bowing out now. And we got about 2 more minutes, 1 more minute before the court's supposed to be back. And she's been keeping a tight rein on the time. She was pissed that the jurors were a little bit late and she had to start late. So I'm expecting her back a minute from now when she says she's going to be back. Hey, we got 1,036 likes. Thank you so much, chat, for your support. Mods, you guys are pulling super awesome duty. Some of you, I think most of you have been here since the beginning. Holy crap! Just looking through the mod list. The people that are here, I'm doing their moddy dudes. Yep, see, boom, exactly at 5:15. The camera comes back on, and she's making her way into the court. So here we go. No audio yet because I haven't muted. There we go.
Please be seated.
That is on time, Judge. Damn. Thank you, mods. Thank you, chat, for being here. The Vice Squad chat is the greatest chat on the entire internet, hands down. Everybody who is in here now is a Vice Squad member. Thank you so much. You guys are great. And thank you so much for the likes. Thank you so much for the chat, the super chats and everything, and the membership. Just thanks. Thank you all. The 1,100 of you that are watching this can be anywhere, and you're here now, so thank you.
You to present your witness.
Yes, ma'am.
Please be,
Rhonda McElveen. You know this one.
Sure.
You know this one.
Yes, I do.
Dang.
Do you swear or affirm that the testimony you're about to give in this case to give the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am, that's what I'm here for.
Thank you. Please have
Yes,
someone
ma'am,
in
that's what I'm
stand,
here
state
for.
Your full name for the record. And please spell your first and last name.
Just say yes.
Rhonda McElveen, RHONDA MCELVEEN.
Help me, Rhonda. Help me, Rhonda. Yep.
Yes, sir.
Say your name for the record, please, so I can make sure I can hear you.
Rhonda McElveen.
Your Honor, can you hear? Okay.
I can hear you great, Dick. I can hear you, but I would doubt that anybody posted lawyers would hear you.
Is that better? No?
Is that thing on, Mr. Bailiff?
I can't remember how she spelled her name, so I'm just going to make up my own spelling.
Well, I can speak up. I'll just speak up. How about that? I have a big voice. I'll use it.
It's just not on at all, though.
No, it's on.
Is it on?
Yes, ma'am.
Okay. All right, Mr. Harpoon, you may proceed.
I'll speak a little louder if that helps. Say your name again for the record, please.
Rhonda McElveen,
And Ms. McElveen, what do you do for a living?
Clerk of Court and ROD for Barnwell County.
Clerk of Court in what?
Register of Deeds, I have 2 titles.
2 titles. And is that an appointed or an elected position?
Elected.
So you're elected by the people of Barnwell County.
Yes, sir.
And how long have you been the Clerk of Court of Barnwell County?
This is my 16th year.
Barnwell?
16 years.
B-A-R-D.
And I'm running again, sir.
You're up this year, 24?
Yes, sir.
All right. Don't think I'm allowed to plug that, but you have been the clerk for 16 years. You're up again this year. Now, do you know the clerk of, well, back up for just a second. Do you hold any position with, is there a state organization of clerks of court?
Yes, sir. I'm actually the president of the South Carolina Clerks of Court and Register of Deeds.
Okay. And that means that of the 46, there are 46 of y'all, is that
Yes,
right?
sir. Yes, sir.
And you were elected to be the chairman of that group?
President of that group.
President of that group.
Yes, sir.
Now, are there certain rules and constraints that clerks should operate under in terms of dealing with juries?
Yes, sir.
And is there training for that, or is there a book for that, or how do you learn that?
You have the Clerk of Court manual for one that's on the judicial website. You also have the law books that have it in there.
There's
Yoda
actually
has
two,
returned.
separate forms, SCCA 237 and 238 maybe, that has regulations on it. And then we also have in the handbook or not handbook, but in the program within the CMS system, they actually have rules and stuff there you can go by as well.
Now, as a clerk of court, are part of your duties to deal with juries?
Yes, sir.
We understand there's a jury venire that's brought in at the beginning of a term, and then individual juries are picked for both civil and criminal cases. Is that correct?
That is correct, unless it's a non-jury trial.
And then there's just a judge, like we're doing here, right?
Yes, sir.
And in the process of picking juries, do you assist as clerk of court? When I say assist, who actually picks the jurors out of a hat, or whatever the process is?
Well, actually, the first process is you draw a jury by computers through the CMS system, and then summons are sent out. And then once we come to court, we usually do a roll call. We see what everybody's doing, what the jobs and everything, to help the attorneys to decide which jurors they would like to get. They have so many strikes, etc. And then you call the names, and they have the strikes, and then that's your jury pool.
And then the judge will seat a jury in a jury box, although I've never quite seen a jury box that looks like that, but a jury box in a courtroom, right?
That is correct.
Your jury box in Barnwell County is like 2 rows of 7 or 8 people.
Well, I actually have a jury box on both sides of the courtroom, because I have the grand jury on one side when they convene, and then I have the petit juries on the other side when they convene.
Okay.
And Yoda's
the
Yoda
jury
has fucked off
they're
back to the
sworn
bed.
by the judge, and then they're put in the jury box, and they begin to hear arguments and testimony and jury charges by the judge. Is that correct?
Well, actually, sir, where we do it, the clerk of court usually swears them in with the judge presiding over the whole deal.
Okay. Once that jury is sworn in, what is your role in terms of dealing with those jurors individually or as a group? Are you allowed to talk to them individually, to pull them out, to converse with them about your opinion about the case?
To pull them out of the trial while we're going on?
Yes, ma'am.
No, sir, we're not. If they're on a break, et cetera, or if they request to see someone, then we manage to, I'll go in the door open. I'll say, which one of you needs to see someone? It might be the judge. And I said, hold on. And then I go get my judge. And so we've got a juror that needs to speak with you.
Do you converse with jurors about the merits of the case? By the merits, whether someone's guilty or innocent, or whether a plaintiff or a defendant should win in a civil case? Do you ever do that?
No, sir. About the most only thing I ever do is go in and count them and tell them I can count up to 14 without even using my toes. And then I might get their lunch order. That's it. And the doors are usually open when I'm doing that.
And you have bailiffs that sit with the jury or sit outside the jury room?
They sit outside the jury room, and usually there's one beside them in the courtroom in case somebody needs something. But usually they'll catch my eye, or they'll catch the judge's eye, and we'll get something handled.
Okay. So did you have any contact with the clerk of court of Carleton County prior to her being elected the clerk of court of Carleton County? Did you know her before she was clerk of court?
No, I did not.
Did you come to know her once she was elected clerk of court?
Yes, I did.
And was it a pleasant relationship?
It was.
And how did you come to be, and to cut to the chase, you ended up being in the courtroom during the Murdaugh trial for part of those 6 weeks. Is that correct?
Yes, sir.
How did you come to be there?
When Beck and I met each other at a conference, clerk of court's conference, where she was discussing that she had that trial coming up, and I knew that she was relatively new, and I said, I'll offer to come help you if you would like. And I think she ended up talking to Judge Newman about it, and they both said, yes, it would be good that I was there.
Okay, because you tried a murder case, two in the past, correct?
Yes, sir.
Okay. And did you go and help Becky Hill try that murder case?
I did. I couldn't go for the first 3 days because I had court in Barnwell, and I told both of them if I had court going on in Barnwell, I could not be in Colony County.
Okay. Now, To your knowledge, had Ms. Hill ever been the clerk of court that managed a murder trial prior to this?
Not that I'm aware of, sir.
So this was her first murder trial, as far as you know?
As far as I know of this magnitude, I don't know if they had one before then or not.
Okay. Now, when did y'all, I mean, initially, what were you talking about in terms of logistics and how you did it and all those sorts of things?
Yes, sir.
During that, before the trial, before we ever picked a jury, did she ever discuss with you that she was going to write a book?
Yes, sir.
And
She
did
wanted to write a book. Yes,
wanted
sir.
to write a book. Did she indicate what the book was going to be about?
About the trial?
About the Murdaugh trial?
Yes, sir.
And did she discuss with you, what, if anything, did she discuss with you about how she felt the verdict should turn out to be in the Murdaugh trial, vis-a-vis in reference to the book? What would help the book?
A guilty verdict.
And tell the judge and me what exactly she said to you that you remember. This is prior to the trial.
Okay. Well, first of all, she said we might want to write a book because she needed a lake house and I needed to retire. And then further conversations, a guilty verdict would sell more books. And we looked at that. This was before, even in December.
And when did she ever say that again to you during the week she spent there?
Several times. It could be said it was, amongst friends in her office, or we might be having dinner, that kind of stuff, but that's about it.
That she needed a guilty verdict to sell more books.
That would be the best way to sell books, yes, sir.
The best way to sell books. Now, during this process, did she ever express to you an opinion on whether or not, in fact, was Mr. Murdaugh guilty of the murders of his son and his wife?
Yes, sir.
Tell me what she said, and if you remember when.
I don't exactly remember when. I know it's over half of the trial had already happened, but the evidence was coming forth that it looked like he might be guilty, and she made a comment that guilty verdict would be better for the sale of books.
Okay. Now,
well, they can talk amongst themselves about whether they think he's guilty or not.
You had sometime during the trial. I don't want you to relay to me what was told you. Did you have a discussion with the clerk, Becky Hill, about her being with jurors on her own?
Yes, sir, I did. One morning I showed up to Colony County, and I was told that she had taken a juror home the night before. And I was in the courtroom and I saw her, and it was between the pews and where the back row pews are. And I mentioned to Miss Beck, I said, please tell me you didn't take a juror home last night. And she told me, she says, I did, but I didn't talk about the case. I had a bailiff with me, Mr. Bill.
Oh, my Lord in heaven.
I said, Becky, you don't do things like that.
Holy shit.
I thought we had stopped everything. It wasn't far enough along to really
that's two lies.
Cause a major problem, or I would have told Judge Newman. But I thought we had to understand that you did not spend time alone with the jurors.
Okay. Now, I'm going to read you some statements. Well, first of all, did you ever hear her say anything in front of you to a juror about whether or not, on the merits of the case, that is, whether or not he was guilty or innocent, or what you should pay attention to? Did you ever hear her, what, if anything, did you ever hear her say to a juror or in the presence of a juror? Anything?
No, sir.
Okay. But let me ask you if you've ever heard her say these statements, and if so, to who? Don't be fooled by the evidence presented by Mr. Murdaugh's attorneys, which I understand. Do not be fooled by the evidence presented by Mr. Murdaugh's attorneys. You ever heard her say that?
Your Honor, this time I would object. This witness was specifically called as a Rule 16.3B extrinsic evidence. I think we've covered the two grounds that would be permissible for her to testify to, and I believe that should be the extent of her testimony. So we would object any further extrinsic evidence as improper impeachment and also irrelevant. I think that the issues that were raised with the prior witness have been covered, and that was the express reason that this witness was called, and Your Honor allowed the testimony.
Overruled. You may continue.
Thank you. Did you ever hear her say that?
Can you repeat the verbiage?
Don't be fooled by the evidence presented by Mr. Murdaugh's attorneys.
Yes, I did.
And who was it said to?
It was said to me.
Okay.
And sometimes it might be a staff member in our office or someone from the media there. But other than that, I didn't hear her say it out there in front of any jurors.
Did she ever say to you or to other people around you, I'm not talking about jurors, watch him closely, talking about Mr. Murdaugh. This is just before he testified. Look at his actions. Look at his movements. Did you ever hear her say that?
Yes, sir.
Okay. Did you ever have any conversations with the bailiff, Mr. Bill?
Yes, sir.
Did he ever discuss with you the clerk's contact with jurors?
No, sir.
Okay. Did you ever hear her say that the defense is going to try to confuse the jurors? Did you ever hear her say that?
No, sir, I don't think so.
Okay.
She's a very credible witness.
Now, let me deal with one last area. Let me see if I can simplify this. There was a setup in the courtroom. Pardon me, I've got a little frog in my throat. I'm fine, thank you.
I think I'll share my bottle over here if he wants part of it.
Once a clerk, always a clerk. Your Honor. So, and I was there, you were there, this judge was not there. And prosecution tables over here, defense tables over here, judges up here. And then there's a rail behind which the clerk was. And because of all the massive electronic equipment we had there with big screens, there was an area over on my right facing the judge. And then I think you were located in that area right between the judge and that area. Is that correct?
Talking about in the well area?
Yes, ma'am.
Okay, yes, sir. For
Now-
the most part, now sometimes I was out there with the screen
Right.
in the gallery.
Right. But there was a screen on which you could see not only what the gallery back there could see, but the images that only the jury was supposed to see that were under seal. Is that correct?
That is correct.
Now, there's a woman named Rhonda Ryder, correct?
Rich.
Rich. And tell me who she is.
At the time, we did not know who she was. The first time they were there, we didn't know. Then she came into Miss Becky's office the night before, and she asked if she could have another seat in the courtroom for the next day. And Miss Becky said yes. And she says, and what's your name again? And the only reason why I remember Rhonda, because of course my name being Rhonda. And the next day, Miss Rich was sitting, I don't know how to tell you, but she was sitting. Do you know where Doug was sitting?
Yes, ma'am.
All right. I know, Judge, you don't know where Doug was sitting, but anyhow.
But Doug was the audiovisual guy, and he had access to the unscreened, the unsealed images, correct?
I like
Yes,
her.
sir.
I
And
like
she
her.
was sitting right next to him, right?
Yes, sir.
Okay.
In that little part. And
So she could see the body cam, she could see the unredacted corpse pictures, the autopsy pictures, all the photos that the judge had done.
Biff, it's right there scrolling
Oh, no,
across the
all
bottom
she
of the
sees what
screen.
was
She's
being
the
put up
clerk
at
of
the
the
time.
county in another county,
Okay.
as they
Barnwell
were put up,
County.
you could see them.
right, but they tried their best to seal it where you couldn't, but you could still see it there. I didn't see any of the
Right.
photos, okay?
But she could see them.
Right, and Doug was really having a problem with that. And I can also tell you that our court reporters didn't know who she was either, okay?
Okay. And she turns out to be a writer, correct?
Yes, sir, after I found out, yes, sir,
And her name is Rhonda Rich.
correct.
She was given access to areas that only court personnel should have had access
Right,
to.
but then we broke, and then she moved her in the well with me. She was about on my left, and either Elizabeth or Mike was on my right. And I noticed she was taking notes. And I asked her what was she doing, taking notes. She says, I'm a Sunday school teacher. Well, I immediately covered up everything I had.
You don't trust Sunday school teachers?
So,
You don't trust Sunday school teachers?
let me just, there's too many preachers in my family on both sides, okay?
So you determined she was not a Sunday school teacher and later learned that she was a writer writing about the Murdaugh case, correct?
Now, I don't know if she's ever a Sunday school teacher or not. There's just, I don't even know where she goes to church or anything, so I can't tell you that answer. But I did find out that she was a writer because shortly after she was put there, and evidently after I covered everything up, shortly after that, Judge Newman asked for a recess so we could find where people were going to be working.
Rhonda should have wrote the damn book.
She put Miss Rich out in the gallery in control of that screen.
But she has too many ethics.
Ended up writing
her ethics are too good for her to write a book. She should be the writer.
Book, is that correct?
Yes, sir.
Okay. And Becky gave her access to area only court personnel should have had. Is that correct?
That is true. But now I'll be honest with you, sir. There's been a couple times when we had other people that were sitting on that side. We weren't planning on seeing sealed documents that day.
Right.
But there were some other people that sat there, but nobody that actually sat in the well that wasn't court people.
Okay. Thank you, Court's indulgence.
Mr. Waters, on cross-examination. Thank you, Your Honor.
That was good questions. Good answers.
Judge, do you have an extra bottle of water up there by any chance you're willing to share? Oh, Miss Elizabeth's got one. Thank you.
Hydrate, Rhonda, hydrate.
Ms. McLean, how you doing today?
I'm good, sir. Please call me Rhonda.
I always called you Miss Rhonda. I've known you for a long time as well. In fact,
Yes, sir.
I tried one of those murder cases in front of you years ago. Right.
Yes, sir.
Wanted to ask a couple things. I won't be that long.
That means it's going to be long.
One of the things that you said earlier is you said when you initially were talking to Miss Hill, she said something like, we ought to write a book or something.
That is correct.
Okay. And so did y'all have any further discussion about you writing the book or participating with the book?
Oh, no, sir. I'm crazy enough not to write one.
Okay.
There you go.
During the course of after the trial, she did send you like chapters and things like that to take a look at.
I did get to see a couple of drafts of the manual.
Okay, so she did send you those to take a look at and review and that sort of thing. Is
Correct.
that correct? Okay. All right.
This dude's face makes me angry.
And you were asked and again, Your Honor, just to be clear, I'd made some objections.
You do not waive any objections by cross-examination. They are all preserved. You may proceed.
Thank you. You mentioned, some statements that you attributed to Ms. Hill, during the course of conversations during the course of the trial. Is that correct? Just things like watching closely, watches mannerism, things like that. And where were those conversations? Were those conversations taking place back in the clerk's offices with clerk staff and people like that?
Yes, sir. In the clerk's office. It might have been downstairs in the bathroom.
Okay.
Some of us had privilege to go to.
All right. So you and Miss Becky and other court staff maybe just discussing the case and that sort of thing. Is that correct?
That is correct.
And people were expressing their opinions about what was going on and that sort of thing. Is that correct?
No, when we were having those discussions, there weren't more than one or two, maybe three people there.
Okay. But just a few people there just talking back behind the scenes. That's what I'm driving at.
Yes, sir.
It was behind the scenes. And it's not uncommon for, clerk staff behind the scenes, not to the parties, not to the litigants, not to the jurors, but among themselves back in the hallways back there to talk about the day's activities and things like that. Is that fair?
That's correct.
Okay. And that's a big difference between the natural conversations that people that work together, court staff and the like, have with each other and actually having those conversations in front of the jurors, right? There's a big difference between those two, correct?
Yes, sir.
Okay. And it's not uncommon for you. You're a clerk of court. You got people that work for you. Y'all are going to have private conversations about what's going on that are not to be shared, particularly with jurors, but with the public as well. Is that fair to say?
That is true.
Okay. All right. And so there were conversations like that going on that you were privy to and part of. Is that correct?
That is correct.
Okay. All right. And you mentioned a little bit about, well, let me ask you this. So there are all these conversations going on, and that's natural. That happens, private conversations with court staff behind closed doors. But you never once saw or observed or had anyone tell you that any of those conversations were being shared by Miss Becky with any juror. Is that right?
That is correct.
All right. And if that had happened, if you had observed anything untoward or improper going on at this particular trial, you would have immediately gone to Judge Newman as part of your obligation. Is that correct?
That is correct.
And you never did that because you never observed anything like that. Is that correct?
That is correct.
Okay. All right.
He's getting good questions in, but he's performing for a jury that's not
Now,
there.
You were asked a little bit about
He doesn't
Rhonda
have to be
Rich, who was a
shouty.
member of the media, and how she was placed kind of back where the defense IT guy was. Is that
No,
correct?
I didn't say she was part of the media, sir.
Okay, well, she was a writer.
Yes, sir.
Okay. All right. And then you said that eventually, though, Judge Newman stepped in, and then she was moved out into the gallery in charge of the screen out there. Is that
Right, but I don't know. I thought Miss Becky moved. I'm not saying Judge Newman did.
Okay. All right. And over there in that area of the, if we look in the courtroom, there was sort of the grand jury box over here, and that was where court TV was and media was stationed and that sort of thing. Is that correct?
That is correct.
All right. And inevitably, there were media members that could view some of the images that were being shown. They were just not able to report those just because of the nature of where the courtroom was. Is that accurate?
Well, I was told they couldn't see it, so I don't know what they actually saw because I didn't discuss it with the media.
All right. You never had a conversation with court TV or anything like that?
Other than the fact that be careful what they put on my front page of the New York Times on me.
All right. All right. And you're not aware of any image or confidential information or sealed image or anything like that that was ever made privy to Miss Rich that was put in any sort of publication or anything like that. Is that correct?
No, I'm aware of, sir.
Okay. Because if you had found out about that too, you would have immediately gone and reported that to Judge Newman because you would have said, that's improper. That I need to go report to the judge, correct?
Correct.
And you never once saw anything during the entire course of this trial that caused you to say, you know what, I got to go talk to Judge Newman. Something ain't right about what's going on here. Is that correct?
That is correct.
And you would have done that without a doubt if you had seen that, correct?
Yes, sir.
All right. Now, in looking at, back at this trial, you mentioned that there was a few days at the beginning of trial that you weren't there because you had your own court to take care of back in Barnwell County, correct?
Correct.
All right. And then pretty much after that, I guess you were pretty much present the majority of the remainder of the time. Is that fair to say?
I was. I had one medical procedure done. I missed 2 days, but basically, other
He's
than that,
trying to make it
I was
sound
there
like
every
she's
day.
contradicting herself
And there
when
was
she's
a period
not.
of time, though, during the middle of the trial where Miss Becky had a medical issue and had to be absent from the courtroom for about a week or something like that.
That is correct.
Okay. And during that period of time, you were present and functioning as the lead clerk of court during that period of time.
That is correct.
All right. So the reality is that you were present for probably as much, if not more than anyone in the clerk's function during the course of this trial. Is that fair?
Yes, sir.
Okay. And again, just to reiterate, there was not one time that you observed or came in possession of any information that you were like, I got to go talk to Judge Newman about this.
No, sir.
All right. Court's indulgence, 1 moment.
That hurt.
Nothing further. Very good. Mr. Harcourt, then?
Half a question.
All right.
Mr. Waters indicated to you that you were not aware of whether or not, and you agreed that you never witnessed her talking to a juror about the evidence. Is that correct? We agree on that. Do you know, but she did admit to you that she had been with a juror alone in a car for some period of time when you confronted her with that. Is that correct?
Yes, sir.
And did she indicate to you what she talked to that juror about while they're alone in the car?
No, sir. She told me, the only thing she told me was that she did not discuss the case, that she had Mr. Bill, the bailiff, with her, and he could tell her that. Tell that.
And when she said she didn't discuss the case, did you bring that up or did she bring that up?
She brought that up.
You didn't say shouldn't be with him because it's frowned upon?
I did tell her that I would caution her on doing that because the perception of dealing with the jurors one-on-one is not tolerated.
Is not tolerated. Thank you.
Thank you, Ms. McElveen. You may be excused.
That did not go well for the prosecution.
Call your next witness.
Your Honor, we would call juror 741.
I know you're not going to. Well, that's right. She's an alternate. That's all right.
We're not going to sign her a letter. We'll just go with 741.
I got you.
And Your Honor, while she's coming, my understanding is I'm limited to 4 questions.
Yes, sir. I have a copy, and I have given the court reporter a copy of this affidavit with the name obscured and the number, I think, as well. So, but the affidavit that supports this testimony that you're about to offer is Court's Exhibit 5.
Other than a little factual background about her getting picked for the jury and how long she was on the jury and
That's
that she got
fine.
excused. That's all we intend on asking these 4 questions.
All right.
Unless Mr. Waters asks.
Sure. I mean, they'll have cross-examination.
I'll be crossing, so.
He will definitely open the door.
All right.
He's limited to 4 questions initially, is that?
Yeah.
No, sir. He's just telling me that's what he intends to do. Sometimes you can hold lawyers to that, and sometimes you can't, Mr. Miller.
Yes, ma'am. Thank you.
I intend on only asking her those 4 questions.
That's fine. Yeah. Yeah.
And Weeb gifted 5 Legal Vices memberships quite a while ago that I didn't mention. I apologize for not mentioning that for about 30 minutes. We just got all caught up in things. And I didn't notice until just now. Thank you so much, Weeb. If you remember getting one of those 5 Legal Vices memberships from Weeb, give Weeb a super special thanks. Thank you so much, Weeb, for the support. Deeply appreciated. I apologize for the 30-minute delay.
Do you swear or affirm that the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God? Yes, I do. Thank you. Please have a seat. Please stand.
Your Honor, I assume the same rules apply to her that apply to the other jurors in terms of her image appearing.
That's correct. There'll be no photograph made of this particular witness who was an alternate juror.
Too late.
Thank you.
You might want to do that before she walks in front of the camera.
I'm going to refer to you as juror 741. It's what we got to do here, so we don't use your name, so people don't know who you are. Is that okay with you?
That's fine.
It's a bit late.
And you and I have met before.
Correct.
I came to your home one Sunday afternoon. I believe you're cooking Sunday dinner, and we talked. Is that correct?
Correct.
And then you were interviewed by SLED.
Correct.
And you gave them a recorded statement. And then this morning you came here and you gave me an affidavit that you signed, and you're here with your lawyer. Is that correct?
Correct.
Now, just for purposes of the record, you were a juror. You were selected to be a juror on the State versus Alex Murdaugh murder charge, correct?
Correct.
And you sat in the courtroom for 6 weeks and listened to all the testimony.
Correct.
And you were the alternate.
Correct.
And so when the jury went out to deliberate, you were excused. Is that correct? Now, I'm going to go through a series of questions based on your affidavit, okay?
Okay.
Which you signed this morning, which was based on our initial interview with you and your interview with SLED. This is basically the same thing you told SLED. Is that correct?
Correct.
In your affidavit, you say before the defense put up their case.
Sir? Leave. Overruled. Go ahead.
Thank you. In your affidavit, you said before the defense put up their case, Ms. Hill told the jurors, quote, the defense is about to do their side. They're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off, unquote. Is this true? Did Ms. Hill say that?
That's exactly what she told us.
I'm sorry?
That's exactly what she told us.
Okay. The next thing you say is Ms. Hill made the above statement warning the defense would try to confuse us in the presence of all the jurors as we assembled in the same jury room. Is that correct?
Correct.
Now, y'all were initially in two
We were in 2 separate rooms, and when she came in, we all went in one room.
Okay.
These jurors are a bunch of
Paragraph
liars.
number 5, Ms. Hill said, if you get emotional, we want to see your face because that is what they want to see. What does that mean?
She said, don't get nervous. Be afraid to show your emotions because that's what they want to see.
Who wants to see?
I don't know who she was speaking of. I'm assuming the court.
Okay. And then number 6, Ms. Hill also informed us Alex Murdaugh was going to testify, but I don't recall exactly what she said. All the jurors were assembled in one room when she made that comment.
Exactly.
She told you that Alex Murdaugh was going to testify.
Exactly.
Did you know before that he was going to testify?
I think we knew that he was going to come up. I think he was supposed to do it the day before, but he didn't. And I knew he was going to be the last person that afternoon.
Okay. During the visit to Moselle, juror number 826 and I walked to the scene together. Then juror 826 began walking with the clerk of court, Becky Hill. I could tell they were talking. I could not hear what was said between them. Is that correct?
Correct.
Is what you put in this affidavit truthful?
Yes, sir.
And this is what you told us back in
I don't remember.
August, I believe. I think I interrupted you cooking Sunday dinner.
Right.
All right, thank you. Please answer any questions defense may have for you.
Mr. Waters, or Mr. Meadows.
Thank you, May please, Your Honor. Good afternoon, Ms. 741. It's nice to see you again.
Yeah.
I think it's the first time you talked to Mr. Harpootlian or Mr. Griffin or any other attorney.
I can't tell you exactly. It's been months. It's probably been September, August. It's been months.
Okay. And were they the first attorney to talk to you, or was there somebody else that talked to you prior to them? Any other attorney?
No, I think he was the first person I talked to.
You sure?
I think it was so many people trying to call me, and I was trying not to be involved, so I can't quite remember. But he was the first person I seen.
First person in person?
Yes.
Okay. So when he came to your house?
Yes.
Mr. Harpootlian came to your house?
Yes.
Okay. And at that point, was Miss Holly with him? Holly, do you mind raising your hand?
We got 1,200 people here now. Thank you so much,
And was
everybody.
anybody else with him?
Yes. He was.
Mr. Griffin?
Mr. Griffin.
Thank you. And you gave them a statement then, right?
Right.
And did they record you? I mean, were they audio or video recording you? Did they say we'd like to record this?
No.
They didn't?
But neither did the people that came out. They didn't. I didn't know I was being recorded by them neither.
I'm not trying to fuss.
Oh, okay.
But is there an audio recording of your conversation with them that you know of?
No.
Did they say?
Not that I know of. No.
Okay. So you don't remember saying?
No audio recording. We're required to tell her if we're recording her under rules. We didn't record her.
He's on cross-examination.
Thank you, Ron. And at that point, and that was again, do you remember, you said you think, was that around the end of August, 1st of September when they first came and talked to you? Roughly?
Roughly. Okay. I don't want to.
And you told them basically everything that you've told us now, right?
Yes.
Exact same thing?
Exact same thing that I told them.
Nothing less, nothing more.
Yes.
So Mr. Harpootlian, just, and you didn't sign an affidavit back in September or when you talked to him the first time?
No.
And why not?
Because he was just coming out to talk to me. He just was asking questions. It wasn't nothing officially. He had, so.
When you say nothing officially, I don't know what you mean.
He was just coming out to ask, he was just asking questions about what went on during the trial. It wasn't.
But did they ask you to sign an affidavit that day?
No.
Okay. Did they ask you to sign an affidavit any time right after that?
No.
So they never asked you to sign an affidavit until this week?
No, I was supposed to meet with them a couple of occasions, but I was having my own personal issues and I couldn't come.
Okay. Well, I'm sorry about that.
No problem.
So you told them at this first meeting back at the end of August, 1st of September, that y'all going to hear some things that will throw you off. Don't let it distract you or mislead you. Is that what you said?
That's it.
I mean, normally you
didn't
ask
say
for
that. That's what the
permission,
clerk
but
of court
Yeah, I'm saying that's what
Oh,
you
yeah.
said to them. I'm sorry.
It's not a
Okay,
big
and where
deal.
did that take place?
She would always stand like on the outside of the jury room, like in between, like on the outside. She would never really come inside the jury room.
So there were 2 rooms, right?
Yeah.
Okay, one room.
I mean,
and
I don't
the
know how
other room
close he
separated,
is
right?
getting
Right.
to her,
You
but
couldn't hear people talk in the other room, could you?
No, that's why when she came, everybody came in one room.
Okay, so this
if I was the
comment
judge,
that you
I'd tell him
made,
to
did you bring
stay his ass
everybody
back
out
by
in
the
hallway?
microphone.
Some people was in the hall. That's why I said she was standing right at the head of the door.
Standing at the head of the door.
Right.
Was Mr. Bill there? Your bailiff?
Yeah, he would be standing in the hallway.
He's all out there, right?
Right.
And then she said in front of everybody, the defense is about to do their side. They're going to say things that will confuse you. Don't let them confuse you or convince you or throw you off. She said that to everybody.
She said that to everybody.
So everybody could have heard.
Everybody could hear it.
And you said you were all in the same jury room.
Yeah, we would all be in the same. When she came, she was standing in front of the door with the jury room that I was in, and everybody would come over. They would let us know before she came. They'll let us know like after lunch she gonna come talk to y'all, and we all would gather together.
So would you go from the 2 rooms into one room?
Some would be standing out. She would stand in front of the door. Some would be standing around her outside the door, and some would be in the room. But it was clear enough for us to hear and see her.
And I'm just, Mr. Harpootlian led you, and Ms. Hill made the above statement warning that the defense would try to confuse us in the presence of all of the jurors as we had assembled in the same jury room.
We was all in the same jury room. She would be on outside the door, and we would be in the room, and someone would be standing beside her. We was always all together when she came.
And do you think that was unusual?
No, because I guess she didn't want to walk back and forth to room.
No, the fact of what she said. Do you think that was unusual?
Yeah, I did.
And if you get emotional and see his face, they want people to see your face?
Because some of the jurors was getting emotional, and I guess she noticed it, so she commented on it.
And you said you didn't, the statement he read, she informed you that the defendant was going to testify, but don't recall exactly what was said.
After,
When was that?
That was, I think he came in that afternoon, like at 2:33. So that was before he testified, I think.
That'd be funny.
And where was it?
Oh, in the jury room, where we were all, like I said, we would all meet.
And I guess what I'm saying is you're in 2 different rooms for a while, right? When y'all get up there, you split, don't you?
Yeah.
The people that talk loud in one room and the others in the other. Pretty much.
No, it's not like that. It was just, they just split it off. They just asked us what room we wanted to go to.
So when you were fixing to come back to the jury room, to the box,
Mhm.
you tell us you'd all go into one jury room together?
Only when she came to speak to us.
And so you
Mr.
got to
Walker
ask,
then asked
what
you about,
possible motive would
leave
she
number
have
7 on
to lie
affidavit.
about this?
And when did you sign this affidavit?
This morning.
Those are the worst glasses a
When's
human
the
being
last
can
time you
ever
talked
wear,
to
by
Mr.
the way.
Harpootlian
No,
or
I haven't
Holly
talked to him since he came to my house.
or any of them before today?
No, I haven't talked to him since he came to my house.
Talked to anybody else involved in this case before today, since then?
No, he was talking to my lawyer,
Okay, and who was that?
Sean Wilson.
Okay, and when had Sean Wilson talked to you?
He's been my lawyer
Since when?
since 2021.
Okay, when Mr. Wilson talked to you about this case and what you told Mr. Harpootlian prior to.
All right. They apparently don't object to this, but I am very uncomfortable with your asking what her lawyer told her.
There you go.
I was just looking for timing.
Well, she's told you a couple of times that he was her lawyer since 2021.
Good
Is
judge.
he your lawyer for this?
For what you mean for this?
Well, like being a juror.
For being a juror?
Yes, ma'am.
I didn't have he was always my lawyer.
You didn't hire him for this.
Stop asking
No,
the
I didn't hire
goddamn
him.
question.
But he had talked to Mr. Harpootlian about your
No,
affidavit and your testimony today, hadn't he?
No,
Is that a
no.
Yes, he was looking over the paperwork. He was looking out for me because he's my attorney.
And when was he looking over the paperwork?
Oh, I guess ever since September, October, I don't. I
Guy,
wasn't really
the jury's not here.
keeping
The
up with-
judge has already
to
told
be
you
honest, 'cause
she's
I'm-
not happy with you
if he
asking these
talked to Mr.
questions.
Harpootlian this week.
Yeah, he talked to him today.
Called in today.
We was together.
Who was together?
Me and my lawyer.
And Mr. Harpootlian?
Yes, when I went to go sign the affidavit
Okay. Where'd you sign it?
at his office,
At whose office?
Mr. Harpootlian office.
Your Honor.
I was supposed to.
I would object.
Okay.
This meandering, I mean, there's no jury here. It's you. And I don't know what this is.
How about helping a little bit? I think we got all the information. Yeah, all right. I think he's gonna move on. Yeah.
I think he's going to move on. That's judge speak for move the fuck on.
And that's the last question Mr. Harpootlian asked you about this affidavit, isn't it?
What was the last question?
All right, Garrison Keeler, go back to Lake Wobegon
Say the
and
number, whatever the letter is, it doesn't matter. You saw a juror, and I walked the scene together, then the juror began talking with the clerk of court. I could tell they were talking, but I couldn't hear what they were said between them. That's the
Correct.
last question he asked you, right?
Correct.
So, and you have no idea what that conversation was about, do you?
No, I don't.
Now, the next, number 8, he didn't ask you about, was I also overheard discussions in the jury room that Mr. Hill drove a juror home. I believe it was a juror whose nickname was Boston. Now, he didn't ask you that a minute ago, did he?
No, but okay. No.
And you didn't include that in the first conversation you had with him back in August and September in this affidavit. Miss Holly did you? You didn't tell him about that.
What?
I can't remember.
Have you seen the affidavit Miss Holly did for you back in September 1st,
Objection, Your Honor.
2022?
Miss Holly did not do an affidavit. Miss Holly
She
did
just
her affidavit, her notes of what this young lady said to her, and what she included and didn't include was based on what Miss Holly thought was relevant at the time, but she
Yeah,
can't be
that
cross-examined.
affidavit's not in evidence, Mr. Meadows, so I think you need
We'd
to
offer
move.
it, Your Honor.
Sir?
I'd offer it. Just to.
Well, how is this thing gonna be authenticated?
Even more importantly, he can't question her. I'm sorry.
Several people can't talk at one time. Look, I don't even have the affidavit. Let me see what you're talking. You talking about the one that was just offered today?
This is one Holly did when he first talked to her back in August, and she's referring back to.
Miss Miller. Okay. Miss Miller.
This is Ms. Miller's affidavit about what she thinks this juror said.
Yes.
I'm not going to allow this, Mr. Meta. I don't see a whole lot of difference between this and what's been said in the affidavit that has been offered by Mr. Waters, but I'm not going to allow that.
good for you, Judge. Tell him to shut up.
You did not tell them about hearing that Miss Hill had driven a juror home back when you met with them in September, did you?
I can't remember.
Move it along, buddy. Let's go Lake Wobegon days.
Who is Boston?
She was a juror on the trial. I don't know her, but that was the nickname they gave her. I don't know her first name.
And what, if anything, did you know or convey about Boston?
She was a juror on the case, just like everybody else.
Anything else?
Nothing.
Ma'am?
No.
So again, Mr. Harpootlian didn't ask you, but when you, in the affidavit of today, I also overheard discussions in the jury room that Miss Hill drove a juror home. I believe it was a juror whose nickname was Boston. Is that something was added after your lawyer was with Mr. Hartookian today?
I don't know if I added it. We talked about it today, but I don't know if I mentioned it in September or not.
That's
But
the
I
first
know
time
it.
you've ever talked about it, wasn't it?
Your Honor.
No, it's not.
No reason
To raise objection.
The first thing is, Mr. Meadows, I'm going
Objection.
to caution you one more time about this. You cannot talk over
There
a
you
witness.
go.
The second thing is, you don't need to be marching all back around here. You talking only to me, not the jury or anything else.
I like this judge
So
now.
let's slow down, and, you know, this is repetitive of questions that have been asked before. If you want to take this tone with her, I don't know exactly what you're trying to accomplish.
I'm not trying to take Tony. I apologize. She knows that, and I'm sorry.
Well, she doesn't know
You're just
that.
talking to me.
I'm sorry.
This is not some drama thing for the jury.
I know. I'm sorry.
All right, well,
I'm sorry.
let's
And
finish
Judge,
this thing up.
The only reason I did it, what he hadn't asked about it, and it to me is the key issue here. They're trying to say was different.
Mr. Meadows, I mean, you lecturing to the witness or to me or what? Please don't do that. Strike that from the record, please.
Don't strike. Don't strike. I'm
Let's
so
line
sorry.
Let's line this up.
I am.
All right.
To Be Flair gifted 5 Legal Vices memberships. If you got one of those, make sure you give To Be Flair a super special thanks. Thank you so much for your support. You're awesome.
And number 9 in the affidavit, that before the jury began deliberating, I heard a member of the court staff say the deliberation shouldn't take long. I don't remember specifically who made it, but it was made in the presence of the entire jury right after closing arguments in the jury room.
Correct.
Then I think you said something, Judge Newman came to see you afterwards, but after the jury went to their room, you were in a separate.
No. When we first left out the courtroom, we all went. in
Dude, the
same
judge does not like
jury
you.
room.
Shut
And
up.
then they separated me.
You're making it worse
Oh,
for your
that's-
team.
That's okay. That's fine.
But when they started deliberating, were you in a separate room?
Yeah, when they started deliberating.
So you had no involvement in the deliberations or verdict of Richard Alexander Murdaugh? at
No,
all,
sir.
did you?
No, sir.
You didn't get to come back with the verdict, did you?
No, sir.
Judge is chewing her cud there, getting ready to lurch.
Have you read Miss Hill's book?
No.
Okay. And I noticed your interview. I did watch it. And I think Mr. Radford back there, you can raise your hand, kind of Radford, I think came to your place and interviewed you.
Right.
At some point during the trial, I think there was some discussion that somebody might have wanted to do an interview with you.
Yeah, that's what she said.
Okay. And then after the trial, I think there was some discussion. Somebody, since you weren't on the jury, they may not have wanted to interview you. You remember that, roughly telling the officer that?
Yeah, that's not what she said. She came to me roughly in the middle of the trial, and she said, I have a few people who would like to interview. She said, she didn't say a few. She said, I have a lot of people that's inquiring an interview with you. She said, but I'll have to get with you after the trial. But after the trial, she came back in the jury room, and she started handing out cards. And she handed everybody cards but me. And she was like, I don't have any cards for you for an interview because no one wants to speak with you. That's what was said.
And did, I mean, you weren't happy with that, were you?
Yes, I was.
You were happy with that?
I don't need to be interviewed.
Dave Portugal.
Angel Australia, thank you so much for the Aussie 20 super chat for a 1,000,000 shot espresso. Oh, that'll get me a few extra shots at Starbucks.
Briefly.
Thank you so much.
Briefly, Your Honor. Mr. Meadows just asked you a series of questions that I'm not sure I've heard before. Who approached you during the trial and indicated the media would want to interview you?
Miss Hill.
Miss Hill?
Miss Hill herself.
Just you or all the jurors?
They had, I think it's the day they had the bomb threat. And I think that was the day. And she approached me.
You?
Me, by myself.
By yourself. And where were you?
That's the day in the lunchroom when they had the bomb threat. We went to the middle school. I believe that was the day.
The middle school. And she came over to you and said what?
That she had some reporters that was reaching out to her that wanted to speak with me.
To you?
Yeah.
Not the whole jury, to you. Was there anybody with you at that time?
No. It was
Did
just
she indicate why they wanted to speak with you? Just you?
No.
Did she indicate what reporters?
No,
And did she ever talk to you about doing interviews with the media after that?
no.
But you indicated she brought some cards at some point
She brought cards in to hand to the jurors
before,
after
after
the verdict was read.
cards of media people.
Yes, sir.
Did she tell you she was writing a book?
No,
Did she indicate to you why it might be good for her if you did media interviews?
no.
But she had a conversation with you in the lunchroom of the
I
middle
believe
school.
it was the lunchroom. I think the day of the bomb threat.
The day
But
of the bomb threat.
I'm 100% sure she came to me and she told me that in the middle of the trial.
Was there a bailiff with her or just
No,
her?
it was just her.
Pulled you over and said, "Hey, I can make you famous. I can put you on TV."
She said she had media that wanted to talk to me. That's what she said.
Okay. I hyperbolize. I apologize, Your Honor.
Yes, sir.
That's all I have.
All right, no further questions, Mr. Harper?
No, Your Honor.
Very good. Thank you very much, ma'am. You are excused. All right, Mr. Harpootlian, that it?
I need to put one matter on the record, Your Honor, and that is it.
All right.
What else do you have to say, Dick?
Your Honor, earlier today, you received a very short affidavit from Juror Z. We'd like to proffer that and make it part of the record.
Right, I did not admit it, but I'll accept a written proffer, and if you would give the thing to me, I saw it on the screen on my law clerk's computer, but I don't have a printed out copy.
We don't either, but would you allow us to do that?
I will allow, before I close the record with Ms. Harris, if you can get it to us. When can you get it to us?
We can email it this afternoon.
Very well. How about do this? How about email it to Mr. Waters, to me, to Ms. Diaz, and to Ms. Harris, the court reporter.
Yeah.
And I will say now that it's offered as a proffer, and I will receive it as a proffer. I have not admitted it into evidence.
Yes, ma'am.
All right.
Your Honor, we referred to earlier on a email to the Japanese television folks. I do have copies of that. I'd like to make that part of the record.
All right, but hand it up to me and let me see it. And also, of course, to Mr. Waters. I got two of these, Mr. Harpootlian. I'll give you one back.
Is the judge watching your commentary? No, the judge is just smart like me. More Japanese. More Japanese. Yes, she is really 80 years old.
All right.
And Your Honor, for the record, the hearing before Judge Newman to seal the body cam videos was on May 26, 2023. This email is in July, just to give you the context of
All
what's
right,
going on.
and this is being offered as a after the fact email to Rebecca Hill, and her replies garnered from the emails that were released by
I'm Big in
Tom
Japan.
County, certain
Great
points.
song by
And
both
it
Tom
addresses
Waits and
the,
Alphaville.
issue I raised with Ms. Hill relative to the security of sealed records.
Exactly, Your
All
Honor.
right, I'll admit it. Mr. Waters?
As to this specific exhibit, Your Honor?
Yeah.
Your Honor, I mean, we don't have any objection other than the ones we've raised just generally to the testimony. But I have no further objection to.
Very
Your
good.
Honor.
All right.
Your Honor, that's all we would have.
All right, hang on. All right, have you got a copy of it there? I got it. This is his next exhibit. Proffer is his one. All right, your proffer is your exhibit one, Mr. Harpootlian, and this spot, which I have admitted, is your exhibit two.
Thank you, Your Honor.
All right. All right, now we proceed to closing. You prepared?
Yes, ma'am.
Very good. Mr. Waters.
Thank you, Your Honor. Just to go back and reiterate as to the standard, and ultimately, we've of course argued that the defendant has the burden. We've also discussed that the standard for Your Honor, of course, is first of all, was there any misconduct that occurred? And then regardless of that, whether or not there was any effect on the verdict. And the standard has been expressed in multiple cases is whether the verdict is solely the product of honest deliberation or the product of outside influence. And that inquiry fundamentally, as the court recognized from the very beginning, focuses on the jurors themselves, because it doesn't necessarily matter what was said as much or what was intended or what was inadvertent, even assuming that those existed. What matters is what the jurors heard, what they perceived, and whether or not it had any sort of effect on the verdict. And Your Honor went through that inquiry with these jurors. 11 of those jurors were clear and unequivocal that there was no effect on their verdict, and also clear and unequivocal that nothing was said that could in any way be inferred as any sort of attempt to influence them. And I think that's very important, Your Honor, because there can be sometimes behind the doors, as we've talked about, I think some of the cases recognize this, that some conversations can go on and things like that can happen. But ultimately, and while I think there were some cases cited in some of the various South Carolina decisions, that's unrealistic and not surprising to think that sometimes things like that can happen, an untoward comment or something was said. But that was an Aldrich, Your Honor, in the 1999 Supreme Court case. But the mere fact that something like that may be stated, that could be stated in a neutral reason, is not enough to undermine the verdict, because the inquiry ultimately boils down to what was it that those jurors heard, and in the end, though, did they listen to the instructions from the trial judge? Did they come to a fair and honest verdict? And Your Honor, the evidence here is overwhelming, I would say, from the people that matter, and that's those jurors. And that is, there was no effect on the jurors. And you saw every single one of them very clearly and strongly looked you in the eye, all 11 at least, and I'll get to the 12th one in a second, but looked you in the eye and said, no, that didn't happen. No, I didn't hear anything like that. No, there was no effect on our verdict. No, this was our verdict, and it was based solely, which was Your Honor's question, solely on the evidence and the law and the testimony at trial. And I think that carries the day. We have the one juror, and I want to make sure, because I'm about to say the number and I don't want to do that. Let me go back to Juror Z. And let's look at Juror Z and what she said, because Juror Z also said that, yes, I said this was my verdict. I was polled and said this was my verdict. Juror C also said that my verdict was solely based on the evidence and the law of the testimony at trial. Answer question number 2, yes. Absolutely, yes. But then goes on after that to say she heard some communications from the clerk, and then says, well, it had an effect on my verdict. Even after she had already answered question number 2, when she said her verdict was based solely on the evidence and the law and the testimony at trial. And beyond that, then, Your Honor, I think that it's very telling that the affidavit that was submitted from this particular juror, and we've been pointing this out from the beginning because it's very crucial and very telling, because
despite the things that she alleges that happened, even though the other jurors say it didn't, despite the things that she alleges that happened, she says that she voted guilty because she felt pressure from other jurors. Not that her verdict was in any way affected from some supposed external influence. In that affidavit that was filed with the defense motion from day one, that is what she says, that she felt pressure from other jurors. And Your Honor, we've cited the cases over and over again that the internal mechanics of the jury room, the fact that one juror feels pressured by others, as long as there's not violence or things that go beyond the pale, that is not a basis for undermining a verdict. That is part of the deliberative process, and it's expected, and it occurs. But I think it's very telling that we have those conflicting answers. And Your Honor, without waiving any objection to the latest affidavit that we were just discussing from this juror, I think that's very telling, because now we have answer number 3 as it relates to this particular juror. And of course, it is clearly manufactured and rehabilitated, recognized after the fact. She, of course, is this juror is represented by Joe McCullough.
Doesn't matter.
And ultimately, we've got now a third version of events from this very juror. So we have this juror who's given answers all over the place that are inconsistent
Like Becky?
with 11 other jurors who were very strong and unequivocal that, yes, this was our verdict. It was based solely on the evidence, the law, and the testimony, that there were no communications from Becky Hill that influenced that verdict. And I think ultimately when you look at the case law, in the end, it's up to Your Honor to make that ultimate determination and looking at all that law together. We cited a number of decisions, including, as we discussed, the questions to be had. I sent an email where we set out some questions that it's not uncommon, perhaps, because what that would do would be to consistently and constantly put every verdict that occurs in any courtroom in this state or in the nation at risk. Jurors don't have to vote in perpetuity. They vote on one day and one day only. And here, Your Honor, the evidence is overwhelming that those jurors' verdict was the product of honest deliberation. And the only bit of contrary evidence to that effect is from a juror who, frankly, not only said that it was purely the result of honest deliberation, but then has answers all over the place. And Your Honor, I would say that the other 11 jurors are credible. They were strong. They were clear with Your Honor. And I think that ultimately that carries the day. Now, we've had testimony from other people since the jurors were here. We've had testimony, obviously, from Ms. Hill. We've had testimony from Ms. Rhonda. And we've had testimony from this alternate juror. But again, none of that testimony at all goes to what is the ultimate test for Your Honor, and that is whether or not this verdict was the product of honest deliberation. And on that, again, the evidence is overwhelming and strong and clear that it was the product of honest deliberation. It's very interesting as we look at some of the testimony from the other witnesses. And obviously we have Miss Becky, and as Your Honor has pointed out, we're not here to go through some of the issues that have been alleged or are percolating out there. That's not the point of this proceeding here today. But Miss Becky is a court reporter and then became a clerk, and was clear to you that she never made any comment in an attempt to sway the jury one way or the other. We have Miss Rhonda.
Yeah, we had Ms. Rhonda. We sure did have Ms. Rhonda. We had Ms. Rhonda on the stand.
I would submit to Your Honor that this is kind of a red herring, because what Ms. Rhonda described were conversations that she herself admitted are just the kind of conversations that go on. And that's the reality of it. The conversations that go on among a trial team when we're not in open court, where we're discussing things, the kind of conversations that go on among court staff behind the doors.
But not usually in front of juries.
Conversations go on, but that does not mean, nor does that necessarily indicate that somebody's not going to come out here and do their job fairly and understand the distinction between influencing a jury and not doing that. And one thing that I think is very important is Miss Rhonda was at that trial more than Miss Becky was. And she was very clear. And I probably was as repetitive as anyone here today in asking that question over and over again because I didn't want that point to be lost. That Miss Rhonda said, I was there more than anyone else, and I never saw anything or observed anything or had anything happen that would cause me independently to go to Judge Newman, because that's what I would have done, to go to Judge Newman and say, something's not right about this. This needs to be fixed. Something's going on that's improper. And I think that that is an extremely crucial fact because Miss Rhonda admitted and said, of course, as she would, that if something had happened that the judge needed to know about, she would have been the first one to do it. And it never happened. And she was here more than Miss Becky was. It never happened.
Pancras says the
When you look at
prosecution
the
does not
balance of
want a
those
new
facts.
trial. He thinks he's going to lose if Murdaugh is
When we
retried.
have the clerk of court come in.
The prosecution never
testify
wants a retrial.
that, yeah, maybe I did
After
this,
they've got a
maybe I
conviction.
did that, maybe I plagiarized the book, a portion of it. Maybe I did this, maybe I wrote in things in there that are based on community knowledge or newspapers or poetic license or whatever you want to call it. I don't care about the book. And I would submit that Your Honor doesn't need to care about the book either, because the book and what happened with the book afterwards is not what is relevant to the inquiry. But she was clear that she did not have any attempt to influence that jury. She was clear about that. And Miss Rhonda was clear that she was not aware of anything like that either. And what does that do but corroborate the most important witnesses here? The defense, I think in one of their letters, tried to say that Miss Becky was the state's star witness, and that's not what this inquiry is about. It's not what this inquiry is about at all, because as I've said from day one, if there were not facts to be litigated, if we had not done an investigation and had those 11 jurors say, that didn't happen, there was no effect on our verdict. This was the product of honest deliberation. We would be the first ones here standing here to say that. But what we do know, Your Honor, is that what Miss Becky said and ultimately what Miss Rhonda said corroborates who are the true, if you want to say it, and I'm only using this term because the defense accused us of Miss Becky being our star witness. There are no star witnesses here. This isn't about stars. But what Miss Becky and Miss Rhonda do is corroborate who are the most important witnesses. And that are those jurors. And you have 11 of them strong as a rock saying this verdict was not influenced. Nobody tried to influence. And regardless, it was the product of our honest deliberation. And you have one juror who said that too, but then has answers that are all over the place. And if you go back to her original statement, what she says is not external influence anyway. It's not sufficient under the law. So I think that the proof here is overwhelming. I think the proof here corroborates what those jurors say. I think the only juror that we have to contend with, her testimony is compromised. And
I think you're wrong.
That person is in here maliciously lying. I just think that this process is a lot. But it's clear that if there was any attempt to influence this jury, those jurors who sat in that box, every single one of them, you saw them, and we saw them for 6 weeks. They are conscientious. They take their obligations seriously.
Except for that one, right?
They were not here to reward friends or punish enemies. They were here to do their job appropriately.
Except for the one you disagree with, right?
You saw that in their eyes. You saw that in their mannerisms. You saw that in their demeanor. And they were strong and clear that this verdict was fair. Your Honor, we would submit that the motion for new trial be denied.
Mr. Harpootlian.
Mr. Harpootlian.
All right.
All right, well, he's coming up again. I just want to thank the 1,227 of you that are here right now for being here.
Trying to make my points. Your Honor, I want to first start with State v. Green because I understand that that's the guidance. That's what we're following here. And reading, excerpts from State v. Green, first, it is absolutely clear in State v. Green that we find ourselves, and the issue is whether there's a defendant's right to a fair and impartial jury under the Sixth Amendment has been violated. Reading from the opinion, it says, in the Sixth Amendment's context, the Supreme Court of the United States has held that, quote, any private communication, contact, or tampering with a jury during a trial about the matter pending before the jury is deemed presumptively prejudicial. Now, Green goes on to say that we are not going to categorically apply the presumption whenever there is a contact with the juror. But the question is it prejudicial? Not whether the verdict would have been different. It is it prejudicial? And I'll keep reading. The court says we're not persuaded that the Rimmer presumption of prejudice, we're talking about prejudice, not is the verdict different? It was their prejudice. Was this tainted process? Was it prejudice to the defendant? Was the process prejudicial to the defendant because of extraneous communication? Not whether the verdict would have been different, but whether there's prejudice involved in the process of the trial.
Not whether it was,
the court goes on
whether
to say,
it could have
our
been.
unwillingness to categorically apply the Rimmer presumption of prejudice stems from our view that not every inappropriate comment by bailiff to a juror rises to the level of constitutional error. Goes on to say the attempted bribery of the jury and Rimmer conduct, which goes to the heart of the merits of the case, is a far cry from the circumstances presented in this case. The bailiff's actions here, though improper, did not touch the merits, but only dealt with the procedural question of how the judge might handle a jury impasse that apparently never materialized. The court says, while we decline to adopt the Rimmer presumption of prejudice in every instance of inappropriate bailiff communication to a juror, the occasion of this case presents an opportunity for our clerks of court and circuit judges to ensure that all bailiffs are properly trained. Now, the only thing the Green did was reject the presumption of prejudice in every case. And Your Honor, I just want to preserve for the record that our position is that the comments that you heard in this case go to the merits, go to the heart of the defense. And if you find that those comments were made, and I'm going to establish for the record, we clearly have proven that then we do get the Rimmer presumption, that we do get the Rimmer presumption if we have proven these comments were made. But I'm going to argue that we proved prejudice also in this case. So to start with, let's go to the evidence that was presented since Friday. And Your Honor, we have 12 deliberating jurors. In this case, what you've heard, 3 of the 12 have testified under oath that they heard Ms. Hill make comments about the case.
That's enough.
How they categorize it,
enough for
merits
me.
or not. But Juror X on Friday acknowledged that Ms. Hill made a comment about Alex was going to testify, that it was going to be epic or some words like that, and that defendants don't normally testify. That's what Juror X said on Friday.
Yep.
Today, so that's one who says Ms. Hill made a comment about Alex's testimony, how it's going to be a big deal, and defendants don't normally testify. Juror Z today says that first she says Ms. Hill said to watch his actions, to watch him closely, and then she said there are other things that he said I don't remember, and then we were allowed to show her, and with Your Honor, I asked her questions about her affidavit, and she says, confirm what was in her affidavit, that Rebecca Hill told the jury not to be fooled by evidence presented by Mr. Murdaugh's attorneys, which I understood to mean that Mr. Murdaugh would lie when he testified. She also acknowledged, this is a truthful statement, that she instructed the jury to, quote, watch him closely, close quote, immediately before he testified, including look at his actions and look at his movements, which I understand to mean he was guilty. And she also said and confirmed that Ms. Hill said when they began deliberations that this, quote, this shouldn't take us long, close quote, and that if we deliberated past 11 p.m., that we'd be taken to a hotel. Those statements go to the merits. Those statements go to the heart of the defense. Those statements go to what Mr. Murdaugh, his credibility. So that's 2 deliberating jurors down. The 3rd deliberating juror who testified today is Juror P. And he says, you were asked, Juror P, did Ms. Hill make any comments about the case?
I think so.
He says, yes. She said the day that Alex was taking the stand,
prejudice.
Excuse me, Juror P is a he, but he is saying that she, Ms. Hill, said the day Alex was taking the stand, that she, Ms. Hill, made the comment about watch his body language. That's all I recall. So 3 of the 12 deliberating jurors heard Ms. Hill speak about Alex Murdaugh's testimony. 3 of the 12. And then we get the alternate juror came in and basically corroborated what those 3 of the 12 heard. And she had additional things that she had heard, but she corroborated what those 3 of the 12 heard. And then you've got Ms. Hill who gets on the stand and denies it all. And Your Honor, I couldn't agree with you more that you're able to judge the credibility of witnesses. And on this record, there's no way to find Ms. Hill credible.
No way at
to
all.
credit her statements that she did not make these statements about his testimony. I mean, she crossed herself up as Your Honor is questioning her about the transcript involving the egg lady and how the egg lady learned that there's some Facebook post that was allegedly attributed to her husband. There's no way the egg lady would have known that unless Ms. Hill told her, and that pretty much came out there. I mean, so, you know, and I know this is not a jury argument, but if someone misrepresents a fact to you once, I mean, I don't think you should go back and credit anything beyond that. What we hear from Ms. McElveen is that she heard these almost identical statements from Ms. Hill that Ms. Hill told that 3 of the 12 deliberating jurors heard and the 4th alternate heard. That Ms. McElveen heard her make very similar statements about the defense's case, about Mr. Murdaugh's testimony. So you got to put Ms. McElveen's testimony in our category. And Ms. Hill gets up there and says, never drove a juror home. Ms. McElveen's got no dog in this fight. And she says, she goes to court one day, she hears that Ms. Hill took a juror home the night before and went and talked to her and said, you can't do that. Ms. Hill said, I didn't talk to her about the case. Well, she gets on the stand under oath here and tells you, I never took a juror home. I mean, it's totally inconsistent. And for her to say, I never made these statements, you know, she tried, I mean, she kind of gave herself a little wiggle room at the end. Well, when they were lining up, I may have said he's going to testify today or something, but these jurors heard this information. And the question under Green and Rimmer, was it prejudicial? Now, what we got from Juror Z today, the question was, did these comments influence your verdict? And Juror Z says, yes. Then you ask how. And Juror Z says, to me, it felt like she made it seem like he was already guilty. Then you said, did it affect your finding of guilt in this case? And the answer was yes. And so that's prejudice, Your Honor. That is prejudice from one of the 12 deliberating jurors. Was your verdict influenced by what Ms. Hill said? And good grief, how could it not be? How could it not be? And to ask all these other jurors who heard the same thing, was it influenced? It is really an impossible task because you don't know what's influencing a jury. And frankly, that's why the Rimmer presumption is there. But let's try to sort this out. And Your Honor, I think it was a State v. Kelly case where the deputies went out and they were investigating the jurors' beliefs on the death penalty, and there was really no testimony about did that affect your verdict, but it was just so wrong. The conduct was so wrongful that the Supreme Court says that's prejudicial, and we're granting a new trial. I mean, this is prejudice, and this has been proven. I mean, Ms. Hill is not credible. Ms.
Not
Hill
at
is
all.
not credible.
Not
She's talking
at
about her
all.
book, talking about taking literary license to lie. Literary license to lie is what that's what she thinks a literary license is.
Yeah.
So her testimony should not be credited. We have proven, we have met our burden of proving that there was extraneous contact with these jurors. 3 of the 12 deliberating jurors have testified to that. 1 of the 12 says it influenced my verdict. How is that not prejudice? And that's all we have to prove. We believe, for the record, there is a presumption of prejudice that they have to overcome, but we have proven prejudice. And Your Honor, we respectfully request that a new trial should be granted based on the record developed today.
Do it, Judge. Grant that retrial. Wake up, Judge. Wake up, Judge.
All right. The arguments are closed. I will take until 5 of the hour to examine my notes, and then I will come and make a ruling from the bench on this matter. Court will be at ease.
Oh my gosh, she is going to give us a decision in 10 minutes. 10, 15 minutes. Oh my gosh, I did not expect her to be giving her ruling today. As I said earlier, I was expecting a week or 2 for her to consider it. Wow. Just when I thought it was safe to go to sleep. Damn. All right. Well, there you go. Angel Australia member for 4 months says just rah. That's an acceptable comment. Thanks. Tank Rat, wasn't the book sold as the truth behind the scenes of the trial, not a work of fiction? Well, that's how it was. That's how it was sold. And then suddenly today it's full of literary license, exaggerations, literary ease, as she was calling it. Yeah, that's how it was all going down until today. It was truthful until today. Well, unless you count the 12 pages of the introduction that were plagiarized. And Nancy Korenzek, is caffeine? Oh yeah, there'll be plenty of caffeine. And Shannon 7. If second trial, can Alex's testimony at the first be used? The general basic answer to that is yes. It was a former sworn statement, so it could be. Again, exceptions depends on a bunch of factors, but generally, previous trial former testimony can be used against you or not even against you. It can be used in a following trial, in a retrial. She said 5 minutes from the hour. So I'm assuming that means 5 minutes before the hour, not 5 minutes after the hour. She wasn't very clear from that. So 5 minutes from the hour, you're 5 minutes away from the hour. So you're not there yet. So it would be 12 minutes from now. And we got, it's In Exile. Thank you so much, In Exile. If she was the trial judge, this would have been a 2-week original. Yes, it would have been, which I think is what it was originally supposed to be. I think it was originally supposed to be a 2-week trial until we got off into financial crimes land where all that was being brought up. Legal advice beginning. But can they motion for and against all the crap that Newman allowed? and is allowed. It would just be a retrial. If you get, if he decided to take the stand again, could be, but like they're not just going to retry absolutely every issue. It would be a do-over. They would start again. And I would suspect that the financial stuff ain't coming in. For one, well, see, that's an interesting thing. Now he's already pled guilty to the financial crimes. So whether or not his convictions on the financial crimes would be allowed in, that would be an interesting question. But 10 minutes potty break and a power nap. My prediction. Oh my gosh! Don't ask me for my prediction. My original prediction walking into this today was I strongly believe there should be a retrial based on, let me show my handsome mug over here. My initial thoughts walking into this were that there should have been a retrial. There should have been a retrial. That was my initial thought. What am I looking to do here? My cognitive functions are starting to fail me. That's not what I wanted to do. That's definitely not what I wanted to do. Whatever. We'll just do this. Why not? I don't care. I just know that this is the one that I really don't want to do. But my brain is shutting down here. As we walked into this originally, my original thought was I think there should be. I'm convinced there should be a retrial based on what we've seen today. But my gut was telling me no. My gut was telling me no, that they wouldn't do it, that the judge wouldn't do it. But I was not expecting that absolute crushing of Becky Hill. I expected a lot of pleading the fifth, to be honest, given that she is under two separate investigations relating to this. I didn't expect her to be crushed so hard by Harpootlian, and I certainly didn't expect the judge to come down on her like a ton of bricks. The judge's withering examination of her was completely outside of anything I was expecting. And so having gone through that, seeing the attitude the judge took during her questioning of Becky, it wasn't confirming Becky's story. It wasn't questions that was designed, it wasn't the softball questions designed to get Becky to say the right things. It was designed to impeach her and crush her. And the judge just said, even after everything was done, she was mentioning how that she had contradicted herself. I want to say I think the judge is going to give a new trial. I want to say that. But I can't say this is what I think. I'm still stuck in the hope mode. My gut is saying 60% she'll give a retrial, 40 she won't. So it's just, my gut is split 60-40 right now. But I was damn near 100% certain that there wouldn't be a retrial when we started today. Okay, yeah, let's do the same poll for the fourth time, shall we? Same poll, fourth time. Let's see here. So, all right, the last time we took the poll, the first two times we were in this, it was 69%, then 63% yes, and then no, and 8% for hell no. Right now we're sitting at 82% yes, 15% no, and 3% hell no. Let's look at it now that everything is completely shut down and done. We're just waiting for the judge to come back with the verdict. So let's take the poll again. We've never done the same poll 4 times in one hearing. So yes, no, and let me add hell no. And to the 1,272 people of you that are here right now, make sure you've hit the like button. Make sure you've hit that subscribe button if you haven't already done so. And take our final like and subscribe poll on this. Will Becky Hill's alleged shenanigans result in a new trial? Yes, no, and hell no. I so desperately want to say yes. My gut is leaning towards yes, but I just know that it would be wild if that happened. So I'm going to say yes. I know I'm going to be disappointed for saying that, but I hope I'm not, but I might be, but probably, I don't know. I haven't been this excited for a verdict, or not a verdict, a decision in a long time. I'm really, really excited and curious to know how the judge is going to rule on this. I'm jinxing it because that's it. Okay, we read that one. And Knox Fuse, assuming a new trial, where do you find a jury? Well, that would be a question, wouldn't it? Probably not in the same county where they were. Probably in this judge's courtroom. I mean, you just have to find an unbiased jury. It's not a jury it's not a jury where none of the jurors have ever heard anything about the case. Even if you hear something about the case, can you still be unbiased and follow the law and the court's instructions in your verdict? And this judge here has been assigned to handle all matters relating to the criminal trial. So I'm assuming that if there's a retrial, she will be hearing the trial. That would be pretty damn awesome. Mike says he's still in Korea. Are you talking about me? If you're talking about me, yeah, I'm still in Korea. I've been here 35 years. Where I'm not going anywhere. There's nowhere for me to go. I'm not going anywhere. Somebody else asked what time it is. It is 6:51 a.m. here. My alarm to wake up is going to go off in 9 minutes. So there we are. But if she wraps this up in a hurry, if she wraps this up in a hurry, I can still, if I hurry, get 90 minutes sleep or so. Normally I start work at 9 a.m., but as long as I'm kind of in the office somewhere between 9 and 10 a.m., that's good. So I could bump it back to 10, which would give me about 90 minutes of sleep. But of course, I would be afraid that I'm not going to wake up, so I'll wake up every 10 minutes and it won't be a restful sleep. Ooh. Boy, this is tense. I wonder how this is going to turn out. It might be. I actually got a bit of sleep before the trial too. I got a couple of hours sleep before the trial, so I'll be good. Then I can take a little bit of a nap at lunch. Now, one thing that I guess we can talk about what's coming up, because she's wrapping this all up today. Ooh, the camera's back on. Because the court is wrapping up today. Tomorrow, Tuesday, I will most likely be doing the Aguilar Mendez case, which is the case of the Guatemalan boy that was jumped upon by 4 large police officers. This 5 foot 415-pound 18-year-old kid who doesn't speak English or Spanish. He speaks an obscure Mayan dialect that not many people on earth speak. He was jumped on by 4 cops and tased for allegedly trespassing, which it just wasn't. It just wasn't. You know, it just wasn't. There was no viable Terry stop either to stop and talk to the guy, question him, search him, and certainly not take him into custody. And these 4 cops jumped on him, tackled him, tased him 6 or 7 times. They eventually got him into the cop car, and a few minutes after they got him handcuffed into the cop car, the first officer on the scene dropped dead. He was 52. He was suffering from heart arrhythmia, hardening of the arteries, clogged arteries. He had high blood pressure. He was recovering from bronchitis and back pain. And they charged this kid originally with felony murder of a law enforcement officer. And they reduced that to aggravated manslaughter of a law enforcement officer because the guy dropped dead 5-6 minutes after that. So we're going to be looking at a bond motion to reduce his bond, as well as a motion to dismiss the charges. And we'll also look at the there's a change.org petition to release him and to drop the charges and release him, which has at this point, I believe, over 500,000 signatures. So there we are. That's what we'll be doing on Tuesday. Wednesday, we'll be having Jules. Jules from the Maya Kowalski trial, the court observer there. We'll have Jules on to talk about her situation and let her tell her side of everything that went on and everything that was being said about her, get her response to that. Thursday will be O.J. Simpson Day, where, again, we're going to continue with the closing arguments. Barry Scheck is giving his closing arguments for the defense. That's what we're going to be watching. And Friday is up in the air. If we can, we'll have Mr. Fitz from Fitz News on if we can on Friday. If not, I will probably most likely be doing the interview of Sadie in the Zachariah Anderson case, the police interview for Sadie, the ex-girlfriend that essentially turned the police on to Zachariah Anderson. That's kind of what's coming up for the week. All right. The judge is not here at 6:55, so perhaps she did mean 5 minutes after the hour. I hope not, because I want this thing to be over with. Yeah, I have it down somewhere. I'll be putting up it in the links when we do it tomorrow night. I have the link somewhere. But well, that's what we'll be looking at the bond motion and the motion to dismiss tomorrow for Tuesday. Yes, probably most likely. Rosalind Duke, that's probably most likely what we'll be doing on Friday, unless something goes wrong. Or tomorrow's, whichever one I said probably most likely for. Things change. Yes, it's 16:57 now. That is correct, Flux. There's the change.org link. All right, we are just waiting. We're just waiting for the results here. This is fascinating. Waiting. Nah, it's not 15. It's not 14:57 in my homeland. You're in my homeland. It's not. Is it 2:57 there? Yeah, maybe. I guess so. Yeah, I guess it is 2:57. Correct. Oh, no. I didn't expect the ruling either. I was expecting a week or two. But she's ready to go. And I see now my gut is second guessing itself. Now my gut's going back to she's not gonna give him the retrial on this. Yes, 2:57 is Mountain Time. That is that's my homeland. I just had to do the math. I had to go back from Eastern Time. Well, let's see what you guys all think here right now. There's 1,285 of you here, and we have 439 votes. There's like 800 of you haven't voted. anybody that's here and listening, with the 1,290 of you that are here listening, get over here and vote. I want as many people to vote in this as possible. Take the poll over here that's in the chat. If you can, if you're driving, don't do it. If you're asleep, don't do it. If you're, if you're available to do it, take our poll. I want to get as many people taking the poll as possible. Right now, 86% say yes, there's a new trial. 12% say no, and only 2% say hell no. So the adamantly no, under no circumstances will we be having a new trial, has dropped from 8% to 2%. And the yes has gone up from, went from 69 to 63, now back up to 86%. So that's a significant change. Oh, there's my alarm to wake up. It's time to wake up, people. Yeah, let's see if the poll is actually right for a change. Right. I'm thinking this is a fake Steve Gosney. This is not logged in mod Steve Gosney with the proper with the proper profile picture. So don't know if that's the real Steve Gosney or if that's just a troll. Jeff is not behind on the stream. Why would I be behind on the stream? Why would I be behind on the stream? Danielle says Steve has multiple accounts. Is that but is that a real one? We just don't know. He was here on the usual one already. And this potentially imposterish one popped up. Why would he be behind on the stream? That's weird. Steve said he was driving home. Maybe, I don't know. Well, if he's driving home, he shouldn't be texting repeatedly. In-car Gosney.
All rise.
Oh, here we go. In-car Gosney, stop texting and driving.
Please be seated.
Here we go.
In the matter of State of South Carolina against Richard Alexander Murdaugh, 2022 GS 15-00592, 593, 594, and 595. The following constitutes my ruling on this matter from the bench. This order will be supplemented, as I will explain, after proposed formal orders are received from each side in this matter. This case is unique in my 20 years of experience as a lawyer and my 35 years of experience as an active justice of the Supreme Court and a senior active trial and appellate judge. Usually matters involving possible improper contact with or conduct of a juror arise during or shortly after the trial. The judge then puts the affected juror or jurors under oath, conducts an examination, and rules on the request for a new trial or a mistrial. In this case, I was appointed almost 9 months after the trial to replace the trial judge who was recused. It is now almost 10 months after the verdict was rendered and sentence imposed in this matter. It is now on appeal to the Court of Appeals. Several months after the appeal was filed, the defendant moved that his appeal be suspended and this matter be remanded to the trial court to consider his motion for a new trial on a charge that the clerk of court for Colleton County tampered with the jury by expressing her opinion to the jurors about what their verdict should be and about the credibility of the defendant who had elected to take the stand and testify on his own behalf. Since this matter has been remanded to me, I have set the matter for a pretrial and a final hearing, conducted a telephonic status conference with the attorneys for the parties on December the 21st, 2023. I have received briefs from the parties. I conducted a pretrial proceeding on January the 16th, 2024, in which I invited briefs and arguments by the parties and by the attorneys for certain of the jurors and for the clerk of court, Rebecca Hill. On Friday, January the 26th, 2024, I conducted a hearing on this matter in which I took testimony from one of the jurors. The conduct of the examination conducted solely by me. I received further argument from the attorneys for the state and for the defendant. Today, January the 29th, 2024, I have taken sworn testimony from the remaining 11 jurors who rendered a verdict in this case. This examination was conducted solely by me. I have found no case that provides otherwise in the many cases I have read on the subject of a motion for a new trial on the basis of after discovered evidence of jury tampering or misconduct. I have also received sworn testimony from the clerk of court, Rebecca Hill. Direct examination was conducted by Deputy Attorney General Creighton Waters. Cross-examination was conducted by Defendant Attorney Richard Harpootlian. I have also propounded questions myself to the clerk of court. I also received testimony from the clerk of court for Barnwell County, Rhonda McElveen, who attended most of the trial and assisted the clerk of court for Colleton County. I've also received testimony from the remaining alternate juror who was, when the matter was deliberated, dismissed from further service. The following is my ruling on the defendant's motion. The standard of proof. The state contends that in order to prevail, the defendant must show, 1, that the clerk of court made an improper comment or propounded an improper question to the member of the jury, to a member of the jury who rendered the verdict.
I say it was found yes.
2, defendant must further show that Ms. Hill's improper comment or question actually influenced the juror's verdict.
I don't think that's a standard.
Citing State v. Green, State v. Aldrett, and other opinions of our Supreme Court.
Okay, she's going to say no.
Other authorities. Defendant contends that he must show only that an improper question or comment was propounded to any juror by clerk of court Hill. If so proved, the defendant contends that the motion for the new trial must be granted. Defendant relies on United States v. Rimmer and many other cases. My ruling is this. On the law, the defendant has the burden of proving both the fact of the improper comment or question by the clerk of court, Rebecca Hill, to a juror or jurors, and 2, prejudice suffered by the defendant, specifically that the Hill improper comments to the juror or jurors influenced the juror to vote to convict Defendant Murdaugh. The facts. Did clerk of court Hill make comments to any juror which expressed her opinion of what the verdict would be. Ms. Hill denies A, and so the question becomes, was her denial credible? I find that the clerk of court is not completely credible as a witness.
Okay.
Ms. Hill
We're halfway
was
there.
attracted by the siren call of celebrity. She wanted to write a book about the trial and expressed that as early as November 2022, long before the trial began. She denies that this is so, but I find that she stated to the clerk of court, Rhonda McElveen, and others, her desire for a guilty verdict because it would sell books. She made comments about Murdaugh's demeanor as he testified, and she made some of those comments before he testified to at least one and maybe more jurors. Did Clerk of Court Hill's comments have any impact on the verdict of the jury? I find that the answer to this question is no.
No.
Each member of this jury took their involuntary assignment very seriously. They obeyed the instructions of the court. They obeyed their oath. These good and decent citizens of Colleton County stood to their duty and rendered their verdict without fear or favor. It was a difficult task. 11 of the jurors very unconditionally said they either heard no comment, or if they heard a comment, it had no effect. One juror was ambivalent in her testimony. She was then examined on her previous affidavit, in which she said the effect, if any, that she had was pressure she felt from other jurors. The cases are myriad that pressure from fellow jurors is a part of the normal give and take of jury deliberations. The court is not to inquire in any way about what is said in those deliberations. But the juror who was somewhat ambivalent said on her oath at the time of trial twice, and said on her oath before me in these proceedings that she stood to her oath. The clerk of court allowed public attention of the moment to overcome her duty.
She got it
I
wrong.
have read the entire transcript of this lengthy trial, not an easy task. I have studied in detail all of the authorities cited. I have independently researched the case law, learned treatises, and scholarly articles on the subject.
She's wrong.
Although there is certainly a split in the federal circuits and in the states on the standard of review, I simply do not believe that the authority of our South Carolina Supreme Court requires a new trial in a very lengthy trial such as this.
The length of the trial does not matter.
Fleeting and foolish comments by a publicity influenced clerk of court.
That's exactly why you need a
This is
retrial.
a matter within the discretion of the trial judge, and I am the trial judge at this moment. I do not feel that I abuse my discretion when I find the defendant's motion for a new trial on the factual record before me must be denied, and it is so ordered. I will file a fuller order which denies this motion on the grounds I have recited on the record before me as a trial judge and the authorities that have been cited by all parties in this matter. To that end, I will hold the record open. I direct that within 4 business days of receipt by the attorneys in this matter of a transcript of these proceedings, a proposed order by the state denying the defendant's motion for a new trial with citations be sent to me and to opposing counsel. I will allow the defendant 4 business days from receipt of the state's proposed order to lodge objections and or submit an alternative proposed order. Upon receipt by the court of all proposed orders, I will finalize this record, submit a written order, and I will at that time transmit the written order to the Court of Appeals the court which has remanded this matter to me. This hearing is adjourned.
Thank you, Your Honor.
Thank you. Let me say this, and I should have said it before I began my order. Hey, members of the audience, would you just be patient with me for one more minute? Please keep your seats. I have probably had more experience with trial and appellate work than anyone else in this room.
Does not matter. You can still be wrong.
And it has been an absolute pleasure to receive from these learned lawyers some of the best briefs I've ever received. I know they're a product not just of the attorneys who presented to me, but of the attorneys who sit with them and help compose the research and the writings that I received. I know that I put you on a very tight timeline, but my feeling is these matters are best disposed of by the trial judge in a very timely manner, so that you may then go to the authorities that really count more than I do. That is, the appellate authorities who will decide what the standard in this particular matter is. I've not seen a case such as this before. I doubt whether our appellate judges have seen a case such as this before. And they will take a lengthy time to study the record in this matter. The record.
She knows it's being appealed.
Remanded to me. There are many issues in this case, issues over which I have absolutely no authority whatsoever. But I will say this about the record now that I have read it. And I will say this about the testimony that I heard Friday and today. Judge Newman said it best in his sentencing.
No, he didn't.
When he discussed the weight and the measure of the case presented and testimony and evidence submitted in this case when it was tried. It is a very compelling case supporting the verdict that the jurors reached. He said it with a lot more detail than I do, but now that I've read the record, I say as the successor trial judge, I agree that the evidence was overwhelming and the jury verdict not surprising. This matter is now adjourned.
That had nothing to do with anything. See, my gut was right. She's wrong. Just simple wrong. She used the wrong standard. You don't have to show actual prejudice. You just have to show it was done. That there was inappropriate contact. That presumes prejudice. Potential prejudice isn't this. It's going to be appealed, and I hope it's overturned. That's it. Judge has spoken. Until the appellate court gives their ruling a billion years from now, that's it for this issue. There's still other issues that they're raising for appeals, but I think this was the strongest one for a retrial. I mean, there's several other issues they're raising for a retrial, but this was the strongest one. That ain't good. Well, it wasn't a waste of time, as some of you are saying. It just wasn't the outcome that I'd hoped for. That's all right. I've been giving my thoughts and opinions for the last 8 hours. There's no need to continue giving them. That's it. Dead flat. I think the judge was wrong. I think the wrong standard was applied. I think she misinterpreted it. And I think there is reversible error here. So, all right, folks. Let's give our big outro here. It's time for me to get some sleep. It's 7:18 a.m. The sun is coming up, and we'll get some sleep. All right, people, excuse me, sorry. Oh, one big yawn. Equality, thank you for staying up all night. You are all very welcome for me staying up all night. Ellie Fant said, you're too chipper for that early hisses. Oh, I'm not chipper anymore. Now the adrenaline's gone and the crash is gonna take place, and I will get, if I'm lucky, a little less than 90 minutes sleep. 10 Gauge Cheesehead with the $5 super chat. I knew it. Court fails again. I have learned from this channel, never put your faith in the court system. Yeah, I hope to God nobody ever finds themselves in the court system and has to deal with these things. Excuse me here again. Yeah, see, it was like the adrenaline just instantly shut off, and now I'm getting a little sleepy. Right, let's do this here. Hang tight for just 1 second. Let me see what's going on here. Just YouTube Studio content live. Murdaugh. Customization and redirect. I'm just wiped. It just feels like Lemon just literally just threw a switch and killed me here. Just a second. Huh. Okay. Well. I don't see Steve's setup, so it's that time to check out here, folks. People, mods, sincerely, thank you from the bottom of my heart for sticking through this, for sticking through here with me for 8 hours. Chat, thank you so much. Steve got his hand for 8 p.m. Eastern time. That's a long time from now. So, who do we got then? I don't know how much longer Danny's going to be going. We'll just send you off into the wild. It's what are we gonna call it? It's YouTube roulette. We'll just shut it down and let y'all decide where you want to go. All right, people. I think Danny's getting ready to wrap this up as well. So let me just double check to see if it sounds like she's going somewhere soon.
One, which means we met our factual burden. Two.
They're doing a press conference now, and I just shut it down. So, all right. Well, okay. People are saying send you over to Danny. I'll send you over to Danny. I have no idea how long she's going to continue going for. Probably not much longer herself. But hey, anyway, just going over there. We got 746 of you still here. We're going to send you over to Danny on direct, who's been covering the same thing. Tell her hi. She might be shutting it down in a couple of minutes herself, but we'll see. 82% of you thought yes, we'd get a new trial. 82% of us were wrong. Chat, thank you so much for your support. Thank you so much for your keeping me company and keeping me entertained through all of this. Mods, thank you for being here. Thank you for all the memberships, the super chats, the monthly member chats, everything. We'll see you tomorrow for the Aguilar Mendez bond motion and motion to dismiss. And let's go around over to Danny on direct. Tell her hi. Tell her Legal Vice sent you for the last little bit, and like her channel, subscribe to her channel, etc., etc. We'll see you tomorrow, people. Bye now.